Not maybe permit to mention that I'm mentioning some matter relating to the appellate side. But
When we take up appellate. Yes.
wait. Well, this was fixed today for the purpose of filing of the written notes, my lord. Lord, I'll file the written notes.
Lord, I appear for the respondents, my lord. My lord, I have the copy of the written notes, my lord. I see now that there's some discrepancy in the index, my lord. We'll just correct the index and file it.
Good. The written notes of arguments filed by the written notes of arguments filed by these are section 37.
Section 30.
The written notes of arguments filed by the appellants be kept on record. First up, learned counsel for the respondents seeks leave to file the written notes of arguments for the respondents during the course of the day. First up, such leave is granted. First up, hearing is concluded and the matter is reserved for judgment.
Grateful, my lord.
Delay.
Number 3. Lord, I am appearing for the respondent.
Yes, Mr. Mitra.
Lord, disputes between the parties, initially an arbitration not given effect to the award, parties said. Then, my lord, a mediation. Now, the mediation, my lord, there is an agreement that, my lord, the appellant says that it is an award. My client has said, no, it is not an award, it is merely an agreement. Now, on the treating it as an award, the appellant had put the award into execution. My lord, an honorable judge of this court, my lord, was pleased to hold that no, it is not award, and application for execution was dismissed. They have preferred appeal. Now, my lord, thereafter they have made, my lord, an application under section 9 for, my lord, enforcing, my lord, some of the clauses. Now, a single judge, an honorable judge, my lord, was pleased, my lord, not to pass any interim order in that. My lord, they came up before your lordships have given them some protection. Now, my lord, my short point is, my lord, my lord, cannot, my lord, they have to elect. They are approbating and reprobating. On the one hand, they are saying it is an award, executing it. After, my lord, putting it into execution, my lord, they cannot file any section 9.
Section 11 opposed to it.
And, my lord, they have, my lord,
arbitration
opposing this section 11 application, saying that no.
Mediation Act. So they have started arguments. They have argued on the last case.
Mr. Jishnu Shah, my lord, in fact, made some arguments, my lord, but
if they are not there, what can be done?
No, this much I can say, my lord. The whole difficulty is, my lord, I cannot proceed with my section 11. They are opposing that. In the Supreme Court, they are saying it is an award. My lord, they have to choose either way. Now,
Mr. Mitro, before the language of section 9 is, but before it is enforced.
yes, your lordship, my lord, was pleased to observe that. I shall, my lord, try to clarify, my lord, that it cannot be. Before it is enforced means it is put into it.
Moment it is put. Yes. So that
Otherwise,
will be one of the points.
I will try to, my lord, demonstrate that otherwise, my lord, it will have. I know that
only yes.
Absolutely.
Otherwise, yes, they have to elect you, right?
Your Lordship, I'm very sorry. I was on it.
Take leave.
I'm very sorry, Your Lordship. I was on my legs in some other court. My senior is currently not well. Please.
Has not come to court.
No, Your Lordship.
Has or has not come to court?
No, Your Lordship, not present.
Has he come to court?
Yeah.
If you don't have any information, say that
I do not have any information, Your Lordship.
We pass it over. How do you know he's not well? How do you know he's not well?
Your Lordship, I was on my legs to come to this court.
That's why he was not well.
He is in court, my lord. His clerk is there. Please.
Why make these submissions? He's not well and all this. Yes, ma'am. You're learning sharp practice from the beginning. It's called sharp practice. We just thought that you'll get away with this by saying that he's not well. Never try to pull one on the court. Never. The beginning of your career, ma'am. The beginning of your career. Don't put a black mark on your career. You are already wearing a black gown, but that's supposed to not to be tainted with further blacks.
My apologies, Your Lordship.
So why did you say he's not well? How long are you practicing, ma'am? Yes.
6 months.
And you have started this. You are very hurt because you are quite junior. So you say he's not well. And you thought you'll get away with that. We'll close arguments of the appellant for this only. And hear the other side and close the arguments. How dare you make this submission that he's not well? Unless we cross-examined you, you wouldn't have, you'd have got away with it. What's your name, please? So that we may remember. Yes, what's your name?
Indrani.
Don't have a surname?
Indrani Juatar, Your Lordship.
You don't repeat this again in any
I'm
court.
very sorry, Your
About
Lordship.
your
My
career.
lord, I beg to.
If you once do this, Ms. Jordar, we'll remember it and we'll ensure that you don't get away with it in future.
My lord,
Yes.
I apologize, my lord. The item number 3 has item number 3 been called, my lord.
Yes, three.
We are very sorry, my lord. Actually, Mr. Saha, Jishnu Saha is leading us, my lord, in this matter. He is
So
in
what
some
should you
difficult.
do? Tell us. You're telling he's appearing will not do. You have to make some prayer or start the arguments.
My lord, I am praying if my lord can keep it upon reopening, my lord. Because we are being led by Mr. Saha, my
You're
lord.
enjoying an interim order. We are in the midst of a hearing. It's the first matter of the day.
My
After
lord,
the to be mentioned.
I appreciate, my lord. My lord, if my lord
Continue with
considers
his arguments.
subject to
Mr.
the other side, my lord.
The
Otherwise,
subject to the other side is all right, but we are also here before that, before the other side.
yes, my lord,
The
absolutely.
part-heard
my lord.
matter, you are enjoying an interim order. Why should we grant you further adjournment?
My lord, I appreciate, my lord. Otherwise, my lord, if my lord, we can start, my lord, when
The interim order is continuing till disposal.
Till
Till
31st of
31st
January.
Let us put it after the vacation, Mr.
My lord, in that event, only one prayer.
Yes, you make your prayer.
My lord, it's possibly the next Wednesday or immediately after reopening is possibly 7th, my lord.
7th, yes.
My lord, let us understand, my lord, that it would be
Very well. An adjournment is sought on behalf of the appellants. First up, we notice that the matter is already heard in part, and the appellants are enjoying an interim order, adversely affecting the respondents. First of learned senior counsel appearing for the respondents submits that the interim order is operating against the respondents, and as such the matter should be positively taken up on the next date, even if adjourned. Which are next para as a last chance to the appellants to complete their submissions, the matter is adjourned till January 7, 2026. Footstep it is, however, made clear that in the event the appellants fail to resume their arguments on the next date, the arguments of the appellants will be closed, and the respondents would be invited to commence their arguments.
it will retain the position. my lord.
Yes, obviously it will.
Lordship. I'm okay.
my lord's our sincerest apologies, my lord, because of the
Accepted.
instruction, my lord.
Accepted.
Very sorry, my lord. We'll convey it, my lord, completely. My lord. Thank you, my lord. Most grateful.
Your Lordship, I apologize on my behalf as well.
Yes, please. Next matter.
Yes, my lord. Mr. Mitra was addressing your lordship on this Birla matter, my lord. In fact, he had recommenced the submissions because of the bench which has been constituted, my lord. If lordship will kindly keep it any day on the other side of the vacation.
Part-heard matter, then we'll cancel the part-heard. No, it's not a part-heard matter.
No, lordship.
It's not a part-heard, so no difficulty. In this bench, it's not a part-heard matter. Very well. On the prayer of the appellant, comma, the matter is adjourned till after the upcoming Christmas vacation and shall be listed next on January 7, 2026.
Great.
I am for the plaintiff respondent here in Malat. This matter, Malat, the appellant Malat, obtaining interim order Malat from two appeals Malat, one for Malat eviction degree and another Malat for mean profit Malat. Two appeals Malat. Malat, they have obtained interim order.
But they put to terms.
Yes, Malat, put to terms. But Malat, during this period, Malat, they handed over the property belongs to the port trust, Malat. I am the lessor, they are the sub-lessor. I am the lessee, Malat. The lessor must say lessee, she is the sub-lessee, Malat. They have,
They
Malat,
have directly handed over to the port.
they have
Port is the owner.
port is on. Without, Malat, through me, they have directly surrender. But that is another. Malat, regarding mean profit, they have not give the said money, my lord.
They were put to terms. They were directed to. It was conditional. Mean
Yes.
profit stay.
Yes. In degree, Malay, it was thereafter, Malay, special
There
reply
was a
was
stay order passed by this court.
this court, Malay, the appeal court.
On the mean profit decree also.
Also, Malay.
Was there any condition to such stay of the mean profit
Yes,
decree?
Malay. They are directed to deposit the deed, Malay, in their property, Malay, in personal property.
They are not asked to put in some money.
No. No, not only for directed to deposit the title deed in their
And eviction suit was stayed on what condition?
condition. They have their lease were expired. Lease.
You don't understand our question, Mr. Mondul. You are practicing sufficiently long. We are asking you generally if eviction decrees are. Don't you know if eviction decrees are stayed? Generally, we pass orders directing occupation charges to be paid and all these things.
Yes, my lord. So, my lord,
Since you are not, they are not in occupation, therefore no occupation charges were put in. What was the condition of grant of? When was the stay granted?
in 2015, my lord.
Date. We don't find any stay order on our records.
This is the order passed on, my lord, the 10th May 2016, my lord, by the Honorable Chief Justice.
16.
Yes, 16. 10th May 2016.
2016 এখন order তো এখানে নেই।
I handed over, my lord, one copy.
এটা consistently দেখছি অরিজিনাল সাইড এটা হচ্ছে জানো তো
The
অর্ডার
applicant,
গুলো আলাদা none appears for the appellants at the time of call. None appears for the appellants at the time of call. First up, learned counsel for the respondent submits that an order of stay was passed on May 10, 2016. First up, we are rather surprised to find that no such order finds place in the records of the case before us. First up, the office is directed to be cautious henceforth in ensuring that all orders pertaining to a matter
Lordship.
are put in the file when the matter is placed before a bench. First up, next para. No condition was passed.
next page, the security, the title deed is.
Anyway, in any event, comma, since none appears for the appellants to move the appeal, comma, we cannot take up the matter. First up, as a last chance to the appellants to argue the matter, comma, the same is adjourned till January 7, 2026. First up, it is made clear that in the event the appellants choose not to appear or seek an adjournment on the returnable date, comma, as and when the matter is next taken up, comma, ex parte orders stroke judgment may be passed in the absence of the appellants. Next. Yes. None appears for the appellants at the time of call. A last chance is given to the appellants to commence arguments on the next occasion when the matter is called on for hearing. Full stop. In default, comma, ex parte orders may be passed in the absence of the appellant.
Number 9.
Yes.
Respondent, my lord, family dispute, it was possibly heard by your lordship also. Family dispute, my lord, allegation was, my lord, that companies under control of, my lord, one group of the family, my lord, those were, my lord, transferring properties, all those, my lord. So this suit was filed. Thereafter, my lord, application was made for, my lord, addition of parties and injunction against some of them. Now, a part of the same order, my lord, your lordship was pleased to, my lord, an appeal from a part of the same order, my lord, your lordship lordships were pleased to, my lord, send it back because the interim order is continuing. This is another appeal.
This is that was regarding which part? Addition.
This was I have been added.
Yes, we did not get an order of injunction. We came up in appeal.
That portion was sent back.
Yes,
Injunction
with the
granted.
injunction. With the injunction. The appeal.
Granted injunction and sent back. Now they are challenging the refusal of addition of party.
No, different number 79's subsidiary was added by the application GA 156 of 2017. I am for the subsidiaries. It is my appeal. Subsidiaries are challenging an order of addition in the partition suit.
Addition of yourselves.
Yes, I have been added different number.
You are challenging your addition to the
Yes,
suit.
yes.
Move your appeal.
But can it be Mr. Chaudhary is not there?
Not there.
Yes, he's not there in Calcutta, my lord.
You're sure he's not
Yes, yes, I'm sure.
unwell or something?
No, I'm sure that he is not there.
So keep it after the with what can be done. You should have also left Calcutta.
Can't afford to.
Convince someone else. On the prayer of the appellant, let the appellants, let the matter stand over till after the upcoming Christmas vacation.
Great.
নামগুলো একটু রেকর্ড করে নেবেন বোথ সাইডের নামগুলো দিয়ে দেবেন রেকর্ড করে
Your Lordship, item number 10, I'm appearing on behalf of the appellant. Your Lordship, for the last election or passed by Your Lordship, you have already served the copy of the paper book. In the meantime, Your Lordship, as instructed by my client, the talks of settlement, because it's a dispute between the brothers. So talks of settlement may arrive, Your Lordship. That's what's instructed by my client.
Talks of settlement is a new ground of adjournment.
No, not new one, but there's a submission before Your Lordship. That's not adjournment because I have already served the paper. This affidavit.
None appears for the respondents at the time of call. Full learned counsel for the appellant submits that as per direction of the court, copies of paper books and other papers have been served on the respondents. Full next para. It is further submitted by learned counsel for the appellants that talks of settlement between the parties are going on. Full stop. Next para. Accordingly, in order to explore possibilities of mutual settlement between the parties, let the matter stand adjourned till January 7, 2026. Full stop. However, it is made clear that in the event the parties fail to arrive at any settlement conclusively prior to the next date when the matter is taken up for hearing, the matter will be taken up for hearing on merits.
Your Lordship, only 7 may it be if it.
As a farewell.
Lordship.
14th January.
No, Lordship. I'm
ওটা 7th না করে January 14th বাকিটা
Affidavit of service.
Affidavit of service filed today be kept on record.
Your Lordship, I'm grateful.
It is just 7th or 14th.
Your Lordship, I'm grateful.
I appear for the appellant, your Lordship. I'm
For the
praying for an
respondent number
adjournment
124.
today. If the
Yes. What is the matter about?
Your Lordship, by the impugned order, 4 applications were disposed of, and one of those applications was my application under Chapter 13A, Your Lordship. Your Lordship, I'm being led by Mr. Shoroshi Dashgupta. I'm only praying if the matter can be taken up after the vacation.
My lord, on the last occasion, one of their contention was that the matter is a commercial matter, my lord. Now, this suit that has been filed before the Commercial Courts Act came into effect, your lordship. So what they had sought is they have to seek transfer. But in case they have to seek transfer, they have to seek transfer of the suit, and then the maintainability of appeal comes into question, my lord. That
Because of the commercial matter that
yes,
dispute whether it's
yes.
wrong.
Because
They have taken a point. You have filed a regular suit.
they have filed a regular suit.
This was a non-commercial suit.
Lent in
when
advance,
filed.
on account of money lent and advanced,
The
my lord.
appellants filed the suit.
Yes.
Yes, Your Lordship.
On
I'm the
account of
plaintiff.
recovery of money on account of money lent and advanced, your
That
lordship.
was a non-commercial suit. Now you want
Filed
to
in
get it transferred.
2015, Your Lordship.
Get it transferred to a
Your Lordship,
Commercial division.
commercial division.
It's a non-commercial. They're seeking
So
transfer.
you take a
commercial.
stand that it's a non-commercial dispute.
Your lordship, I'm not disputing whether it's a commercial or non-commercial. I'm saying that in case they have to seek transfer of commercial, my lord, the maintainability of appeal comes into question because first the suit has to be transferred, my lord.
What
Then
are they seeking? Transfer of what?
transfer of this appeal, your lordship, in commercial division. That might
Oh.
perhaps without the suit being transferred to the commercial division would not be permissible.
Yes, if the suit still stands in the non-commercial
Non-com-
division, how can this appeal be maintainable?
Your Lordship, as I can see from on the last occasion, Your Lordship, on 24th of July, submission was made on behalf of the appellant that this is a commercial that this pertains to a commercial cause, and the court had said that that issue will be considered on the next day. So, if on the 7th of on the next day, if Your Lordship, we can make submissions on that.
In case we can proceed with
No,
the
as of today, this appeal,
Is in the non-commercial
transfer
division.
application,
No transfer application has been made. Your
the
Lordship.
appeal.
Oral submission had been made on the last occasion.
But that depends on you have taken out an application for transfer of the suit to a commercial court. Have you taken out such an application?
No, Your Lordship.
No. What is the impugned order? Let us see the impugned.
Your Lordship, the impugned order is at page 1076 of the
Volume
paper
8.
book, volume 8.
Volume 8, your lordship.
Yeah, we'll just following the memo.
chapter 13.
Yes, Your Lordship. Order 13. Volume 8. বলেছি সেটা বলেছি 4 applications were disposed of. One of them was my application under chapter 13. Commercial কোথায় আছে?
এটা কি হচ্ছে সাবসিকুয়েন্টলি আমরা
So are you ready to argue the matter? You were there.
today we are not ready, my lord. We'll do it.
We'll keep it after the vacation leave. Whatever points are there. On the prayer of the appellant, the matter appellants, the matter is adjourned till after the upcoming Christmas vacation.
Lordship, may I only seek that in case, can it be on 14 January instead of 7th?
And be যা বললাম তারপর and be listed next on January 14, 2026.
Grateful.
I'm grateful.
Grateful, your lordship.
Both of you, please give the appearances. Yes, 12.
I'm for the respondent, man.
Respondent. Although the respondent is represented before us, none appears for the appellants, nor is any adjournment sought. Push up next para as a last chance to the appellants to argue the matter on the Next occasion when it is called on for hearing, comma, let the same stand adjourned till January 7, 2026.
Lordship.
Next.
Appellant नहीं बोला
Order. None appears for the parties at the time of call. Full stop. Let the matter stand adjourned till January 7, 2026.
That I appear for the appellant, my lord.
In the previous matter also you were appearing.
No, this is the
ভুল ফাইল দিলে নাকি সৌনকের নামটা দেখলাম আগেরটা সৌনক ভট্টাচার্যের নাম দেখলাম ফাইলটা কি ভুল দিয়েছিলে
I am the appellant in Devang Kankaria versus Salarpuria
ফাইল
investment.
দিয়েছিলে কি করছো
APOT 57.
এই ফাইলটা তো আগেরটা দিলে তুমি আগের ফাইলটা কোথায় প্লিজ ওয়েট আ মিনিট
Yes.
আগের ফাইলটা দাও ঠিক ফাইল দাও
My lord, I'm appearing for respondent number 1 hearing.
ঠিক ফাইলটা আগের ফাইলটা দেখি একবার। Please, ঠিক ফাইলটা তো দিতে হবে জজকে আগের ফাইলটা দেখি কি হয়ে বসে আছে দিয়ে মালুম এই ফাইলটা দিয়ে দিলে নাম্বার চেক না করে রেঞ্জ এরকম ভুল কি করে হচ্ছে আগেরটা কি অর্ডার দিলাম হ্যাঁ এটা এই ফাইলটা এই ফাইলটা দাও এটা কি এটা আগেরটা এই ফাইলটা দাও 14 এবার হয়ে গেছে আগেরটা ঠিক আছে আগেরটা আছে 14 ফাইলটা দাও Yes, you are for the other side. Respond.
Yes, yes.
What is the
My
matter?
lord, I appear for the plaintiff, respondent number 1.
Right.
I in my application had got an order from which this is a leave to appeal by a non-party to the suit.
Good. What's
The
the
claim is the, my lord,
Yes, Mr. Gupta.
yes, my lord, the claim in the suit is on account of money lent and advanced to the defendant.
Let
Well, the
Mr. Bhattacharya open. He's for the.
My lord, kindly see, my lord, the order, my lord, the order impugned, my lord, 12th March 2021. My lord, most of my submissions have been, my lord, completed by Mr. Gupta. My lord, up to that, my lord, factually he is correct. My lord, this is the order impugned.
Who are you?
Yes, I'm the defendant. If your lordship would kind enough to come.
You are not a party.
No,
to the suit
I'm
when the
not the party to the suit. If your lordship would kindly come to the my lord plaint, which starts, my lord, at page 68A. At page, there are three page numbers, my lord, it should be 79. 79.
Yes, 79.
My lord, what happened, my lord? The Salarpuria investment, my lord, they had filed a money suit against Shudha Kankaria. Now, my lord, the Shudha Kankaria is the mother of the appellant. Now, my lord, what happened? There is a, my lord, will of the father, father of the appellant, my lord, and the husband of the defendant. The will says there is a flat which, my lord, ultimately, my lord, after probate, will go to my client, and the mother will have a, my lord,
Interest.
life interest. My lord, that is the issue. Now, my lord, after, my lord, filing of the suit, my lord, this order has been passed, my lord, on the application, my lord, filed by the plaintiff, my lord, on 12th March 2021.
What is the order? Let us see.
12th March 2021. এর কথাটা কত রে?
What connection do you have with the money suit?
Milord, money suit, Milord, that flat, Milord, ultimately, Milord,
So,
it is,
Sudha Kankaria, what is their case? It was a loan.
yes,
In advance.
yes. If your lordship would
So even if they get a decree there, how are you affected?
Milord, affected, Milord, kindly comes to Milord annexure C, Milord, page 92. Page the will.
Yes, 92.
The will, kindly see, Milord, first, second, the third paragraph.
91 is the
Milord,
first page.
there are three, Milord.
Anyway,
paginations. I hereby give, devise, and bequeath all that my flat number 3A at premises number 14 Ashoka Road, Kolkata 27, to my wife Srimati Sudha Kankaria to use, possess, and occupy for her residence for her life, and after the demise the said flat shall go to Devang Kankaria, my son, absolutely for forever, and Devang Kankaria will be the absolute owner thereof, and Devang Kankaria is the appellant before your lordship.
yes, but this is a loan taken by her. When they suppose they get a decree and try to execute it, you can set up this point in the execution case under Order 2097 principle.
Milord, that is there.
Because what is your anticipation? How are you a necessary party in a suit? Your mother took a loan; they have taken out a suit against her. So,
No,
if
Milord,
in
if
execution
if your
they
lordship,
include these properties, then you have a right.
if your lordship would kind enough to
It's
consider,
absolutely inter parties.
Section 14, subsection 2 of the Hindu Succession Act. Milord, 1 says life interest, Milord, upon the mother, Milord, she will become the absolute owner. 14 says if there is a, Milord, bequeath, gift, Milord, 14.2 will override 14.1.
So she'll get an absolute title.
And if your lordship would kind enough to come to the order dated 21st April 2021, passed in this appeal. But 21st April 2021 passed in this appeal. What was the observation made by the lordship's, Milord, coordinate bench? Order admitting the appeal 21st April 2021.
You were not restrained from disposing.
Parties, Milord, consider
the impugned order, the order of the division bench, coordinate bench records the impugned order
direct
the applicant
yes,
from disposing or
yes,
disposing.
and
You have never been restrained.
yes, and Milord, kindly see 12th April order, 12th April, the third paragraph, 12th April.
Attachment, where is the attachment?
Yes, that is the order impugned, Milord, 12th March 2021.
Miss that. Not attachment, injunction.
Yes, yes. Well, Milord, what I would be praying, Milord, the order, Milord.
So obviously the court is proceeding on the premise that that property belongs to her.
I may be added as a necessary party, and secondly, Milord, this position, Milord, as of 21 April 2025, we maintain till disposal of the suit.
Position as well?
Which was, Milord, held by the Honorable Division Bench in the order dated 21st April 2021, Milord. Case of the applicant is desirous of
no position was set out.
But
the order remains.
Order remains.
Will remain. So why didn't you go and take out an application for addition of party in the suit instead of preferring this appeal?
That I will, because but attachment, Milord, they should not, Milord, take further steps.
This is not attachment. This is injunction against the respondent, against the defendant, by which you are not bound in any event. But yes, you may have an apprehension that the commercial court is proceeding on the premise that this property belongs to her. So there you may have something to say.
Perhaps,
But
my lord, the
suit
will
whether-
was not my lord, produced before the my lord first court.
No, but Mr. Bhattacharya, in the suit, how are you a necessary party? We don't understand till now.
My lord,
And even if there is a restraint order on your mother, there is no restraint order on you.
on me, but on the by the will, my lord, I
You
have
are not a necessary party to a recovery of money suit unless execution is levied and that property is. We'll make that clear in your order subject to hearing, Mr. Gupta, that you will be able to resist. But there are certain situations where you are not a party, necessary party in the suit, but you may become a necessary party in the.
in such situation I may be permitted to
Otherwise, you are neither a necessary nor a proper party. Just
because
because
loan
of the
was not
perception of the
taken by
either the perception of the court or any of the parties. You don't become by perception. You don't become a necessary. You take money from me, I file a suit against you. So if I put it in execution and then have that, but this attachment order gives a presumption undoubtedly that yes. Yes, Mr. Gupta, what do you say? Why shouldn't we clarify that
Yes.
in our order? That in a money suit, we don't find him a necessary party, and therefore and we'll also observe that he is not bound by this order of the trial court because he's not a party.
Malad,
It's your
Malad,
choice,
kindly.
him or not to implement him. You're frozen like a bank account. They've been taking too many freezing matters. So you are still frozen, Mr. Yes, now,
Malad,
yes.
is the network
Now it's all right, but sporadically. Again, same problem. We are disposing the appeal, Mr. Yes, we can see you move now. Now you can speak. Yes.
Yes, Malad, I'm really sorry. There's some issues with the network right
He
now.
is
Where I
not
am about to
apparently a
submit.
necessary party in the suit because it's a money suit
Yes.
against his mother.
Malad, I would humbly beseech, Malad, that your lordship would kindly not entertain this application for leave to appeal at all. And I'll tell you, lordship, why. But as on date, my learned friend's client is not a party, not a person aggrieved.
Why not?
Yes, because Malad, the will does not give him the right to the property as of now. The mother has the right of residence for her life.
No.
So, Malad, the
Right of residence.
injunction order.
No, it's a question of question to be. If you say that, then he becomes a necessary party because will gives him certain rights. It's arguable whether section 14(2) applies, 2 or 1.
But I was only limiting my argument to at present that what is the order which
Order
is being
restrains the
it's
mother
an order injunction
on the mother not to transfer the property. It's very difficult, Mr. Gupta,
this stage.
Video is being frozen. At this stage, his mother has been restrained, right? He is not a party. If he is not a party and his mother has been restrained, either you say that he is not bound by the order, and if he is bound, definitely we will grant him leave to prefer an appeal and he is affected party. Either he is affected or not. If he is bound, he is affected. If he is not bound, he is not affected. And we find that a non-party cannot be bound. A non-party cannot be bound. If you see the moment you say he is bound, then he is affected.
I am not saying whether he's bound or not bound. My submission is only
we are saying that he is not bound. If you take a stand, but you have to elect a stand, Mr. Gupta. Either you say he is bound or not. Because that will be your entire argument on the leave application.
But we have not said whether it's bound or not. The only injunction is restraining the defendant, his mother, from selling of the property till the disposal of the suit. The mother has the
mother only has a life interest, Mr. Gupta. Mother only has a life interest.
The mother has the life interest. Yes. So, the mother should not dispose of the property in the meantime.
No.
That is all.
Sorry, Mr. Gupta. This then is an attachment before judgment order, because the suit is for money. It's a money claim. You have not claimed any corporeal declaration regarding the property. How can you have an injunction on the property? You have a relief by way of money. That injunction would tantamount to attachment before judgment. And if there's an attachment before judgment in a property which he claims right to, definitely is a necessary party. Without him, the suit is bad for non-joinder. It's attachment before judgment. In a money suit, you cannot get an injunction on the property. There's not a single prayer made regarding the corporeal rights in the immovable property.
It is an attachment before judgment.
If that
But-
is so, definitely this person is also affected, because I mean, or
what
categorically that he is not bound, he is free to dispose of the
No,
property.
Manoj, could I suggest two simple things, Manoj, subject to what falls from your lordship?
Yes.
Manoj, this is a ploy between these two persons to denude my rights.
It
Manoj, what
maybe a ploy between his mother and you also, Mr. Gupta. We don't know. He's not a party.
No,
And you get
Manoj, what I
who has only a life interest.
Manoj, I have twofold submissions. Manoj, on the strength of the will, the mother is the residuary legatee. He has got every other property from the father, from a deceased husband. So let them produce the other respondent, the
Mother is
mother.
not the residuary legatee. Mother is a lifetime interest holder.
No, only in respect of the flat. No, in respect of this flat. But for all other properties, the mother is the residuary legatee. Kindly see the language of the will. But everything else, the mother has got. But we'll kindly have a look at page 91, the third paragraph, fourth paragraph. I hereby give, I'm sorry, has your lordship got it? Page 91.
Yes.
I hereby give, devise and bequeath my all other properties, movable and or immovable, belonging to me, or which may belong to me and remain undisposed of during my life to Srimati Sudha Kankaria, my wife, absolutely and forever.
All other properties.
All other properties. So
And
let them in all fairness, the mother, the party to the suit, produce the affidavit of assets in this probate application. That is my first prayer.
The injunction granted is only on the flat.
Injunction
not on
granted
the
is
other.
only on the flat. And
Mr. Gupta, if you get a decree, you realize it from the other properties of the.
I will, but the injunction, as on date, since the mother is alive.
Leave and set aside this injunction. How can you get an injunction on a property on which you have a life interest on?
Could I try and impress upon your lordship? I understand the ownership best with Mr. Bhattacharya's client. I am not joining issues with that. Kindly do not take my submissions that I am going into that issue. What I want today is that the mother has got the life interest. So when this happens between the mother and the son, so this order would get vacated. The mother then would dispose of in the manner she would want. That is the restraint. Till she is alive, let she not transfer the property to somebody else. Till she is alive, I have the right to get the mother's right in the property. Mother's right is till she is alive, she should not deal. This would be possibly inequitable, in my humble understanding, subject to my lord testing it, of course, would possibly be inequitable that she goes along, creates a third party interest, earns profits from the property by leasing it out.
We have to see the order passed, Mr. Gupta, only through the focal lens of your suit. We cannot go beyond that. We have to go by the prayers in your suit. You have made a money claim simpliciter against the mother.
And I've got an attachment before judgment.
How can you get that?
I can.
In a property which is not even hers.
This property is hers. This is what I'm joining.
You could have got an injunction. We could have understood that she cannot part with her life.
I am saying,
Mr. Gupta, you could have got an injunction.
Kindly clarifies that she cannot part during her lifetime. Kindly clarifies that portion. Otherwise, she will have the cake and eat it too.
You could get an injunction that she cannot part her life interest in the property, which is the only thing she has got.
Yes.
Then
I am also protected. What if your lordship sets aside this order? What this will give them the liberty.
That is what we are saying, Mr. Gupta. At the outset, we said we'll make it clear. We only said that we'll make it clear that in the suit as framed, he is not a necessary party otherwise, but this order would affect him if it binds him. We'll just say that this order does not bind the present applicant. It does not. He's not a party. How can he be bound in any way? Binds the mother only.
Binds the mother only. So the mother during her lifetime should not.
No, we won't allow the application for leave also then. But we'll observe that we don't allow the application because in the suit as framed, he is not a necessary party.
He is not a necessary party.
This order has been passed only against the mother and will operate only against the defendant mother and will not bind him.
Absolutely.
That is what we started with.
But there are some network issues, Manoj. I missed the second part. I'm really sorry, Manoj. I missed the second part. That it would bind.
But we'll make it clear, Mr. Gupta, that in the event you get a decree and you seek to execute by touching any interest in the property or touching that immovable property with regard to the immovable property, then he might have a right if otherwise he has it in law to resist that.
But would it, I know we have done the hearing almost completely. Would it be Lordship's pleasure to pass this order that side of the vacations? Because
No, no.
I'll just
You'll get
speak
the
to my,
certified copy that side of the vacation.
no, but we'll
You
just,
get
I'll
the
just
server copy today, the certified copy that side of the.
Only one thing, my lord. Kindly see, my lord, the order
I-
dated 26.
No, we will couch the order in such a way, Mr. Gupta, so that he does not get a right by your order. We'll say that
yes,
the as per the arguments made by the applicant, his remedy lies in resisting an execution if levied in respect of this property.
if
Not
otherwise he's entitled to in law.
otherwise he has that right in law. Yes.
Kindly see, my lord, the order dated 26th March 2021 passed by the Lordship's coordinate bench. 26th March.
That merges in our order. Whatever.
No, no, kindly one.
Whatever order was passed, it merges in our order.
Leave has
We are hearing the leave application.
Yes, leave has that
If you
has
don't grant
already
it,
allowed.
the appeal goes.
No, that has already been allowed. Leave
Leave has
application.
been allowed.
Yes, yes. No, that is what I'm sure. 26th March 2021.
So the moment we are saying something on an order, you are going back by one order.
This I was not aware of it. So
You're granting leave. No need.
Leave to prefer the appeal.
Leave application allowing means, I mean,
This appeal.
then we'll dispose of the appeal. We'll dispose of the appeal. You have been granted leave. Be happy with that. You have argued the appeal. We are disposed. The present appeal has been preferred by a third party to the suit in which the impugned order was passed. Who's the next para? The suit from which the present appeal arises is a money suit instituted by the respondent herein.
Respondent number one.
Right. Again, the respondent number 2 must be.
Yes, yes.
By the respondent number 1 herein, stroke plaintiff, against the defendant stroke respondent number 2, comma, the latter being the mother of the present appellant. Push up. In the said suit, comma, filed before the commercial court, comma, leave was granted under section 12 capital A of the Commercial Courts Act 2015, and an interim order was passed injuncting the defendant stroke respondent number 2 from creating third party right in respect of a flat situated at 3 capital A, comma, 14, comma, Ashoka Road, comma, Kolkata 7,27,000. For sub next para, learned counsel for the appellant argues that the appellant has already been granted leave to prefer the appeal, comma, despite not being a party to the suit. First up, it is submitted that the interests of the appellant in the property situated at 3 capital A, comma, 14, comma, Ashoka Road, comma, Kolkata 7,27,000, comma, in view of the plaintiff having been bequeathed such property by virtue of a will of the plaintiff's father. For sub next para, by placing reliance on the said will, comma, annexed to the stay application filed in connection with the appeal, or this is the leave application. What is this application?
Leave.
Stay application. Comma, that in the third paragraph thereof, comma, the said property, immovable property was devised and bequeathed to the said property. Life interest in the said property was devised and bequeathed to the defendant stroke respondent number 2. However, comma, upon her demise, comma, the present appellant, comma, the son of the testator and the respondent number 2, comma, is to become the absolute owner thereof. For sub next para, as such, comma, it is submitted that by grant of the injunction, comma, the rights of the appellant in the said property have also been affected adversely. For sub next para, learned counsel appearing for the respondent submits that irrespective of the fact whether life interest or absolute interest in the immovable property in question was granted to the appellant or the respondent number 2, comma, fact remains that that the conspectus of the suit pertains to a money claim, comma, the necessary corollary of which would be that the defendant therein ought to be restrained from parting with the immovable asset, comma, in which she has a right, comma, even if a semblance of a right, comma, to ensure that the decree which may ultimately be passed in the money suit may not be frustrated. Full next para, as such, comma, it is contended that the impugned order suffers from no illegality whatsoever. Full next para, upon a careful scrutiny of the impugned order, comma, we find that the same, comma, although couched as an injunction, comma, is in the nature of an order of attachment before judgment under Order 38, Rule 5 of the Code of Civil Procedure. Order 38, Rule 5 of the Code of Civil Procedure. Full next para, be that as it may, comma, since the present appellant is neither a party, comma, nor was any order of restraint passed on the present appellant, comma, the order impugned in the appeal does not bind the appellant in any manner. Next para, moreover, comma, in view of the frame of the suit in its present form, comma, which is a money suit simpliciter against the defendant stroke respondent number 2, comma, the appellant, comma, being a third party to the alleged loan transaction, comma, is neither a necessary nor a proper party to the suit itself. Next para, thus, comma, since the appellant is neither bound by the impugned order nor is a necessary or proper party in the suit, comma, we do not find any locus standi of the appellant as such to challenge the impugned order. Next para, to allay, ALLAY, to allay the apprehension of the appellant, comma, the remedy before the appellant would at best be, comma, in the event a decree is finally passed against the defendant stroke respondent number 2 in the money suit, and in execution, comma, adverse orders in respect of the immovable property in question is sought to be passed by the executing court, comma, to resist such decree on the strength of the alleged right of the appellant by way of an application under Order 21, Rules 97 to 101 of the Code of Civil Procedure. Next para, however, comma, at this stage, comma, it would be premature to entertain the appeal and interfere with the impugned order at the instance of the third party stroke appellant. Next para, in the light of the observations, comma, we do not find any scope of interference with the impugned order. Accordingly, APOT 57 of 2021 is disposed of without interfering with the impugned order in the light of the above observations. GA 1 of 2021 is accordingly disposed of as well. There will be no arrest for cost. Urgency report.
Lordship has recorded my submissions
What is,
as the
what is
respondent
for?
number 1, Lordship. Lordship has recorded my submissions as respondents in the order.
You are
Yes.
I mean, let me, Mr.
3 paragraphs before, your lordship had only recorded respondent submit should be respondent number 1. That's it.
Respondent number 1. Thank you. Thank you.
Obliged, Lordship.
I'm so grateful to your lordship.
Prepare your application under Order 21.
Yes, that is.
They'll get the degree soon. Commercial suit.
Yes.
Yes. Right. Yes.
But I appeal for the respondent. my lord.
Respondent.
And
Won't
appellant
do.
is not appearing also, my lord. The last occasion also before the earlier court also.
No, this is appeared for the first time
First time
before us.
before your lordship.
So then we cannot. Although the respondent is respondents are
But it's
represented.
1 and 2 only, my lord.
Acha, although the respondent numbers 1 and 2 are represented through counsel, comma. Sorry, although the respondent numbers 1 and 2 are represented through counsel, comma, none appears to argue the appeal. Next para. Accordingly, comma, let the matter stand adjourned till after the upcoming Christmas vacation and be listed next on January 7, 2026.
Yes.
We are not giving a last chance
No, the last day.
at the first instance. At the second instance, it will be a last chance. Thereafter, yes. Next.
Milord, Mr. Shumon Datto is appearing for the appellant in Mudda matters, Milord.
He's not in town.
No, Milord. He has not come to court, Milord. Milord, may it be on 7th, Milord.
Plaintiff in the suit, I cannot, whatever, the first time. So 7th.
There
The
should
pair
be
of the one appellant or several appellants.
1 and 2, Milord. I am for the
On the
appellant.
prayer of the appellants, let the matter stand adjourned till after the upcoming Christmas vacation and be listed next on January 7, 2025.
I'm grateful to your Lord.
We ask you, Junior, to give you all your
Yes,
names.
sir.
You also,
Great.
apart from Mr. Shumon Datta.
Yes, yes. Only my name, Milord.
Yes.
লিখে দে।
No, your Junior's name also. Next.
আমারটা লিখে দিই, তারপর তোরটা লিখে দিবি।
18.
কি হয়েছে?
None appears for the parties at the time of call. Full stop. Let the matter stand adjourned till January.
Lord, item 18, my lord, I appear for the respondent. We've also, my lord, not been served with a copy of, my lord, the appeal papers, if, my lord, it may be served on us.
ওটা তাহলে কেটে দিন। Learned counsel, none appears for the appellant at the time of call. Full stop. Learned counsel for the respondent submits that the papers relating to the appeal have not been served on the respondents. Full stop. Accordingly, the appellant is directed to serve copies of the memorandum of appeal and other documents filed in connection with the appeal on the learned advocate on record for the respondents at the earliest. Full stop. To ensure compliance of the above direction, comma, the learned advocate on record for the respondents is requested to serve a server copy of this order on the learned advocate on record for the appellant. First of next para, the matter shall next be listed under the same heading on January 7, 2026.
Grateful, my lord. Grateful.
Just give a server copy to them so that they.
My lord, we will.
Next.
Item number 19, I'm from the appellant lordship. I'm on behalf of Mr. Shivaji Kumar Das lordship. Just I'm paying for not Pune lordship.
On the prayer of the appellant, the matter is adjourned till January 7, 2026.
My lord, I appear for the appellant, my lord. I have a leader in this matter, my lord. It may be kept on 7th of January, my lord.
My lord, I appear for the respondent.
Before that, my lord, there was a direction to file supplementary paper book, my lord. I am filing the supplementary paper book, my lord. Already served to the other side, my lord.
Keep it with you. We won't burden our records if you are asking for time. On the prayer of the appellant, comma, let the matter stand adjourned till January 7, 2026.
But I think, my lord, there was a direction of the previous coordinate bench that the supplementary affidavit may be.
First up, learned counsel for the appellant submits that the supplementary affidavits have been prepared in terms of the direction of the coordinate bench. First up, learned counsel for the appellant, comma, is however, comma, requested to file such paper books on the next occasion when the matter is actually taken up for hearing.
Deeply obliged.
Please give your names also. Next.
Lordship, I appear for the respondent.
I'm appearing on behalf of the appellant lordship.
Lordship, this is that matter where
Lordship,
we are now on the payroll of Birla Ludha and Fox and Mondal. Either the assignment is pertinent to Fox and Mondal dispute or to Birla Ludha, mostly. So yes, half our salary is spent on them. What is the matter about?
Yes, Lordship, I have made this appeal after suffering the interim order. Interim order is at page number, memo of appeal.
Interim order in the nature of an injunction?
Yes.
You are the defendants in the suit.
Yes, I was the defendant in the suit.
Now the suit, in the suit, I am without written statement. They have filed an application.
It's a commercial suit.
Commercial suit.
Then you don't have any defense now. Time is over.
Yes, time is already over. They have filed an
They're
application.
entitled to a decree by
Your Lordship,
default.
summary judgment application has been made. CAB
Final,
rejected tonight.
not
File
CAB,
note.
at final stage.
What remains in your appeal?
Lordship,
They are not appearing also before the trial court.
They're not appearing?
No, that's not the case, Lordship.
One day they appear. The order records, I can produce those orders.
Not this is not the
case then.
This is not the absolutely not the case. We are appearing on behalf of the appellant and
in the appeal court they are appearing,
there
but
you
in
are
the trial court.
in the trial court we are also appearing. Mr. Thakkar was appearing on behalf of the respondent number 1 and 2 and made arguments there. However, some Mr. Thakkar has returned the brief. So
No, this was a contested order.
Yes, you know.
Yes, contested order.
But now, since you don't have a defense in the suit, why should you interfere? Will they dispose of the
in that case, kindly
necessary orders to be passed in the suit?
Kindly keep it
Commercial
after the vacation. Kindly keep it after the vacation. And then one observation to be made, Lordship, that the trial
Not be prejudiced by any of the observations on merits.
made in this order.
On merits, definitely. That is that is the law. The present appeal has been filed against an interlocutory order passed in a commercial suit at the instance of the defendants in the suit. For next para, upon query of court, learned counsel for the appellants, in his usual fairness, submits that the written statement could not be filed within the statutory limitation period by the defendants appellants in the suit. For next para, learned counsel for the respondent submits that the appellants are also avoiding appearance in the suit, which is denied by learned counsel for the appellants. For next para, be that as it may, within the restricted framework of a commercial suit, in the event the written statement is not filed within the outer stipulated limit in terms of the provisions of the Commercial Courts Act, in terms of the provisions of the Code of Civil Procedure, as amended by the Commercial Courts Act 2015, the defendants do not have a further defense in the suit. As such, there is as such, since in the main suit, the defendants appellants have lost their right of defense, little purpose would be served in adjudicating in entertaining the appeal, in view of the defense to the injunction application taken by the defendants appellants being in tune with that taken in the written statement which was never filed. Next para, in such view of the matter, APOT 427 of 2023 is disposed of without interfering with the impugned order, however, with the observation that the observations made in the order impugned in the appeal shall be treated to be tentative insofar as the final disposal of the suit is concerned and will not adversely prejudice the rights and contentions of either of the parties on merits at the final hearing of the suit, which shall be taken up by the appropriate commercial court without being unduly influenced by such observations. For some next para, consequentially, GA Com 1 of 2023 is also disposed of. No order to cause urgency. Thank you.
Well, it's only one thing, this last portion, now, because there is no written statement, there is a order 13A application filed.
We have filed our defense to the order 13A application.
Since an application under order 13 capital A of the Commercial Courts Act 2015 has already been filed by the plaintiff's respondents, the commercial court taking up the same shall decide it in accordance with law.
Grateful.
Yes, I'm for the appellant, Milord. Right. Subject matter of the challenge, Milord, in the appeal is an order whereby my order 9 rule 13 application was dismissed, Milord. on the ground that I participated in an interlocutory proceeding, though I disputed that, I said the affidavit which was
Is there an intra-court appeal?
yes. No,
Acha, you participated somewhere else.
I did not file that affidavit. That's my stand.
Your Lordship.
That's my stand.
Who filed it?
Not even, I do not know, my lord. No Vakalatnama filed, nothing.
Not in your name also?
No. But the
Lordship.
court's finding is, since there is an affidavit and you have appeared in the interlocutory proceeding.
You say you never appeared.
That's my stand. That's my specific stand. And there was
the only premise is that affidavit.
Only premise is that affidavit.
Which is not in your name, not signed.
Not in your name. Not in my name. Even assuming that there is an affidavit, though I absolutely categorically stated in my stay petition as well as in the recalling application that I have not signed. But that cannot, my lord, be construed as my appearance in the suit, because then you will be giving a go-by to Order 8, Order 5, Rule 20. Appearance in an interlocutory proceeding does not mean that I have entered.
What was your claim in the Order and Rule that you never knew about the suit?
Yes. I will show you.
No,
I knew, but I never appeared.
Stand in the Order and Rule 13, Mr. Dev, was that you never knew about the suit. Then that becomes German. Your appearance definitely becomes German. But if you say that you did not have notice of the final hearing of the suit, but previously...
No, my stand was...
You never knew about the suit.
There was an interlocutory application filed in the suit by the plaintiff, and there was an affidavit filed allegedly on my behalf. But that affidavit was never signed, unsigned.
Order and Rule 13.
Yes. Malad, kindly see, Malad, the order, Malad, once, or the page 533.
Your Lordship, I'm sorry to interrupt. I apologize to interrupt. I'm being led by Mr. Shudushatto Banerjee.
He will argue the matter. You argue the matter.
Your Lordship, I'm appearing for respondent number 1, Your
The
Lordship.
affidavit was filed in your name. Then we could catch hold of.
Your Lordship, I'm being led.
Shudushatto Banerjee is not in court.
He's not in town today, Your Lordship. I'm just praying that it be kept after the vacation, Your Lordship. Yes, Your Lordship.
I'll leave it to you, Malad.
It's my humble request, Your Lordship.
Interim order is there, Malad. That is till the end of January, Malad.
Till end of January. Otherwise, we will limit it. Otherwise, he would never come. Now, he comes to court regularly. Very well. On the prayer of the plaintiff stroke respondent, the matter is adjourned till January 7, 2026.
Much obliged, Your Lordship.
Lordship. If Mr. Banerjee is in court, he generally attends.
No. I have nothing. Today is the last day, I know. I would not stand in the way, certainly, Malad.
But it was lucrative. I mean, it could have been disposed of probably in
Yes. Not
half an hour.
Not much to be looked into,
Lucrative for the
Malad.
court.
Yes.
Another disposal.
Grateful. And Malad,
Now, in our dreams, we see disposals. Matters, paper books hanging above our head.
Absolutely, Malad.
Matters, papers scattered. Directives from the Supreme Court regularly. We see these things in our dreams. We have lost the daydreaming aspect of the.
Yes. I got your point, Malad. And Malad, may I wish Malad Merry Christmas and Happy New Year.
Thank you very much, and same to all of you. All of you.
Grateful.
Yes. But those who have not wished, be careful.
Yes.
Follow on the next matter. Dako. For the respondent.
My lord, item number 23, I'm led by Mr. Dheeraj Trivedi, my lord. I'm praying for not today, my lord. He's not in court, my lord. Kindly fix this matter after
Mr. Dheeraj
vacation.
Trivedi must be in court.
My lord, today he is not in court, my lord. Kindly fix this after vacation, my lord.
On the year for the appellant.
I am for the appellant.
On the prayer of the appellant, let the matter stand adjourned till January 7, 2026.
Merry Christmas and Happy New Year.
Thank you, same. Yes.
এগুলো বলতে হবে না?
Yes.
Christmas বলতে হবে।
I appear.
What about the Merry Christmas?
No, but I asked him, do we have to wish?
Suppose it's your other set. First, let us see whether it's a non-starter. I mean, I'm praying for time.
Appellant for the respondent number 1,
and
we are being led. We are being led by Mr. S.N. Mukherjee,
Mr. Ranjan Bachawat,
and
Mr.
Ratnako Banerjee.
Mr. Ratnako
All of them have
Banerjee,
deserted.
Mr. Devnath Ghosh, then
Mr. Devnath,
Mr. Shantun Basu.
But they're on your side, you and him.
No.
We have only.
Well, we were not there in the trial court. We were not in the trial court, and we are not on behalf of ITC. And it is cigarette.
Don't say in such a way. We get personally. But what about you're asking for time? If you're asking for time, say that. Otherwise, we'll take up the matter.
My lord,
Please
it
instruct-
could be kept on the 14th of January.
Could be, but are you asking for adjournment or should you start the matter? You can start the matter also. Mr. Bose will not take much time. Famous for
No,
that.
no, 25 sets of paper book, 25. I'll take little bit of time,
The more
but
the
the
number of
point,
paper bills, the shorter the matter is generally. That's
true,
all of the experience of all of us.
true. The point is short. It's all law point.
If you say we'll start, we're looking at us. I mean,
It
don't stalk us.
could only be kept on the 14th of January, my lord.
Oh, 14. That's why.
14.
Not even
Because, my lord.
Gobalda nahi naki. Huh?
He knows. So we'll keep it on 14, sir. You are for all the respondents.
Well,
Respondent number one.
only thing, everything has stopped by reason of an ex parte order since February 2025.
Everything means in the sense that
The manufacturing of cigarette, everything sale, everything has been stopped.
No, we are vacating the interim.
No. And
No,
there
no,
is
sale of cigarettes stopped.
manufacturing, sale, everything stopped.
Why? Passing off or what?
Millard, that's the big question. If your lordship wants, I can give you the outer, Millard, threefold action: copyright, infringement, and passing off. Regarding Millard infringement, perfect defense, because they said we do not have any monopoly when they got over the mark gold, gave up. So ours is gold stag. So infringement does not lie. One thing is, but learned judge, after recording everything, Millard passed when final order was being passed. Millard exactly passed the order for infringement. That is the one aspect of the matter, but more fundamental, passing off. Millard, passing off 85% is this awkward face, Millard. You won't want to look on that.
That's a statutory word.
That's a statutory. So you are restricted to only 15%.
I wonder who modeled for those.
Millard,
I've ever wondered who.
no, but I don't. Well, this.
No, you have seen the packets.
Yes,
Who
yes.
models for those.
Yes. So, Millard, you are on the word gold stag or gold flake. Everyone knows gold flake, right? Gold, if you have given up.
Gold stag. You're manufacturing.
Yes, in
Right,
Punjab
injection,
only in Punjab. And Millard, if you that's also a jurisdiction point which will arise. Clause 14 leave was taken but not given. Yet passing of past. That your lordship, that these are little bits here and there points of law, but I don't want to trouble.
We will address all the issues when
So
when the
Millard,
appeal is being heard out.
but Millard, it's not absolutely. I told your lordship only law.
Although the appellant is represented by senior counsel, learned counsel for the respondent seeks an adjournment. Full stop. Next para. Accordingly, let the matter stand. Accordingly, on the prayer of the learned counsel for the respondent number 1. Accordingly, on the prayer of the respondent number 1, the matter is adjourned till January 14, 2026. Full stop. However, it is made clear that since the appellant is suffering an interim order, the matter shall be positively taken up when next called on, irrespective of the absence or prayer for adjournment of the respondent number 1.
The second one is a cross appeal.
There is a cross objection which they have also filed. That is 15. It's 25. There we are the respondents.
Acha. Respondent number 1 যেখানে বলছে appellant respondent number 1 এগুলো in the appeal কথাটা দিই. Respondent number 1 are appellant in the appeal. Appellant has to be in the appeal. Appellant ক্ষেত্রে লেখা দরকার. Respondent number cross object respond judge.
Millard,
cannot be a respondent in the appeal.
Millard,
in the
also Merry Christmas.
Retrospectively grown up. Whatever has happened, happened. Adjournment granted against you. Yes, that's the way. Better way.
My lord, in this matter, I am appearing on behalf of the appellant.
And
My lord, learned senior counsel, Mr. Shuman Dutt.
learned counsel for the appellant seeks an adjournment. Let the matter stand adjourned till January 7, 2026. No objection, no you.
No objection, Lord.
Give your appearance. Yes, Christian.
I am for the respondent, my lord. This was adjourned on the last.
Lord, I appear for the appellant, my lord. Before I take adjournment, Lord, I wish Merry Christmas.
Lord, I'm being led by Mr.
No,
Joydeep Kaur, Lord,
now
kindly
it's over.
adjourn, sir.
Now
We have
your
to get the order.
limitation is over for Merry Christmas wishing.
12
Now we start the matter.
No,
on the last
Lord,
of
he is not in town, Lord. It's only two grounds, my Lord. First is, my Lord, there's a condonation from section 34, my Lord. This
is my-
appeal is
no,
filed, my Lord, beyond time.
But no, sorry. This was the last chance given to you. Now we cannot grant you.
Lord, I do agree, my Lord, that the order records, my Lord, last chance.
No.
But, my Lord, since I'm being led by Mr. Kaur, my Lord,
So
kindly
that
adjourns it.
is no ground. You have to start the condonation application. After giving last chance, we cannot do that.
Lord, I'll just request only on this ground, Lord. He's not in town. Otherwise, there's a
After
heavy
giving
matter,
a
Lord.
last chance,
Otherwise,
we
Lord, I
cannot
would
grant you another. There cannot be a second last chance.
Lord, kindly keeps the matter on 7th, my Lord. If he's not there on that day, I will do the matter, my Lord. Only this much indulgence.
Yes, Prashant,
What do I say, my lord? It's very.
We don't know when it will reach here again
Yes,
because the difficulties today
And,
we
my
are
lord,
reaching.
this is
Because
kindly see, my lord, the award of 2014. That's the difficulty, my lord.
this is the
We
second.
have already secured, my Lord.
There are 37 appeal.
37.
They have preferred a 37 appeal.
34 and 37 cannot be held up for so long.
And that
because
was-
that is
My Lord,
against-
on next day, my Lord, even if no one is there, my
not
Lord,
on
I
next
will
day.
do the matter.
Please move
I
the
will do
section
the
5.
matter.
What is the delay? Move
For
the section
45 days. That is why I am opposing, my lord.
You have filed in opposition.
Yes.
Yes, my Lord. They have filed my Lord, they have filed an opposition. We have
What is
filed
the
a
ground?
reply.
What is the ground taken by you in the section 5?
My Lord, the primary ground that has been taken, my Lord, is, my Lord, miscommunication by the department. From the department to its to the, my Lord, lawyers. The erstwhile lawyers who were there looking after the matter, my Lord, subsequently that team was changed. A fresh set of lawyers, my Lord, were
So that's
engaged.
a litigant's fault, not the advocate's fault.
Yes, my Lord, that's a litigant's fault, my Lord.
That's
But, my
not
Lord,
a
I
ground.
wish to address, my Lord, on that part, my Lord, as well. And, my Lord, I will also wish to cite, my Lord, two recent Supreme Court judgments on this part, so far as condonation of delay is concerned.
Mr. Shen, 440 something days delay, he may be in difficulty.
He will be in
He
difficulty.
will be in
Because I am relying upon a judgment, my lord,
Maybe.
specifically for 37 appeal. So if your lordship grants
Yes,
time, my lord, I will
maybe.
not
My
grant.
Lord, that judgment I will also be relying on.
I mean, in the context of 37 appeal, it has been said that even though limitation applies, but considering the object of the Arbitration Act,
That is what we told him because for Arbitration and Conciliation Act, these things, the other liberal concepts don't apply.
might apply, my lord.
May not apply.
So this is the specific judgment which I would be relying upon, my lord, on that.
An adjournment is sought on behalf of the appellant, first up. Learned Senior Counsel appearing for the respondent points out that on November 12, 2025, a last chance was given to the appellant to move the application. First up, next para. However, keeping in view that Learned Senior Counsel leading the learned advocate seeking adjournment for the appellant is out of town and that today is the last day before the Christmas vacation, another chance is being given to the appellant to move the matter. First up, however, it is made clear that in the event the appellant does not move the matter on the next occasion when it is called on and or seeks an adjournment, no further adjournment would be granted and the matter may be taken up for hearing expertise in the absence of the appellant. Thank you.
Grateful, my Lord. Great.
Can it get some precedence if it is possible, my lord?
Mr. Shen, there are other matters also because difficulties we don't have any mechanism to assess which are shorter matters. If we could do that, we would put that above the others, and we cannot do that because now the listing is serially and all those things are there. It's automatic.
Automatic, on the year wise and the number.
That we principally support because otherwise the judges may have some personal interest and those things may be there. So we may
paper book file.
Yes, but that assessment mechanism we don't have. That is the difficulty. Before you hear the matter, when you take up the matter, we understand.
Hear it for minutes or 2 minutes or so, then the judge will be able to go.
Yes, but we have to reach the matter before that. But the previous matters take up time. So next bill is still next January 7. Yes, January 7, 2020. That is the first. Yes, Mr.
Grateful, my Lord.
28.
Yes. My lord, in this matter, my lord, we were to file paper books, my lord, in the appeal. My lord, 28 days. Yes. My lord, in this matter, my lord, we were to file paper books, my lord, in the appeal. My lord, in the appeal, my lord, we were to file paper books, my lord, in the appeal. My lord, in the appeal, my lord, we were to file paper books, my lord, in the appeal. My lord, in the appeal, my lord, we were to file paper books, my lord, in the appeal. My lord, in the appeal, my lord, we were to file paper books, my lord, in the appeal. My lord, in the appeal, my lord, we were to file paper books, my lord, in the appeal. My lord, in the appeal, my lord, we were to file paper books, my lord, in the appeal. My lord, in the appeal, my lord, we were to file paper books, my lord, in the appeal. My lord, in the appeal, my lord, we were to file paper books, my lord, in the appeal. My lord, in the appeal, my lord, we were to file paper books, my lord, in the
I will, my lord, not insist that your lordships take it up today, but the point involved is, my lord, very, my lord, interesting.
Why? Who is appealing for this?
My lord, I'm led by my senior, Mr. Avinash Kankan. He's on his way.
Well, then because you have to start today.
Yes, my lord, I was hoping to leave early, my lord.
Do you have a flight to catch?
I have a flight, my lord, but my lord, I can.
Some other engagements before that.
No, my lord. I've taken leave in another court, and my lord, I have, my lord, I can, my lord, tell your lordship, my lord, what, my lord, the point is, my lord. My lord, a son, my lord, of a testator, my lord, who has been adopted, my lord, by, my lord, the brother, my lord, of the testator, my lord, does he or can he have, my lord, a caveatable interest?
Adopted in due process of law.
Yes. My lord, this is, my lord, the issue. The learned judge.
What is that difference? What is the reason given by the learned judge?
My lord, the learned judge, my lord, has said that, my lord, any vested right, my lord, cannot be, my lord, taken away by virtue of adoption. My lord, the issue is what is a vested right.
But this is Hindu adoption.
Yes. So, my lord, this is, my lord, the
You have heard him. What is your defense?
My lord, I'm again led by my senior. Not briefed well in this matter, my lord.
This will not take much. Could have been finished today even.
My lord, might have been. I have 3 cases to cite, my lord, of the Supreme Court. My lord, on, my lord, the.
Yes, we can. No, you have taken leave from another court. I mean, when we were.
Oh, my lord. My lord, I intended to go back before lunch. My lord, that is, my lord.
But these are actually short matters. I mean. Anyway, let us come back after the vacation if you
Yes, my lord. My lord, could it be, my lord, 13th of 14th? 14th.
Then we'll put it on you, your prayer.
Very well.
On the prayer of learned senior counsel appearing for the appellant, let the matter stand adjourned till January 14, 2026.
No.
The paper books filed today in court be kept on. You have got copies of the paper book?
Yes.
Come prepared on the adoption law.
Only one thing, my lord, since my learned senior friend is there, it's a fight between 2 family members, my lord.
If you can resolve.
Yes, my lord, what is our suggestion is, my lord, the only dispute is, my lord, the caveator, my lord, now he's been adopted by the other branch. So if they accept that, my lord, since Mr. Mukherjee is here, my lord, because
rely on that. Not only accept that, they rely on
they are relying on that, but they are saying no, that is false.
No.
That
cannot say.
I can.
That will beat the difference.
My lord, in the will, my lord, because the application says that he claims to be adopted, but he is not. And then they sought for issuance of citation on
My
that.
lord, I am, my lord, agreeable to exchange the estates also.
My lord,
So he is making it clear.
My lord, since my learned senior friend is there, that is the only
No.
issue that
He's there. He's like to
My lord,
exchange the estates.
yes. My lord, if
Have a talk.
yes, my lord, I'll have a talk, my lord. If my learned friends, my lord,
yes,
then he goes out of this, and my lord,
yes,
my lord, I get this estate, my lord, he gets my brother's estate.
My lord, that is the whole fight about. My lord.
Let us come back on 14th.
Yeah.
My lord, Tapos Kumar Sinha, learned advocate for the petitioner, kindly pay for no.
How dare you? The SG is here and you are asking for time.
Yes, my lord.
Start the matter. Start the matter. What is the matter about? Where is your brief? Open it.
My lord, I am new junior.
No new junior, so what? Start the matter. That's why you are asking you. Yes.
10th of December, this has been restored. This matter.
Start it, ma'am.
And the last occasion specifically directed.
How new? When did you join the profession? When did you join the profession?
কোন year join
Forgotten?
Yes, my lord.
কোন year join করেছো ভাই
2024.
24. So what? 1 year has elapsed. Start arguing. Open the brief.
Kindly, my lord.
Open the brief. The court's direction. Open the brief. Yes, start the arguments. What is the matter about? Place the impugned order.
But I'm led by learned ASU.
Yes, what is the matter? Start the matter. Read the impugned order. Where is the impugned order?
I don't know this matter, my lord.
Adjourning it.
May I just make one prayer?
Yes.
This is a matter relating to detailed allegation about misappropriation of money by the trustees of Dakshineshwar temple.
Oh.
So this is actually, there was a direction by the then Honorable Chief Justice to upon us also in India to file an affidavit. So what status we have filed an affidavit in respect of such an allegation?
For the temple trust.
Yes. Now they are alleging that this is a private trust. The Dakshineshwar authorities, they are alleging or taking the defense, the private trust. But actually, that will be open to your lordships to consider that in case of the Trust Act and the other serious repercussions in regards to the execution.
No,
of the
it's the
trust.
other way around probably.
May I just say one thing?
You are for the Dakshineshwar Trust.
No, I am for Union of India.
Acha.
I am for Union of India. Therefore, I have. May I just?
You are for?
I am for the Dakshineshwar.
Dakshineshwar.
No, I have just only one submission, that we have an obligation to file an affidavit in the event your losses find that this is a public trust.
No, was that a conditional order? There was a direction for filing affidavit, file it.
No, actually, what
you have
has
to take a stand in the affidavit.
Very well. But what has happened, Mr. Dipankar Dandapad was an advocate. He is no longer in this matter. He has recused. Mr. Arijit Bojumdar was replacing him. He is out of station. So I was not surprised that the further direction was given upon us to file affidavit.
So we'll extend the time for filing affidavits. Come back, file it within a week from the reopening, and we'll take it up on 14th.
Yes.
We'll take it up on 14th.
Make it 2 weeks. Now no order has been, but I'll make it 2 weeks after reopening.
2 weeks after reopening?
Because it has to be ascertained from the Ministry of Culture.
Only you are directed, or they were also directed?
Both.
Lordship, the context was that when the allegation was made specific, because we took a preliminary point, objection regarding that this is not maintainable. As far as the
This is from a suit for?
As far as the public interest are concerned.
No, the suit is for what?
Suit is for holding elections of Dakshineshwar, which is held every 3 years.
You filed the suit?
Under the Calcutta High Court.
You filed the suit?
Suit is of Lordship 1862. Now, every 3 years, several directions have been passed. That election is held every 3 years.
Yes.
Last election was held under the ex-Chief Justice. Now, that election was challenged by a person who says that he is just a devotee. His father applied that I'm a great devotee, many years. Please make me a Shaivat. So the chairman refused that this way Shaivat cannot be made because there's an Orpon now. Now, that same gentleman, after that refusal, came up and filed a public interest litigation, which is pending before Lordship. Now, the same gentleman, again, when the election orders was passed,
went and challenged. Public interest litigation. Public interest.
They say it's a public.
That's very well. So
public trust because it has become a public charitable.
And what is the appeal about? I mean,
appeal is from that election order. The same gentleman who has filed the public interest litigation.
There's a question of locus also.
Yes.
Locus and
that has not been heard yet.
We are
giving an application pending.
We are extending the time for filing the your affidavits for all the parties, but we are giving a last chance for that to all the parties, and we'll positively take, because otherwise the elections are held up unnecessarily. Is there any subsisting order of injunction?
Nothing is held up, Lordship. The elections have been held. It's been given effect to. Lordship, the only problem is showing this public interest litigation 3 years, because the direction was made 3 years back, 23. So 30th January 2023. So Lordship, in January, this will become 3 years. By showing this, one crocodile, little one, all elections, all matters, everywhere it has just been held up.
No interim order was passed here.
Nothing.
Interim order was.
This was dismissed and only.
The interim order, if any, was vacated, but there was no interim order.
No.
No interim order at any point of time. Then we'll say pendency of this would not affect the rights of the parties in any forum.
In any way, Lordship, elections are held, just they are not even admitted.
But I have only one subject to what you asked. Unless your lordships conclusively hold that this is a public trust, whether there is any scope for inquiry, or whether there is any scope for maintaining public interest litigation in terms of the rules framed by this honorable court, in terms of 2010 Supreme Court
No, no,
judgment.
you are right. You are right, Mr. Chakraborty. That also, for that reason, probably you are directed to file affidavits to take your stand. An adjournment is sought on behalf. An adjournment is sought on behalf of the appellant. For sub next para, learned ASG appearing for the Union of India seeks an extension of the time for filing affidavit as per previous direction. Accordingly, the time for filing affidavits by all the parties as per previous direction of a coordinate bench is extended till January 14, 2026. The matter shall next be listed on January 21, 2026. Please come back on that.
Subject to Lordship's time, I know. Just on a preliminary point, because we've taken the preliminary and as learned ASG.
Maintainability and look,
Can it be taken up?
it is made clear. It is made clear that the preliminary objection as to maintainability and locus standi taken by the Union of India as well as on behalf of the Dakshineshwar Kali Temple and Devottar Estate is kept open for being decided at the final hearing of the.
One more submission. This Union of India has been added through the Secretary, Ministry of Finance. But it is actually Ministry of Culture has to file the affidavit, because these temples and all these your lordships are aware, they come within the zone of consideration of the Ministry of Culture. What the Finance Ministry will do, unless there are materials before the Finance Ministry to file such an affidavit. So liberty may be given that the Ministry of Culture simultaneously will be also liberty to file the affidavit.
On the submission of learned advocate, additional Solicitor General to the effect that the Ministry of Culture, and what is the full name of the ministry?
Ministry of Culture.
Ministry of Culture ought to be permitted to file an affidavit, since it is the appropriate ministry which might have information with regard to the dispute involved in the present LIS. Accordingly, the Ministry of Culture is also directed to file an affidavit on the returnable date.
Also,
Also, there was a direction on the Ministry of Finance, let them file it. You can say in your affidavit that we rely on this. সবকটা ব্যাটা শেষ হলো না 30 আছে ডেকে দাও তাহলে দেখি যে হবে না হয়তো
Wish your lordships happy vacation, happy
Thank
new
you.
year.
Same to all of you.
Lordships have said limitation is
Yes. So for the SG itself,
but not
senior advocates.
Yes,
Yes.
brother.
30. Let us see whether the other side does it.
Section 5 can be allowed, brother. Only the delay of 25 days.
What is the ground, Mr. You are for the appellant?
Medical ground of the client, brother.
Yes, viral fever.
None appears for the. You have served copies. Just check up.
Service
Yes, service.
Yes.
Affidavit of service. You require the affidavit of service. Affidavit of service? No.
I think one affidavit of service.
Service
If
has
I'm
been filed.
No, affidavit of service. Let us find out date, please.
I'm sorry, my lord, it is not there.
Then difficult.
বলেছি তো তাই।
We'll allow the affidavit, the section 5 and take up lock, stock, barrel on the next one.
Yes.
None appears for the respondents at the time of call. Full stop. The appellant shall file an affidavit of service with regard to the service of the connected applications having been effected on the respondents on the returnable date. Full stop. The matter shall next be listed on January 7, 2026. If you have not served, please serve in the meantime. And
Yes.
we have just directed to file service, affidavit of service on the next day.
But they are saying it is filed in the department along with the notice of motion.
তাহলে যেখানে যা বললাম, if not already filed. To file affidavit the next day, comma, if not already filed.
I think
yes, you are appearing.
No,
Mr.
no,
My lord, I'm led by Mr. Sen only. My lord, what happens, my lord, if you do not file the affidavit of service in the department, my lord, the notice of motion will not be lodged. So it has to be hand served, and then only it could be
If
filed.
not already filed করে রেখেছেন তো ওটা থাক ওটা আনিয়ে নিন we'll get that from it.
Okay.
I cannot hear your lordship. My lord, I cannot hear you. It's deeply obliged. No.
বলুন আপনি any mentioning বলতে হবে?
Malad, with regard item number 57, I am praying not today. I am the appellant. 57.
When if the matter is called on, then mention, not now.
My junior.
Yes, yes.
Malad, may I permit to mention, Malad?
You can keep a sub-junior also. No difficult. Anybody mentions will. But inform the other side if you can.
Already I have informed.
Yes.
Malad, I'm praying for leave to file this appeal without certified copy, Malad.
Granted. This was the matter you were mentioning in the morning.
Yes, Malad.
Right. Granted. Leave granted. Call. Yes,
I have
Mr.
the appellant in this Malad.
When is it expired?
Today.
What is the nature of the interim order?
Notice was not given. I just saw this in the list and came running. This no notice of.
The interim order is expiring today in any event.
But in my humble submission, this is an eviction decree, my lord. On the last occasion, I could not produce anything in regard to the rental valuation.
Directed you to file affidavit in opposition.
My lord,
Opposition reply is filed. Malad, maybe
file it.
May I file the reply also?
Yes, yes. You can dispose of the application also, Mr. Mishra.
Malad,
occupational charges may be given for extension, madam. This is
We'll just check up. Could have given a notice, Mr. Mishra.
For yesterday, my lord.
For mentioning for this is being fixed out of turn for extension.
Actually, it was running in the list, my lord. I thought, my lord.
Running in the list, but this is appearing out of turn for extension.
But I'm sorry, my lord.
I told you that it will be put in the list for extension of. Otherwise, it would be running in the list. It would be much below. It is coming up as the first matter because you mentioned the matter.
Yes, my lord.
Should have given a notice. Opposition, 1 copy.
2 copies will be there.
Where is the second instruction?
My advocate on record is coming. I just came running after seeing the list, man. I'll file it within the course of the day. I'm extremely sorry. I just saw this in the list and I came.
We'll take it up after the 2 p.m. matter. There's a 2 p.m. matter we have.
Lord, in this matter, my lord, for the merits of the matter, my lord, I'm led by Mr. Bhudev Chatterjee, my lord. He has not come today, my lord. So if your lordship can keep it after vacation and extend for that period.
No, then extension can be subject to payment of occupational charges.
No, we'll keep it on the reopening day, on the very first day.
But in that case,
Learned counsel for the appellant. Learned counsel for the appellant submits that the interim order is expiring today and may be extended for a limited period. And may be extended. Please.
I'm sorry.
Learned counsel for the respondents opposes such prayer and submits that in the event extension is granted, the appellant should be put to terms by paying occupation charges. Full stop. It is further submitted by learned counsel for the respondents that respondents যেখানে বলছি ওখানে respondent number 1 হয়ে যাবে, হ্যাঁ? It is further submitted by learned counsel for the respondent number 1 that no notice of the matter being taken out of turn was given to the respondent number 1. Full stop. Next para. Keeping in view the fact that the matter was mentioned for extension without notice to the other side, at the same time keeping on balance that the interim order is expiring today and the appeal may be rendered infructuous in the event the same is not extended, we extend the interim order granted earlier for a limited period till January 9, 2026. Full stop. The matter shall be listed under the same heading, that is extension of interim order, next in the monthly list of January 2026. Full stop. The affidavits in opposition and reply filed to be kept on record. Full stop. The learned advocate for the respondent number 1 is directed to file the learned second judge's copy of the affidavit in opposition during the course of the day. Do that, please.
I'll do that in the course of the day. In the course of the day.
Please do it. Course of the day means not the entire day. Do it as early as possible.
As soon as possible. As soon as possible.
Yes.
Item number 3.
Yes, I am appealing for the appellant, my lord. It's an application for restoration of the second appeal. So, Lord, you heard this matter. The after admission of the appeal, coordinate division, honorable division will please to dismiss this appeal on the ground of non-appearance of the appellant. And regarding one of the respondent number 1,
abated against respondent number 1.
You 1.
It has been since on the last occasion, your lordship heard this matter, and your lordship pointed out that after admission, division bench.
Admission, when was it admitted?
Admitted, my lordship will find in my can 3, I have annexed the order of admission, and along with that, there was a stay application was also there. Lordship will find at page 11 in
Yes,
can
yes.
3, my lord, I have annexed the order formulating the question of law.
Admission report. What was the occasion? Why was it appearing under Lozima?
No, my lord, that is
Must be
even
under
if I have deposited lower court cost of the lower court record, and I am told, my lord, it is also it was all in the record before this honorable court.
You are appearing for the other side?
No, my lord, he is my advocate. Okay. In regard to service.
But you should have served on Mr. Mahato.
Yes, this is service. In regard to earlier also, service, his junior was refused to accept. And in regard to number 2 is concerned, that apna then we want two affidavit of service. The second page is copy none. This is one.
One affidavit of service.
This is different. One for the respondent 1 and another is for the respondent 2.
One has died.
No, one has died. His advocate on record refused to accept the service in view of the fact the brief has been taken back by the client. And in regard to service of 2 is concerned, that has been accepted by his representative.
What about the abatement? Respondent number 1 died. So regarding
abatement, I cannot file abatement until it is restored. My lordship will find the order impugned. Lordship will find.
But the abatement part remains subject to discretion, subject to your making application.
That is, I cannot file until and unless appeal is restored.
No, the fact remains that the appeal has abated. But abatement, recording of abatement does not mean the appeal is dismissed. Yes. None appears despite service on behalf of the respondents at the time of call. Full-stop affidavit of service filed to be kept on record. Full-stop. By an order dated October 3, 2024, a coordinate bench had dismissed the appeal in view of the appellants and the respondent number 2 not being represented on the said date, vacating the interim order, as well as observing that the appeal was treated to be abated as against respondent number 1. To some next parallel, counsel for the appellant submits that after the admission of the appeal, the appellants had no apprehension that the matter would again be listed before a division bench, since the established practice of this court is that after admission, the appeal and the connected applications are heard by a learned single judge. To some next para, secondly, since no application for substitution after setting aside abatement on condonation of delay could be taken out on the demise of respondent number 1, due to the appeal itself having been dismissed for default, leave be granted to file such application upon recall of the order. Push-up. Next para. We find sufficient reasons, sufficient explanation for the absence of the appellants on the relevant date from the application bearing can 3 of 2025. Accordingly, can 3 of 2025 is allowed, thereby recalling the order dated October 3, 2024, inasmuch as SAT 46 of 2017 was dismissed for non-appearance of the appellants, and the interim order then subsisting was vacated. Full stop. Next para. However, we retain the observation in the said order to the effect that the appeal has abated as against respondent number 1, subject to leave being subject to the appellants filing an appropriate application for setting aside for substitution after setting aside abatement of condonation of delay in respect of the said deceased respondent number 1, for which leave is hereby granted to the appellants. Next para. Accordingly, SAT 46 of 2017 is restored to its original file and number full stop. The interim order subsisting as on that date is revived as on today. Full stop. Next para, the matter be placed before the appropriate learned single judge as and when an application for substitution after setting aside abatement on condonation of delay is filed. Full stop. No orders to cost.
Only since the order was for sending down the lower court record.
Acha. The trial court records shall be brought again by special messenger, comma, to be deposited by the appellants within a week, within January 9, 2026. Thank you.
ঠিক আছে তো আর কিছু না না ঠিক এটা I'm applying for the appeal.
You have not filed any supplementary affidavit. You have to file.
I'm fine. I'm fine today.
You're ready with that?
Yes, my lord.
Given a copy to the other side.
Yes.
What is the application?
The application, my lord, for reimposition of the stay order. That was due to default in the paying of the occupational
Have you given a
charges.
notice to the other side?
Yes, my lord.
Let us have those. Supplementary affidavit as well as or receipt of service. Receipt with. What was the original order? You and Mr. What is your name, please?
Orgho Mollik.
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 Mr. Mollik, where is the original order? Have you annexed that?
Yes, that is in the Can 2 application.
Acha, page 8.
Page 8, my lord.
Yes, page 8.
Direction to pay 1 lakh initially, that was paid.
Right.
Thereafter, month
You are
by
for the
month.
other side.
This morning, my lord, I'm praying for an accommodation. My lord.
Why?
Lord, advocate on record not.
No, no.
No, my lord.
They're without stay, then you cannot execute the decree. They're without interim order, you are asking for adjournment. What happens if you execute the decree in the meantime?
My lord, that is fixed, I think, in the middle of January, my lord. The date has been fixed in the executing court.
Supplementary affidavit as well as receipt of service of notice filed today be kept on record. Full stop. Next para. Learned counsel for the respondent seeks an adjournment. Full stop. Next para. Accordingly, let the matter stand adjourned till after the upcoming Christmas vacation and be listed next in the monthly list of January 2026. Full stop. Next para. It is made clear that in the meantime, comma, the decree against which the appeal has been preferred shall not be executed by the appellant, comma, in view of the fact, shall not be executed by the respondents, comma, in view of the fact that the matter is being adjourned on the prayer of the respondents today.
A supplementary affidavit be kept.
First sentence of our order.
Much
Yes.
obliged. Thank you.
I am for the respondent.
Yes.
Appear for the appellant petitioner on earlier occasion.
Seeing Mr. Rai after quite some time. Yes. Seeing you after some time.
Yes, yes.
On the
Yes,
delay
yes,
has
Mr.
been
De.
condoned. Not Can 2 is for not from an order of injunction.
This is an appeal against?
That appeal against dismissal of a suit for specific performance of a contract.
No, it's suit for declaration and injunction, not specific performance. of contract.
Declaration that the agreement is subsisting.
Yes, and in Malad, we are bound to Malad sell the property. The specific performance of contract has not been paid for. The court has held that this is no specific suit for specific performance of contract. The suit has been dismissed. Against that, this appeal has been paid.
Not maintainable in its present form.
Yes, yes. And Malad, another submission before your lordship, Malad, this is today the application is appearing. Now, Malad, during the pendency, this is judgment is of 8 January 2024. The suit was, the appeal was filed with the application for condonation of delay. And your lordship's court, Malad, condoned the delay on 17th December 2025. And before that, in August 2025, the property has been sold to someone else.
You can disclose the name particulars
So then you can take steps.
My lord, I shall intimate my
No
lord.
scope for injunction then. Can 2 is the injunction.
Plan can.
Learned senior counsel appearing for the respondent, comma at the outset, comma submits that
My lord, I am handing over a copy of the deed of conveyance to my learned friend.
that in the meantime, comma, the suit property has been transferred by the respondent in favor of third parties. Full stop. A copy of such deed, you can have it. Have got an extra copy. Take out the copy and file it for the court also. We'll keep it on. Learned counsel, learned senior counsel hands over a copy of the transfer deed to the learned advocate and record for the appellant here and now, comma from where and from when, as well as files copies of the same for the court's records. Full stop. It transpires therefrom that the property has been transferred in the meantime by the respondent in favor of a third party, comma the particulars of such party being disclosed in the transfer deed itself. Full stop. Next para. On the prayer of the appellant, we are making it your prayer.
Lordship.
Comma leave is granted to the appellant to make an appropriate application for implement of the transferee in the appeal. Full stop. A copy of such application, comma as and when filed, shall be served on the learned advocate for the advocate and record for the respondent. Full stop. Next para. In view of such transfer, comma, can 2 of 2025 has been rendered infructuous. Full stop. Accordingly, can 2 of 2025 is disposed of with the above observations without any order as to cost. Full stop. However, comma, nothing in this order shall preclude the appellant, comma, in the event the transferee is impleaded, comma, to seek a similar injunction against the said transferee. Full stop. If such injunction is sought, comma, the same will be adjudicated by this court in accordance with law upon giving opportunity of hearing to the respondent.
Lordship, service upon the opposite party as well as the proposed transfer or only?
Only them. Only them. Because unless we add them, you cannot.
I'm great.
Injunction application, if you file against that added transferee, once we add, that has to be served on them. But this, they are only entitled.
In this matter, Mr. Gautam was the appearing for the rest. Yesterday, I was mentioned because Lord said that his wife is expired on 21st of
Oh, yes, yes, yes.
Let it be 1 week after the result.
Well, on the prayer of the respondent, comma, due to certain mishap in the family of learned counsel for the respondent, comma, let the matter stand adjourned till January 12, 2026.
I'm grateful.
12 January?
I'm grateful.
Give your names.
Yeah.
Lordship, I appear for appellant. May I file the affidavit of service? They have refused.
Last chance was given to you, yes.
Yes, Lord.
Yes, what is that?
Lordship, they have refused to accept the copy. And they are audacious so enough because they have executed the decree. And Lordship, the...
You refused?
No, my lord, that was
why, Mr. Chakut?
That I have instructed to collect. I will collect, my lord.
You have instructed to refuse?
No, my lord. I have.
You cannot.
To,
you are not
my
capable
lord,
of doing that.
Instructed not to refuse any further document, my lord. That
Lord,
was
but this is good service then.
Lordship.
Yes, my lord. But
this is...
Lordship, they have executed the
Yes.
decree without giving any opportunity, and in the appeal, Lordship.
If it is filed within 12 years.
Yes, I am aware, Lordship. I'm aware, but certain principles should have been followed. They took an order from in my appeal. They did not give notice.
But we cannot reopen that now. But the appeal, if you want to carry on with the appeal will be kept pending. If you win the appeal, then 144 applies and you get red
Yes,
points.
Lordship. Yes, Lordship.
So we
So,
can
Lordship,
pass necessary directions for. We'll say that the stay has become infructuous in view of the.
Lordship, they should not change the nature and character, and my
For
machinery
that you have.
dates are there. My machine.
For that you have to file a specific application alleging that they're trying to do it without
They
any
have already changed the imprints and the machinery parts.
So that's why all the more it's necessary for you to file an application
Lordship,
making the averment so that they
Lordship.
can deny whatever they have to.
Lordship.
Do that immediately after the eviction.
Lordship.
Affidavit of service filed to be kept on record. Full-stop. Learned counsel for the plaintiff stroke respondents reiterates, as per previous submission made on December 17, 2025, that the decree impugned in the appeal has already been executed by taking possession of the property. Full-stop. Next para. Learned counsel for the appellants alleges that due process of law has not been properly followed by the respondents in taking such possession, which is denied by learned counsel for the respondents. Full stop. However, fact remains that in view of the decree having been executed, the application for stay has been rendered infructuous.
Lordship kindly keeps it pending. Lordship, there are
Stay application cannot be kept pending. Full stop. Accordingly, Can 1 of 2024 is disposed of as infructuous without any orders to cost. Full stop. Next para. However, at this juncture, learned counsel for the appellants submits that an order of injunction may be passed restraining the respondents from dealing with the property. In the meantime, full stop. Leave is granted to the appellants to file an appropriate application for injunction in that regard. Full stop. If such an application is filed, a copy thereof shall be served on the learned advocate for the respondents. Full stop. Leave is granted to the appellants to mention such application as and when filed for enlistment.
Great, Lordship.
Thank you.
But they have not filed their vakalatnama, and they should give.
They have not
the
filed a
particulars.
vakalatnama?
That is why I served them.
The vakalatnama has been prepared, but I will file it today.
Still they have not.
I beg your pardon.
That is why I took the.
You should say that on the prayer of learned counsel for the respondents. Why should they point it?
Particulars.
On the prayer of learned counsel for the respondents, leave is granted to the learned advocate on record for the respondents to file his vakalatnama during the course of the day. They should not point it out. You should point it out.
I beg your
They should give particulars also for service. They are refusing all along.
But if you refuse once more, Mr. Chakravarti, please give instruction. We'll take exception and we'll grant injunction definitely.
This kind of practice is now going on. They appear, take order, and don't file vakalatnama.
Not generally going on, but in specific certain cases, yes.
First direct as usually to the client, my lord, and he has by some mistake.
Grateful.
I have instructed my lord not to refuse any.
Item number 8, I appear for the appellant. Now, your lordship, before I take your lordship to the facts, my lord, and a 2 pending application, I will hand over your lordship an act. Kindly consider this act. 3 provisions I would show. This is a matter which pertains to the West Bengal acquisition of homestead land for
But you have to file Talabana of rupees 5 for 11, 6 to 11 and 12. We have not filed the written up notice forms. Comply with these things. Why do you keep these pending? We'll permit you, yes. But what is the application for?
2 applications. One is an application for implement of the BLRO. I will tell you, lordship, why the presence of the BLRO is required.
Have you given copies to the respondents? Serve on the respondent and come back.
We have served. We have served.
There's a direction for service previously?
There was a direction for service. We have served them.
Let us see the service.
We have.
Let me do.
This is service on the BLR. Advocate and the BLR. This is a service upon the advocate as well as a BLR.
One second. When was it directed to be served?
There was an order.
You cannot hand over receipts like this. They are not advocates. You have to file a proper affidavit of service, Mr. Dattu.
Affidavit of service.
Only advocates will take receipts.
Yes,
they are not advocates.
Advocate service was effected
on the advocate.
On the advocate.
Achha.
An advocate. First address is the advocate of the respondent. And served.
So, how many respondents are there?
Respondents are 1, 2, 3, 4, 5, 6, 7.
The advocate applied for all the respondents?
5. Yes. All family members.
Great. Yes.
And I will tell you, Lordship.
Additional upper, yes.
I will tell you.
You are
Lordship.
relying on some this
Yes,
statute.
Yes. I will be relying upon this statute. Kindly take this statute once, and I will tell you, Lordship, the facts then, my lord. This is a matter relating to the West Bengal acquisition of homestead land for agricultural laborers, artisans, and fishermen Act 1975. Very short act. This act is to provide for the acquisition of land in rural areas on which homestead has been constructed by any person, being an agricultural laborer, an artisan, or a fisherman, and conferment of title in such land in favor of such person. Thereafter definitions in section 3, 4 says where an occupier has been in possession of any land on the 26th day of June 1975, then if the land is in possession does not exceed such and such hectare, such land, and if the land is in possession exceeds such hectare, so much of such land as it does not exceed such hectare shall stand acquired by the state government and shall thereupon stand transferred and vest absolutely in favor of such occupier. Thereafter, kindly come to section 12. No court shall entertain any suit, application, or proceeding in any relation to any land or part thereof, which has vested in an occupier, relation to any land or any part thereof, within which has vested to an occupier under section 4, and no occupier shall be liable to be evicted or dispossessed from such land, notwithstanding any judgment, decree, or order of any court of such eviction or disposition. Bar on entertainment, no degree. Now, the appellants who are before your lordship is a occupier who has got title over of the property by virtue of this act. Now, the respondents were the original owners of this property. 75, by virtue of this act, state government took over this property, gave me the property, and my name was recorded in the ROR. That is, they subsequently instituted a suit for declaration, eviction. I contested, but I would be candid. I have seen the papers. This point has not been agitated about this provision of law that no suit can lie and no decree could be passed for eviction.
In your written statement, you said that you are an occupier under this act.
That is not stated.
That is a mixed question then.
That is a question that has not been stated. I have checked the written statement.
You have an order for 227 for that.
Yes, that's why we have filed order 41 rule 27.
You sought for an amendment of the written statement also.
Not only order 41 rule statement to show that I am being given
the
this
vesting notification.
Yes, notification. And secondly, I have also sought for an file an application seeking for implement of the BL order, because he is the right person who will be able to say whether I have been.
No, Mr. Dotto, somebody who is not a party to the suit cannot be added now.
But the court has.
There might have been a witness in the suit, but not a necessary party, because this is a suit. The frame of the suit demands that only you two are necessary parties. He has filed an eviction suit. Your defense may be that this land was vested and you are an artisan or but Hillary is not a necessary party.
But we have made for the purpose of proper adjudication.
Rule 27, we can understand, Mr. Doctor, but you should have advised your client also to take out an application for amendment of the written statement at this stage. Without pleadings, how can he entertain evidence?
Copy দিয়েছি স্যার সব কপি দিয়েছে দেখুন এই তো কপি
we only have a notice that a notice has been given to your learned advocate on record to you that this will be taken up, this will be mentioned, but regarding copy service we don't have anything.
Addition of party also we have given them.
So Mr.
দিয়েছে
and file those receipts in court also.
Yes,
all the receipts.
Yes, addition of party in respect of the mentioned application এই তো সই রয়েছে এটা আপনাদের নয়? হ্যাঁ ওনাদেরই সই। এই তো অ্যাডভোকেট অন রেকর্ড বলছে তো দিয়েছে।
Whose signature is that?
আমি ভগবত চৌধুরী বার অ্যাসোসিয়েশন 13 এটা দিয়ে
Bhagat Chaudhary is the advocate on record.
Originally that's what, my lord, I have transferred it.
It has been served on.
So far as this application is concerned, my lord, addition that we have not.
DH. It's
Order
our
41
our
full 27
They've
application.
given all
that-
copies to Mr. Chaudhary, but you take photocopies, Mr. Mitru. You ask photocopies to be taken by your clerk from them.
we will give
Read
one
up after the vacation.
paper book.
Addition of party we are rejecting right now, Mr. Dattu, on the ground that he is not a necessary party.
And order
But at best
41
we are-
full 27 application, my lord.
that has been directed to be heard along with the appeal. By
Yes, that is the usual course that is
already granted.
yes.
That
Yeah.
has
If
been
you want to file opposition there too, we can give you that liberty. Because it will be taken up along with them. Whose phone is vibrating? Your phone.
I have fixed.
Pick up the phone and ask him or her not to call so many times. Documents. Some other court maybe. We are quickly releasing by dismissing this application.
On the last day, an urgent matter has come up.
Yes. Mr. Mitro, we are rejecting the application for addition of party of the BLRO because BLRO is not a necessary party in the frame of the suit.
BLRO's presence, my lord, is required, my lord.
Not as a party.
Not
If
as
has been sought.
but as a proper party can be.
Mr. Mitro, learned counsel appearing on change for the respondent submits that he is not equipped with copies of the applications. Full stop. Next para. Learned counsel for the appellants is learned advocate on record for the appellants is requested to furnish further copies of the applications on Mr. Mitro. Full stop. Next para. However, in view of the nature of the order proposed to be passed on Can 4 of 2023, we are not insisting upon prior service of such copy on the prior further service of such copy on the respondents. Full stop. Next para. The appeal arises out of a suit for declaration and eviction filed by the plaintiffs stroke respondents against the defendants stroke appellants. Full stop. Next para. Learned counsel for the appellants argues that subsequent to the passing of the decree, it came to the notice of the appellants, who, being laymen, were not properly advised previously and not aware of their rights, that the appellants, being occupiers of the suit property.
I'm handing it.
No, we have that act. You just gave. No. Occupiers of the suit property under the West Bengal Acquisition of Homestead Land for Agricultural Laborers, Artisans and Fishermen Act, 1975, are immune from any suit being instituted by dint of Section 12 of the said Act. Push up next para. However, learned counsel candidly submits that such submission having not been made in the trial court, not taken in the written statement, the an application for production of additional evidence has been filed before this court, which has been directed by a coordinate to be heard along with the coordinate bench to be heard along with the appeal. Push up next para. Can 4 of 2023 is an application for addition of the concerned block land and land reforms officer as a party to the suit on the premise that the said officer can shed further light and produce the original records to establish the new case being sought to be made out by the appellants in the appeal. Full stop. Next para. However, upon hearing learned counsel for the parties, we find that the premise that on such premise, at best the block land and land reforms officer, Sakrail, Howrah, might have been a witness to the suit, in the event a proper defense is permitted to be taken in that regard, invoking the provisions of the 1975 Act, and further evidence is permitted at all to be adduced by the appellant. Full stop. Next para. However, in view of the frame of the suit, the cause of action is inter partes and the BL and LRO is neither a necessary nor a proper party to the suit, nor have any reliefs been sought against the BL and LRO. Full stop. Next para. Accordingly, Can 4 of 2023 is dismissed without any dismissed on contest without any orders to costs. Full stop. Next para. leave is granted to the respondents to file their affidavit in opposition, if any, to the application under Order 41 Rule 27 of the Code of Civil Procedure, that is Can 1 of 2022, by January 16, 2026. For sub reply, if any, shall be filed by January 30, 2026. For sub next para, directions for preparation of paper books.
Yes, paper books already prepared.
Leave is granted to the parties to file to mention the matter for enlistment as and when the same is ready for hearing.
Only
But Mr. Dotto, we are not putting it in our order, but we are making it very clear. If we sit when the appeal comes up before us, if there is no amendment to the pleadings, we cannot permit you to adduce evidence dehodes the pleadings. We should not have advised you against Mr. Mitra,
I am
but
really grateful.
we won't be
Only
taking
one thing, my lord.
because the litigant should not suffer.
Yes, my lord. Only the title execution is last fixed on 12th of December 2020.
Is there a stay order, stay application?
No.
That stay refused.
Only, my lord, they will not execute the degree. We have
Stay has been because they will execute the degree.
no. There is a application.
Refused.
Stay application is not there.
No, the application file that was moved, and there was an order that
dismissed or ad interim refusal.
Yes.
ad interim was not.
No.
And
That was refused.
When?
And you see,
ওটাই রেখে দিচ্ছ, ওটাই last। পুরোটাই দাও এখানে। Let us see when it was written.
I think it was presided by.
The order in which the application for additional evidence was allowed by that.
But that has been directed. Yes, let us check up. Stay application is Can 3.
Any steps in furtherance of the
Yes, Can 3
will
was
avoid
disposed
by
of.
the result of the appeal.
Yes, Can 3 was disposed of.
Some protection has to be given.
No protection
Otherwise,
can be given.
otherwise the appeal would become.
Has been refused. What can be done? We cannot sit in judgment over a coordinate bench order. Your application has been dismissed.
Disposed of.
We do not think it proper to grant stay. However, any steps in furtherance of the degree will avoid by the result of the appeal. Accordingly, Can is disposed
yes,
of.
that is
Sorry, no. Next.
But one thing, my lord.
Nothing else, Mr. Next. Yes.
Your Lordship, upon instruction, I'm submitting that the advocate and record for the respondents couldn't come to court because of some personal difficulties. Your Lordship, I'm praying for just one
What
day's
sort of
accommodation.
personal difficulty? Basking in sunshine somewhere?
Your Lordship, as per my instructions, he is unwell.
Yes, you are for the appellant.
Milord.
Move the matter.
Milord, the opposite parties have filed a Can application, Can 3 application, praying for fixing a date of hearing and disposing the matter expeditiously. So
That we are allowing right now.
no, Milord, we are not opposing the prayer.
We are allowing that.
Yes, yes.
You are not opposing, we are allowing, that's why.
Yes, Milord.
We are allowing your application. What is your name? You give your name. Not your senior's name.
Yes, ma'am.
Can 3 of 2025 is an application seeking expeditious disposal of the appeal. Full stop. You are appearing for the sole respondent. Very well. In view of appearance of the respondent, appearance of the sole respondent through her learned advocate, service of notice of the appeal is dispensed with, and the appeal be treated to be ready as regards service. Full stop. Next para. The trial court record shall be brought by special messenger at the cost of the. Let us see if they have paid. We will direct you to the appellant to put in the special messenger cost. Yes, what is your name? You will put in the special messenger cost.
Milord, Miss.
The trial court record shall be brought by special messenger at the cost of the appellants to be deposited within January 9, 2026. Full stop. The appellants shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of the arrival of the trial court records on the learned advocate on record for the appellants, who is sub liberty to mention the appeal for inclusion in the list as and when the same is ready for hearing. টিচার চলে এসছে? ওফ, বলবেন তো যখন ক্যান 3টা কেটে দাও, পুরোটা কেটে দাও। Can 3 of 2025 is an application for expeditious hearing of the appeal. Full stop. We find from the records that the trial court records have already arrived and the paper books have also been filed. Full stop. In any event, comma, since the sole respondent is represented through her learned advocate, comma, the appeal is also ready as regards service. Full stop. Accordingly, the appeal be placed in the monthly list of January 2026 for hearing. Next. Can take কিছু করলাম? Can 3 of 2020 such and such 2025 is disposed of in the light of the above observations without any orders to cost. 25. That one.
But
I appear for the appellant, my lord.
Yes.
My lord, there was an earlier direction on 25th of November granting the respondent 1 week of time to file their affidavit in opposition, which was only served upon me yesterday at 2 p.m. my lord. And I'll require at least up to 5th, only 5th.
Yes.
I'll file it within 5th.
I'm sorry, madam, I have taken a leave lordship to file it because my client was out of town. I could not affirm the time.
You file now ready. Affidavit in opposition filed to be kept on record. Full stop. Since it was served on the learned advocate for the appellants only yesterday
at 2 p.m.
comma, on the prayer of learned counsel for the appellants, comma, the time for filing reply is extended till January 9, 2026. Full stop. The matter application shall next be listed on January 12, 2026.
Much obliged.
I'm extremely grateful, my lord.
Thank you.
I'm extremely grateful.
May I wish you lordship the Merry Christmas.
Thank you and same to you.
Much obliged.
Milord, I am for the appellant, Milord. We have filed the CRAN 1 for condolation of delay and
you have removed the defects.
Yes, Milord.
Classification of appeal and all these things. We directed you on the last occasion.
Yes, Milord. But service is not completed.
No, service we did not direct. You have not. Till the caption defect is there. Only the deficit court fees has been.
Yes, Milord.
No, the memo of appeal needs to be properly classified at its head. You don't know what should be the caption of a memo. Why don't you take help of people who know?
Milord,
You are the advocate on record. Please carry out it within bracket. It's written appeal from appellate degree. You should write properly memorandum of appeal from appellate degree. Despite our previous direction, comma, the caption of the preamble, the caption of the memorandum of appeal has not yet been corrected as to the classification of the appeal. Full stop. Let such correction be affected by the learned advocate on record for the appellant immediately, comma, during the course of the day. Full stop. Yes, this is a Section 5 application.
Yes, Milord.
You are directed to serve. What happened?
Milord, we have served, but no return.
When did you send?
Milord, we have sent on the 19th, Milord.
19th?
December, Milord.
We directed you on 1st December. Why did you send on 19th?
My mother was.
All right. Learned counsel for the appellant submits that the service has not yet been effected on the respondent in respect of the applications. Accordingly, let the matter stand adjourned till after the vacation, after the upcoming Christmas vacation, and be listed in the monthly list of January 2026. The appellant shall file an affidavit of service on the returnable date. Please immediately correct the memorandum in both the judges' copy. If you can't, please ask Mr. Ghosh. He will help you.
Yes.
Unless his matter is taken up in the meeting. Yes.
Lord, I appear on behalf of the respondent.
Sir, please correct your memorandum of appeal right now.
দাঁড়াও দাঁড়াও
Let us guide him first.
My lord, here is my
This is navigation jurisdiction.
my lord, here is my affidavit in reply.
my opposition.
Yes, what is the matter? Reply means you are the petitioner. Yes, yes, Mr. Yes, Mr. Buddha. What is the matter?
My lord, the application
Eviction suit, from eviction suit.
eviction suit.
This is regarding occupation charge.
My lord,
Eviction of what? Tenant or as licensee or trespasser?
my submission is
No, you not your submission. The suit decree.
trespassers.
Your submission is that you are a tenant.
My lord, as per 56 Act.
But you failed to prove any documents. Then you don't have a case in there. You should not have granted no prior facie case.
By the at that time of argument, the learned advocate who appeared for the appellants could not place the judgment passed by your lordship.
What judgment?
My
What is the
lord,
proposition? What is the proposition laid down there?
my lord, I am covered under 56 Act because
yes,
my grandfather, who was the original tenant, he died in the year 1997. My lord, living
no,
my
they filed the suit under 2G.
2G.
Achha, so you see your government 56 Act where this fetter was
My
not there. Achha, very well. So what about the occupation charges? Let us hear them first on the occupation charges. Then we will give a reply. Yes. What is your material?
First and foremost,
What was the original rent? There was no rent.
no rent because they are trespassers. My specific case was this is a dwelling house which was partitioned.
Right.
Their grandfather or their father was a tenant.
2G.
Tenant who had surrendered. They had
Surrendered?
Yes, surrendered.
Surrender letter was.
No, my lord. My father, my predecessor has not surrendered.
No, it's their case. They're saying.
It
That was exhibited. Surrender letter.
Yes, ma'am. It was exhibited in 2006. They surrendered. That is also the recording of the trial court.
All right.
Thereafter, they say that, and what had happened was after the partition, there was a wall which was erected. They broke open. They were initially occupying a space of only 30 square feet.
Broke open, took that also, so trespasser. You have filed the suit regarding the entire.
Yes. For the space which they were occupying, which is around for 2 rooms with bath, kitchen, and everything.
So originally, their father was occupying
only 30.
So that portion is also still retained by them.
That was surrendered. That was surrendered.
But they still retain it.
Yes.
So they are trespassers by virtue of surrender regarding that, and by virtue of actual trespass by them regarding the rest.
Yes.
Entire property was the subject matter. Very well. Now, what is your evidence or what material as regards occupation charge? What is the area, location?
This is.
You have annexed the judgment and degree.
My opposition is there, man.
Your opposition annexes a judgment and degree of a different suit.
No, the same.
The same suit. Why do you annex this? Whoever has annexed asked him.
It wasn't required. The rent which is being fetched by a portion of the other portion of the house,
leave-in license,
which is at page 32, the agreement for leave-in license.
Yes.
Of an area which is slightly smaller than the one which the appellants are presently holding, and is fetching a rent of which would appear from page 34.
Don't admit rent. That will be against you in the next eviction suit which you filed against them. These licenses. Don't say rent.
No, this is
this is license fees. Otherwise, in the next suit, you will be prejudiced against these people. So 32,000 for about for a smaller premises than this. Yes, what do you say to this?
My lord, first of all, nowhere in the plain your lordship will see what is the area of my tenancy or of my occupation. First, now they are telling that I am occupying more than 700 square feet. But it is not that. Secondly, my lord, this license agreement was executed by whom your lordship see, please, Bojendra Kumar Saha. Who is he? He is the father of the respondent. It is a manufactured document. And this is made on 1st July 2025, only for the purpose of this suit, of this appeal. My lord, it cannot be. Thirdly, my lord, I am in occupation for residential purpose, and this license is for commercial purpose.
What is, according to you, what is your occupation?
My lord, another thing, it is for the first floor. The license agreement which is enclosed here, it is for the first floor, and the suit property is on the third floor. My lord, according to me, it cannot be more than rupees 3,000 at present. If I have been inducted at present, it cannot be more than 3,000 for residential purpose on a third floor building.
So, what
without
is
leave.
according to you, what is the occupation, the area in your occupation?
My lord, it may be
stated anything in a reply. You should have controverted by stating. They have stated 700.
My lord,
They
my
must
lord.
have stated 700
My lord.
here. Let us see where they have stated 700. Where have you stated 700?
They have stated 700.
Where? In which paragraph of their opposition?
In their opposition, my lord. Just give a minute.
Which it would appear at page 10. Para 3, it is hereby stated that the defendants are trespassers and unauthorized occupants with respect to the suit property, which is more or less 900 square
900.
feet, consisting of 2 bedrooms, 1 drawing cum dining, 1 kitchen, 1 toilet on the 3rd floor, and a room under the staircase on the roof above the 3rd floor.
It is for the first time stated here.
But from the extent of the number of rooms, 2 bedrooms, 1 dining cum drawing, 1 kitchen, how can it be less than 900 even?
My lord, it cannot be more than 500 square feet.
Not credible.
It is 900.
What is the extent of each room then? Area of each room?
My lord, 10 by 9. It cannot be more than 500 square feet, my lord. Which he is telling the dining and kitchen.
Dining cum drawing and kitchen.
It is impossible to say. It is impossible to say the measurement because it cannot be more than 100 square feet.
The total is 100 square feet.
No, drawing cum dining and kitchen. And 500 square feet, that is also super built.
These are submissions which are coming from the bar because the affidavit in reply states otherwise.
What does it say?
It doesn't say it's a bold denial, and then it says, in reference to the statement made in paragraph number 3 of the opposition, I deny and dispute each and every allegations contained therein. I state that the respondent never appointed an advocate commissioner or an engineer commissioner for bringing.
Do they mention the area?
No.
Then non-traverse. Evasive denial. Then Mr. Mukherjee, evasive denial. You had to state the area. And let us see whether it is for residential or other purpose. This purpose the chicken egg license. . Where does it mention in the license agreement, Sankaji, that it's for commercial purpose?
My lord, in page 4 of my opposition, my lord.
No, from the license agreement itself, it has to be seen.
From the judgment?
License agreement.
Yes.
They have annexed to the opposition.
Yes,
You
yes,
said
yes,
it's for a commercial purpose. Where
my
does
lord,
it appear?
my lord.
Yes.
Yes.
From page 33.
Yes.
Okay. But the difficulty is we have to see what that property can fetch today,
My lord.
not on what on your user.
My lord.
So if they got possession, because they have to be compensated for that, because their execution is being resisted, the principal is they are being compensated for that. So the tastefully what maximum amount they could fetch, they could give it for a commercial purpose also. All the more because it's on a first floor. But first of all, you have not stated in your reply as to your area. One. So the denial is evasive. You have boldly denied, but you don't say what is your area. Secondly, that we cannot assume in the absence of any rebuttal that this is manufactured, because we are not taking evidence. This is at the stage of affidavits. So on affidavits, we have to decide this. And lastly, your first floor and third floor, we appreciate, yes, first floor, but first floor should fetch more than the third floor.
My lord.
You are on the third floor.
My lord.
So yours should be lesser than
My
32,000,
lord.
a bit lesser, but not 3,000 as opposed to 32,000. So we'll resort to reasonable guesswork.
Considering my financial condition.
What do you do? That cannot be a consideration. That has been held by court.
I have only a tea stall.
Still, you don't have any overhead expenses, but you have income.
No, my lord.
Yes. That is very remunerative. Tea stall means you have full income, but no overhead expenses.
Not in all cases, my lord.
কত দেবেন বলুন তো, আপনি ঠিক করুন। আপনি ব্যাজমেন্ট আমি দিয়ে দিচ্ছি, অ্যামাউন্টটা আপনি ঠিক করুন। 32,000 মারা পড়ে যাবে।
It may be fixed in such a way, my lord, that I can survive and I can continue the appeal.
Live and let live concept has gone. You also know that. You know that better than us. You're doing every day in suits.
Let me kindly consider the suit is of 2015.
What do you do? Let us balance the
That I used to
occupation.
seek instruction.
No, in your affidavit, let us
Yes,
see.
in my affidavit.
What have you said? Let us see that.
I have not stated too many.
Service.
Yeah.
Their affidavit, let us see.
He only based on that leave and license agreement.
No, you are a housewife. What does your husband do? You don't find anywhere.
No, 2 sons are also there. 2 sons.
How old?
The widow.
My husband died.
How old?
2 sons. If the mother is. I'm
only
taking the
There is
guess mark.
55.
55.
Only these 2 sons.
Won't be able to help.
Way more capable.
Maybe more of
than
a
us.
liability than.
No, way more capable than us.
No, 55 son, how old? Barely, I mean, maybe adults. আমাদের ছেলে রোজগারের ক্ষেত্রে কত বুঝতে পারে সব। Of there.
My lord, it will be too much, my lord. My lord, what the agreement says. The
This is Amar Street. 15,000 is.
My lord, in the agreement, what they are relying on.
No, we have seen.
My lord, in that agreement also, this amount is high.
The present application for stay in connection with an appeal against an eviction decree has come up for hearing before us today. Full stop. Next para. affidavits in opposition and reply filed today be kept on record. So from the affidavit in opposition, it transpires that the plaintiff stroke respondent has annexed a leave and license agreement, which indicates that on July 1, 2025, a license has been granted in respect of a portion of the suit building, more specifically on the first floor thereof, which according to the respondent is less in area than the suit property, the latter having been described to be about 900 square feet. Full stop. It is submitted that as per the said license agreement, the license fee for such first floor property is rupees 32,000 per month. Full stop. As such, commensurate occupation charges are sought by the respondents to be imposed on the appellant. For some next para, learned counsel for the appellants controverts such submissions and argues that contrary to the allegations made by the respondent, the suit property is much less than 900 square feet. For some moreover, the leave and license agreement produced before this court is manufactured, which is evident from the recent origin of the same, suited for the purpose of the present application. For some next para, it is also pointed out that the leave and license has been granted for commercial purpose, whereas the appellants are using the suit property for residential purpose. For some next para, lastly, it is argued that the license has been granted in respect of a first floor flat, whereas the suit premises is situated on the third floor, for which occupation charges will be further less. For sub next para, lastly, learned counsel for the appellant submits that the appellants are a widow lady and her two sons, and the income of the family is meager. For sub as such, it is submitted that exorbitant occupation charges may not be imposed. For sub next para, insofar as the area of the suit property is concerned, in the teeth of the specific allegation in paragraph number 4 of the affidavit in opposition, to the effect that the suit property is comprised of about 900 square feet, we find in the relevant paragraph of the in paragraph 4 now. In paragraph 3 we find in the relevant paragraph of the affidavit in reply, that is paragraph 4, that such allegation has been denied in a bald manner. More importantly, the exact measurement of the property has not been stated in the affidavit in reply. The appellants have only stated that no advocate commissioner or engineer commissioner was ever appointed, which is evasive in nature. So next para. Moreover, in the absence of any rebuttal, we cannot come to a conclusion. We cannot come to a definite conclusion that the agreement for leave and license, the copy of which has been annexed to the affidavit in opposition, is manufactured, particularly in the absence of any particulars of such allegation being made. Full stop. Next para. From the however, learned counsel for the appellants has a point in arguing that the suit premises is situated on the third floor of the premises and can fetch lesser amount of occupation charges than the first floor flat, which is the subject matter of the leave and license agreement. For sub next para, insofar as the residential versus commercial usage is concerned, the argument of the appellants of current user by the appellants cannot be accepted, since it is not the present user of the suit property, but the maximum amount which can be contemporaneously fetched from such property, if let out at the current date, which is the determinant of occupation charges, stroke compensation, as condition for grant of stay. Full sub next para. Thus, since it transpires that the amount of rupees 32,000 would be exorbitant, comma, keeping in view the third floor location of the suit property and also taking into consideration the humble financial means of the appellants, comma, we cannot but resort to reasonable guesswork as to the occupation charges, as to the amount which can be fetched by way of license fees stroke rent for the suit property, comma, if let out at the current date. Full stop. In such view of the matter, comma, on a preponderance of probabilities, comma, we arrive at the finding that an amount of rupees 15,000 per month would be the appropriate occupation charges. Full stop. Hence, comma, can 1 of 2025 is disposed of by making the interim order of stay granted earlier and comma, thereby staying operation of the impugned judgment and decree as well as execution case, comma, if any levied pursuant thereto till disposal of the appeal, subject to the appellants paying occupation charges of rupees 15,000 per month. Full stop. The first of such current installments shall be paid by January 15, 2026 for the month of January 2026 and thereafter by the 15th day of each succeeding month for such current month. Full stop. The arrears of occupation charges at the aforesaid rate, comma, from the date of the impugned decree till December 2025 shall be paid. When was the decree passed?
14th January 35.
25. Shall be paid by 5 equal monthly installments,
Make it 6 installments, my lord.
comma, the first of which shall be paid by January 15, 2026 and thereafter, comma, by the 15th day of each succeeding month, comma, along with the current occupation charges as directed above. Full stop. Next para. In default of any of the above payments, comma, the stay order granted by us shall stand automatically vacated without further reference to the court. Full stop. In view of the appearance of the respondent through his learned advocate, service of notice of the appeal is dispensed with and the appeal be treated to be ready as regards service. Full stop. The trial court records have arrived.
No.
Trial court records shall be called for by special messenger at the cost of the appellant, comma, to be deposited within January 9, 2026. Full stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Full stop. Liberty to the parties to mention the appeal for enlistment as and when the same is ready for hearing.
My lord, may I humbly pray that the direction for paper books be made upon the respondents.
আচ্ছা, যেখানে appellants বলেছি
and the cost.
paper book special messenger cost to be deposited by the respondents by such and such আর ওখানটাও the respondent shall prepare একটা লাইন শুধু অ্যাড করে দিন for such purpose, comma, the notice of the arrival of the trial court record shall be served on the learned advocates for both the appellants as well as the respondent.
I'm sorry. Lordship, I did not want to bargain with the court, but Lordship would consider
They
that
won't be able to pay.
this is the Arthur Street, right in the heart of the city.
I prayed for 10,000, my lord.
We bargain among yourselves.
No, no, I will not do that.
Permit to mention.
Yes, Mr. What?
Item number 22, very urgent matter, my lord. Construction completed and they are giving.
Sell it. Let us see if you can reach it.
And
Yeah, we can't. If you can't reach it, just mention at say 4:15. 4:15 we'll take up. If you can't reach, we'll take it up at 4:15. Yes. Give a notice to the other side. Please.
My lord, may I be permitted to?
No, this is not.
My lord, memo of appeal, my lord, shop will be destroyed, demolished within 1st January, my lord, please.
What
My
is
lord,
the relief sought?
my lord,
Why are you seeking leave of court?
my lord, order has been passed by.
What leave are you seeking?
My lord, for memo of appeal, filing for memo of appeal, my
Don't
lord.
have the certificate.
Certified copy, my lord, internet copy is there, but
Leave is granted. Yes.
I'm for the petition, my lord. I
Yes, Sheriff.
have served upon them, my lord.
If they don't appear, it's very difficult.
Now the mode of service I have
You're
explained.
appealing for the other side.
But been asked by the advocate on record, well, he is out of India. So well, he seeks for time to well, fix a date after immediate after vacation or after 5th January.
If there's urgency, we'll pass an interim order. Yes.
26 is the date. My lord, kindly come to the impugned order once.
Let us see.
My lord, impugned order date is 15/12/2000.
Why have you annexed the entire copy?
Entire copy, my lord, for the kindly come to the memo of appeal, my lord. The
Don't
impugned
do
order.
this. Just file.
May I read it?
Take out the certified copy of only the order. Impugned order is 15th of December.
15th December.
You have annexed this, taken the certified copy of the application and all. Yes.
Application and all we got.
Let us read this order.
My lord, kindly today is fixed for passing of the order.
You are the mother.
Petition. I am for the mother. 12 of the Guardians and Wards Act. The case record is taken up for passing order. The petitioner has filed the temporary custody of the child, namely Nikunj Banerjee, Section 25. There had been number of litigation between the parties. Petition is also filed under Section 12 of the Guardians and Wards Act. The petitioner has stated that in the said petition that he has prayed for temporary custody of the child, namely such and such, aged about 6 years, for the purpose of his therapy, treatment, education, and other paramount development of this said minor child. The petitioner father contended the child is suffering from condition called autism spectrum disorder. As a result of this condition, his son unable to chew his food and he swallows the food directly. The petitioner father stated that admitted his son to APJ school at Salt Lake, which is equipped with the teachers qualified to take care of the children with special needs. It is specially for the children with ASD, ADHD, etc. He also enrolled his son at the institute called such and such located at Lake Town for other supporting activities like occupation therapy, which could be helpful in developing the essential skills of the person diagnosed with ASD to lead a healthy life. The petitioner had done as per advice as prescribed by the psychiatrist Dr. Anirban Rai. But when the respondent wife had admitted their child such and such in kindergarten school called Bubble Blue, situated at Newtown, Kolkata, the required treatment of his son was hampered as the respondent is residing at her parental house with their son. Hence, the petitioner has prayed for temporary custody of the child, namely such and such. Now, attempting to secure temporary custody to the child in the respect of the prayed in the direction in the court. Now, considered duly, it appears the child, for his healthy living, needs company of both the parents. The dispute between the parents need not be targeted at the child. The child may not be allowed to be used as a pawn to further the interest of the parents. As such, the court directs the respondent mother to hand over the son Nikunj Banerjee to the petitioner father in the evening from 5:30 p.m. of every Friday, and the minor child will stay with the petitioner till in evening, that is 5:30 p.m. of every Sunday. Now, I am objecting to that, my lord. So leaving the child for 2 days.
What is the age of the child?
6 years, my lord.
Son.
And having the special needs of the care.
The child has to be fed.
Yes.
Fed by the mother. The mother does
Mother
it.
to the father for 2 days. Fed by the mother.
Mother feeds the father.
No, the child. Yes, I thought I heard it played well. Sorry.
Yes, what do you say?
Not,
We'll put it after the vacation, but stay the operation.
No,
The child condition of the child should have been considered by taking reports from appropriate doctors.
So, my lord, the father also to take care of that.
Definitely, no doubt about that.
Kindly come to.
But the condition of the son,
Page
this will not be for the
20,
welfare.
my lord, why I have, my lord, taken to my custody?
No, your interest, sir, your intentions, sir, absolutely correct. So you want the son to be treated in a put in a proper school and given proper care. But this is not that order. By this order, only visitation rights has been given to you. That too throughout the weekend. The difficulty is that this child, he has to be fed by the mother. So this is an abrupt, rash order without taking a proper report from the psychiatrists and proper specialists. This could not be done. And even if this visitation is given, the father has to ensure, the father has to satisfy the court that he has the means and he has in place a system, mechanism, where the care of the child can be taken by a healthcare specialist during his visit.
Properly, my lord, I have not, my lord,
We understand. We'll, for
but
the
my lord,
time being,
kindly,
this
my
will
lord, no, my lord,
heaven
what I
will
am
not-
praying this, my lord, kindly modify this, my lord, to allow me to visit in presence of the, my lord, the mother, my lord, at least, my lord, 4 hours or 3 hours, my
See,
lord,
we are not
kindly
setting
to
aside.
modify this, either.
Please hear us. We are not setting aside the order. We are not modifying. We are not deciding the appeal. We are just staying the operation of this order for this because we have a week's holiday only. But this period will stay the operation for a limited period and hear you, and then only pass orders. We are not modifying or allowing the appeal at this point of time. How could we? We have to hear you at length and to look into all the papers. But on the face of it, this order cannot, at least because this has been given on Fridays till Sundays. So you have only 1 or 2 Fridays or Sundays in between. We are staying the operation till a particular date and putting it immediately after the vacation. You will be heard. And we will direct it to appear under the heading application only. But application, no, this is special fix. We'll admit the appeal and we'll put, there's an application also.
Yes,
Can 1.
yes.
We'll put the can in the list immediately after the vacation. The leave is granted to the learned advocate on record for the appellant to rectify the preamble of appeal by incorporating the name of the presiding judge of the trial court during the course of the day. Full stop. Next para. The appellant mother contends through counsel that the minor son of the parties, comma, who is aged about 6 years, comma, is suffering from autism spectrum disorder, CAPS. Full stop. As a result of this condition, comma, the minor is unable to chew his food by himself and has to swallow the food directly. Full stop. Next para. Under such circumstances, comma, the respondent father applied under section 12 of the Guardians and Wards Act for custody of the son, comma, on the ground that he has arranged for admission of the child to the APJ school at Salt Lake, which is equipped with teachers qualified to take care of children with special needs, and has also enrolled his son at an institute called Nanhe Care, Nanhe Care, located at Lake Town for other supporting activities like occupation therapy, etc., which would be helpful in developing the essential skills in persons diagnosed with ASD, comma, on the advice of a qualified psychiatrist. Next para. However, comma, learned counsel for the appellant mother submits that in view of the condition of the minor, comma, who is entirely dependent on being fed by the appellant mother at every meal, comma, visitation rights as given to the father by way of custody during the weekends would be directly detrimental to the welfare of the child and the appellant apprehends that the child may face serious issues in the event he is not fed properly while under the custody of the father. For some next para, learned counsel appearing for the respondent father controverts such allegations and submits that at least visitation rights ought to be given to the father. For some next para, that apart, learned counsel for the respondent father argues that the arrangements made by the father are elaborate, taking into consideration the needs for specially abled persons. For sub next para, upon hearing learned counsel, we find that although the intention of the father is definitely directed towards the welfare of his son, the manner in which abruptly visitation has been given over the weekend in respect of the child to the father might have serious adverse consequences on the child, keeping in view the condition of the child, who is utterly dependent on the mother. Who sub next para, we find prima facie that the said visitation order was would not inure to the benefit of the child, at least without taking appropriate reports from proper medical experts, stroke psychiatrists, and stroke or psychologists as to what could be the modalities to be adopted by the father, by the apparent father, even if visitation is granted, and without satisfaction on the count that the appellant father has the infrastructure in place to give proper care to the child during the child's stay at the father's residence over the weekend. We do not find anything and that in that regard having been recorded in the impugned order, thus, a prima facie strong case for hearing the appeal on merits has been made out. Accordingly, the operation of the impugned order bearing order number 7 dated December 15, 2025, passed by the learned additional district judge.
Additional district, 7th court.
7th court at Barasat district, North 24 Parganas is miscellaneous case number 99 of 2025. Within bracket Act Roman 8 bracket close is stayed till January 16, 2026 or until further order, whichever is earlier, full stop. The appeal is admitted and shall be heard on the above grounds and the other grounds taken in the memorandum of appeal. For sub next para, the application bearing Can 1 of 2025 shall be listed under the heading Specially Fixed Matters on January 7, 2020, January 6, 2026 for passing further orders. It will be specially fixed at the top of the list, January 6th. Please insert the name of the judge.
Instead of at Barasat, I've been corrected and it is Barasat, only Barasat.
Item number 13.
My lord, I appear for the appellant wife, my lord. May I just have
Lordship,
your lordship's 2 minutes of time to apprise of the facts in the meantime, my lord?
Your Lordship,
The microphone so that he can hear you.
I'm appearing on behalf of the respondent husband. I've been instructed by my learned senior, Shri Dibendra Narayan Roy, to kindly pray for pray for an adjournment and maybe
May I just take your
grant a
lordship's
date.
1 minute, my lord?
Before that, we'll have to hear the appellant. Yes.
Yes, my lord. On the last occasion, my lord passed an order thereby directing the husband from disturbing my electricity connection at the matrimonial house. My lord will find that from the order dated 17th of November, para 12, internal page 4.
What about the mediation? Mediation has failed.
That is what I'm saying. Mediation has failed. In the meantime, 23rd January is the date fixed before the Supreme Court, where both the parties have been directed to appear there physically.
Both parties to appear physically?
Appear physically before the Supreme
23rd
Court. January.
So where will we keep it after that?
After that, let the interim order continue till that, my lord.
We'll do that. An adjournment is sought on behalf of the respondent, full stop learned counsel, for the appellant submits that the attempts at mediation between the parties have failed. Full stop. However, the parties have been directed to appear personally before the Honorable the Supreme Court in a connected matter on January 23, 2026. Full stop. Next para. Accordingly, to await the outcome of the proceeding before the Honorable Supreme Court, let the matter stand adjourned till February 3, 2026, when it will be listed next under the same heading.
My lord, may I just hand over the order of the Supreme Court and my reply?
Yes. Reply, where is the reply? You have
They
filed
were
your
supposed
opposition. No, they have not yet filed their opposition. How can we
But
get
they have
fixed?
served it upon me. If they don't file it, my lord,
A copy of the order, a server copy of the order of the Honorable Supreme Court filed today in court be kept on record. First of the time for filing affidavits is extended till the next returnable date.
My lord, one thing, my lord, item number 10, my lord, was pleased to fix it on 12th of January. That is a holiday, my lord.
13th, you have made it 13th. In your order, we
Very
make it
well.
13th.
I'm grateful. I'm
Some of
grateful,
the
my
orders
lord.
we have directed 12th, that will be 13th.
I'm grateful, my lord. I'm extremely grateful.
Item number 14.
I am for that.
Yes, yes, sir.
Lord, in this matter, Mr. Rohan Banerjee is leading the junior, who is my sister. Mr. Rohan Banerjee left the court.
So it has ultimately fallen on the brother to protect the sister.
My junior is my sister. He is ill. She did not come to court today.
Yes,
Mr. Rohan Banerjee was leading.
Actually, Lord, at the
Affidavit in opposition was to be filed. What about that? Your sister should.
they have filed. They have filed.
They have given a copy. Have you filed? Just
already served.
No, you have to
Oh,
file
yeah.
it in court. Just file it formally. Yes. Reply also, Mr. Bhattacharya, file will adjourn it till after the vacation. Affidavits in opposition and reply filed today be kept on record. Full stop. On the prayer of the respondents, the matter is adjourned till after the upcoming Christmas vacation. Thank you.
Much obliged.
It is
For item number 15, I'm for the appellant, my lord.
Yes, right.
My lord, I'm led by Mr. Rahul Kormokar, my lord. I'm praying for an adjournment, my lord.
Out of the list.
My lord,
Start moving the matter.
my lord, this is an appeal, my lord.
Have you
Challenging.
directed service of copy in this matter?
Yes, my lord. Yes, my lord.
What about the affidavit of service? That you have to file at least.
My lord, it is there, my lord. In before the Lojima court, I have filed the affidavit of service, my lord. The sole respondent has been served.
Lojima court?
Yes, my lord.
We have directed service you have filed before the Lojima court. What do you mean?
My lord, the Lojima court directed me to serve the sole respondent, and my lord, I have served the sole respondent.
How can the Lojima court direct you to file? What are you saying?
My lord, this is item number 15. Ramkrishna Mondal versus
Yes,
Tanushree Mondal.
Tanushree.
Yes, my
Lojima
lord.
court has directed filing of
Yes.
an application which is to be heard before a court.
My lord, the Lojima court directed me to serve the respondent, my lord. I have done that.
Lojima court cannot direct you to serve. Lojima court has recorded that notice upon sole respondent has already been served. That can be recorded by the Lojima, the registrar. So you have already served.
Yes, my lord. Kindly seize the order of the Lojima court, my lord. It is there.
Anyway, but what is the matter about?
My lord, this is my
You
lord,
are
I
for the
have-
other side. Why are you making such a face? Take your seat. Yes. Yes, please, ma'am.
my lord, this is an order passed by the ADJ First Track Court, Bakuda, my lord. The
You have
order,
asked for filing preparation of paper books and all these things.
yes, my lord.
You
For
are
the
allowing the application. We are allowing your application.
All right, my lord.
Affidavit of service filed to be kept on record. Full stop. It transpires that none appears for the respondent despite service. Full stop. In view of the innocuous nature of the prayer made in the application, comma, we deem it unnecessary to direct further service. Full stop. Next para. This is a matrimonial matter.
Yes, my lord.
since this is a since the appeal arises out of a matrimonial suit, comma, there is implicit urgency in the matter. So accordingly, can 1 of 2025 is allowed, thereby directing the appellant to put in postal costs and requisites for service of notice of the appeal on the respondent, comma, within January 9, 2026. Full stop, next para. The trial court record shall be brought by special messenger, comma, at the cost of the appellants, comma, also to be deposited within January 9, 2026. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop, liberty to the parties to mention the appeal for enlistment as and when the same is ready for hearing. Thank you.
Deeply obliged.
Thank you. You are the advocate on record, Ms. Bandyopadhyay?
Yes, my lord. I'm the advocate on record.
Yes, Tannistha Bandyopadhyay. Now to review. Next.
Deeply obliged, my lord.
Lordship, in item number 16, I am led by Mr. On Banerjee on behalf of the respondents, Lordship.
What is the matter about?
My lord, a very short matter. My lord, I filed an appeal against the revocation of probate, and in this appeal, my lord, I filed 2 applications, one for temporary injunction, another for mandatory injunction, because they have taken me out, thrown me out from my position, as well as put the padlock on my door and also installed CCTV. For that, I filed a mandatory injunction and temporary injunction filed because they are now conspiring to sell out the property. That is why I filed a temporary injunction. My lord, on 19th May, my lord, your lordship took up this matter and granted an order of status quo. My lord, status quo continued, but unfortunately, around 28th October, this matter came up before your lordship. But unfortunately, due to my personal reason, I could not appear. Your lordship has been pleased to vacate the status quo order. I pray, my lord, because it can be sold out at any point of time. My lord, your lordship has been pleased to grant the status quo. My lord, he is coming from legal aid, my lord. Person is very much poor. My lord, kindly.
We did it on the premise of a coordinate bench direction. There was a direction in our order dated August October 28.
Yes, my lord, I have explained.
We recorded that the learned coordinate bench recorded that in the event the appellant, that is you, is not represented on the adjourned date, the bench may vacate the interim order and dismiss the appeal.
Yes, my lord.
This was an order of the bench.
I have explained, my lord, because this person is very much poor. His driver, my lord, he could not contact with me. So
that's why you did not appear in a legal aid matter.
I appeared in the month of August. In the middle month, I appeared in the August.
In legal aid matters, it's all the more the responsibility of the council to appear.
My lord, I beg your lordship's kind pardon, my lord.
Because they don't have they are marginalized. That's why you are all the more responsible for appearing. Why didn't you appear?
My lord, their lack of instruction, my lord, I could not appear.
Lack of instruction and in a legal aid matter.
I beg your lordship's pardon, my lord. Your lordship.
In the same breath, you are saying it's a legal aid matter, and you are not appearing for lack of why you should be dependent from the legal aid.
No, my lord. On 25th August, I appeared, my lord. I paid for accommodation.
You are saying lack of instruction in a matter, legal aid matter.
No, actually, my lord, this was I had to take some affidavit in opposition. Reply has to be filed.
Why didn't you appear? You could have appeared and said that.
My lord,
lack of instruction is not an excuse not to appear.
I'm submitting. I could not contact, my lord. There is a.
Let us see the explanation. We'll see your explanation.
Like I said it in paragraph 6, my lord.
May I just pray for a day's accommodation?
No.
Lordship? Because the thing is, the lordship, the brief is
maybe
gone with Mr. Banerjee, lordship.
Should have a copy with you. You should have given a copy to you. These matters, legal aid matters, we won't hold up. This arises from what sort of a suit?
Milord?
What sort of a suit does it arise?
That was a probate proceeding.
Oh, you said probate. Sorry.
Probate proceeding. Probate has been revoked, lordship, by the
district
court. They have come up before this honorable court challenging the revocation of the probate.
They were enjoying an injunction that was vacated.
That was vacated, lordship. They have obtained the injunction and then they have started to not appear in this matter. In spite of that, we are repeatedly appearing, lordship. And even then, lordship, there are no prima facie case could have been established, lordship. We have filed as per your lordship's direction, we have filed our affidavit in opposition to the previous applications, lordship.
We'll allow the recall and keep the stay application, injunction application after the vacation.
Yes,
the lordship may kindly allow the recall
within that time.
But your lordship may kindly specify that the order that has been subsisting, the order is still disposal of the application. The interim order that your lordships has granted on the.
It will again be revived to disposal of the application.
I'm just beseeching your lordship, if your lordship may kindly modify that order to a limited extent, lordship.
What?
Not
No, sorry. Definitely not.
because your lordship, this matter, no prima facie case could have been has been established by the petitioners. In our case, we have obtained
Said
a
that at the final hearing of the injunction application.
Milord.
The present application bearing can 6 of 2025 is one for recalling the order dated October 28, 2025, whereby the interim order of status quo granted earlier was vacated. Full stop. Next para. Learned counsel for the appellant submits that the present matter pertains to the legal aid services. Full stop. The appellant, comma, it has been stated in paragraph number 6 of the application, comma, it comes from the marginalized sections of society, comma, being a poor man, within double inverted poor man, double inverted close, and is engaged in his daily routine and could not contact his advocate in time. Full stop. It is also stated therein that due to lack of instruction, comma, the learned advocate could not appear during the relevant period. Full stop. Furthermore, comma, subsequently, the matter came up on October 28, 2025, when the learned advocate was on legs before some other court. So, moreover, comma, in view of the father of the learned advocate for the appellant petitioner having met with a fatal accident.
But he was he went to the.
How is he now?
Quite
Do you know the meaning of fatal?
But he had head injury. He had 7.
Fatal means something else. Fatal means which leads to death.
In
You use this for your father.
But
Has a serious accident 2 days before the 2 days therein before, for which the learned advocate had to leave court early. Full stop. Next para. Upon hearing learned counsel for the parties, comma, we are satisfied that sufficient explanation for the absence of the appellant on the relevant date has been made out. Full stop. Accordingly, can 6 of 2025 is allowed on contest, thereby recalling the order dated October 28, 2025, insofar as the interim order granted earlier was vacated, and hereby restored the said interim order till disposal of the application for injunction, that is, what was the injunction?
Can 4. Injunction order was passed in Can 4.
Can 4 and Can 5.
Can 5 also?
Yes.
Can 4 is for temporary
Applications, that is, Can 4 and Can 4 of 2025 and Can 5 of 2025. Full stop. Let the remaining pending applications, comma, including Can 4 of 2025 and Can 5 of 2025, be listed in the monthly list of January 2026.
Lordship may just pay only one thing. Lordship may
Yes.
kindly give this matter some precedence.
No.
Your Lordship.
Call on the list.
Great.
Item number 17.
এটা কি মেনশন করেছিল? মিডিয়েশনে গেছিল, কবে মেনশন করেছে? ডেট টেট দেয়নি। ওরা না দিলে আপনি লিখে দেবেন ডেট, ওরা না দিলে আপনি লিখে দেবেন ডেট। আমাদের বোঝা যাচ্ছে না, আমরা ডিরেকশন দিচ্ছি, মিডিয়েশনে পাঠিয়েছিলাম। The matter has come up on the mentioning, আর হয়ে মেনশন করছে সেটাও তো বোঝা যাচ্ছে। On being mentioned, full stop, next para. However, comma, from the mentioning slip, it is not clear as to which party mentioned the matter for inclusion in the list. Full stop. Even at the time of call, none appears for the parties. By an order dated April 28, 2025, the matter was sent for mediation. Full stop. The office shall accordingly furnish a report as to the outcome of such mediation, enclosing the report, if any of the mediators. Full stop. The matter shall next be listed under the heading to be mentioned on January 12, 2026 for furnishing of such report.
I'm for the appeal, my lord.
Yes.
My lord, this is analogous matter to another appeal, my lord, where his lordship has passed an interim order. If your lordship kindly
Deficit
come
court
to
fee? What about deficit court fee?
my lord, if your lordship kindly come to Can 1, your lordship have passed, my lord, it's analogous matter.
Let
My
us see
lordship
the
has
facts first.
observed that, my lord,
Observed what?
of the two cases, two appeals has been filed, case and counter claim, where one appeal has been preferred. For that, this appeal has been preferred after finding that, my lord, and a lot liberty also there.
No, you have to put in
And
the court fees for that.
my lord, this is application is filed before your lordship for exemption of the court fees because my lord already 50,000 paid in the trial court, also 50,000 paid in the appeal. There is the first one. Then my lord, for my lord exemption for filing the court fees. And
Why
also
two
an
appeals?
application.
What was done by the
My lord,
two suits were decided?
Case and counter claim. Suit and counter claim, my lord. And also application filed for my lord exemption of file the certified copy and all injunction
Certified
application.
copy will definitely exempt.
And there is a delay of my lord 57 days, my lord. 4 applications there. If you
Which is which? Let us see. Take one by one. Can 4 is section 5.
Lordship. Can 1, my lord, the
You have to serve copies of the application.
Yes, yes.
The copy has been served.
Yes, Lordship.
They have received.
Lordship.
And this, what is the delay?
57 days delay, my lord.
Extremely sorry. What is the reason?
My lord, after my lord,
Very well understood. Despite service, none appears for the respondents whose every service filed to be kept on record. Full stop. From the application for condonation of delay, we find that there was certain misunderstanding as to whether one or two appeals have to be filed, in view of the suit having been disposed of. Suit was dismissed. Your suit was dismissed. The suit of the, in view of the suit of the appellants having been dismissed, and simultaneously the counter claim of the defendants stroke respondents having been allowed. Full stop. During arguments before this court, it transpired that a second first appeal has to be filed against the counterclaim, upon which the present appeal has been preferred. Full stop. We find such explanation plausible and bona fide, and as such, sufficient grounds have been made out for the delay in preferring the instant appeal. Accordingly, Can 4 of 2025 is allowed, thereby condoning the delay in preferring FAT 219 of 2025. Full stop. Next para. Which appropriate order is certified copy? Very well. Since the certified copies of the judgment and degree have already been annexed with the appeal arising out of the main decree passed in the suit, that is, what is the other FAT number?
My lord,
mention at least in this.
In the injunction application, it is mentioned, my lord.
That is
it
FAT number 92.
92.
That is FAT 92 of 2025, filing of certified copies in connection with the present memorandum of appeal is dispensed with. Full stop. Can 3 of 2025 is disposed of accordingly. Full stop. Learned counsel for the plaintiff's appellants, in support of Can 2 of 2025, which is an application for exemption of depositing court fees, submits that maximum court fees of rupees 50,000 has already been deposited with regard to FAT 92 of 2025, comma, which is the other appeal preferred against the decree dismissing the title suit itself, and as such, since the present appeal arises out of the counterclaim being decreed, comma, the further court fees be dispensed with. Full stop. We find substance in such contention. Full stop. Accordingly, can 2 of 2025 is allowed, comma, thereby exempting the appellants from depositing further court fees in connection with FAT 219 of 2025. Full stop. Injunction. What is your prima facie case? What is the suit for?
My lord, if you lordship kindly see the
suit for declaration of title and recovery of possession.
Lordship.
On what ground? They are trespassers.
No, they wanted to purchase that. Subsequently, some amount has been paid, but not the entire amount has been paid. So, my lord,
they were put in possession in terms of that agreement.
Yes.
You are the owner.
Yes.
Now, what is their defense?
Their defense, they stated that they have paid considerable amount of the consideration amount.
Was there counterclaim for what? Declaration or specific performance?
Specific performance.
That was decreed. What remains in his suit?
No, my lord, if your lordship carries that, if your lordship has find your lordship goes to your lordship's order, my lord.
What did you say?
Lordship found that that amount has not been paid and they has not tendered the amount, rest of the amount. So, my lord, their intention was not clear, my lord. What is my case is that.
Let us see our order, which date of?
Can 1, my lord, at page answer A.
In a different matter?
That matter, my lord, 92, FAT 92.
Let us see. So you are already enjoying an injunction in that appeal. Why further injunction? With granted injunction, didn't we grant injunction?
Interim order is there.
Stay of operation of the judgment and decree.
Yes. And here is injunction for not to change the nature and character.
You have served copy of this application also?
All, my lord.
You have checked up good service?
Lordship. Delivered. Yes, my lord, both delivered.
Delivered where? To the SO?
No, my lord. By name, N. Chandra Kumar.
Hand up.
And addressee. 2 brothers.
Can 1 of 2025 is an application for injunction pushed up in our order dated May 6, 2025, passed in FAT 92 of 2025, comma, that is the connected appeal, comma. This court had observed that arguable issues have been raised in the appeal, comma, including the question as to whether time was the essence of the contract and the respondents tendered part consideration within time, as well as whether the agreement in question, comma, being unregistered and insufficiently stamped, comma, could be relied on by the learned trial judge while declaring the counterclaim. Full stop. Next para. Thus, comma, a prima facie case for grant of injunction is made out. Full stop. Accordingly, the respondents and or their men and agents shall remain restrained by an order of injunction from. You have asked for change of nature, character.
And also damage. They are creating some damages. To stop
From
damaging and
changing the nature and character of the suit property and or damaging the same in any manner during pendency of the appeal. Full stop. Lastly, there will be no arrest to costs. Full stop. The appellants shall put in postal costs and requisites for service of notice of the appeal on the respondents within January 9, 2026. Full stop. The trial court record shall be brought by special messenger at
already
the directions are there.
Yes. And I also paid, my lord.
Postal costs also.
Special messenger cost also get there.
Very well. তাহলে এই লাস্টের পোর্শনটা দরকার নেই, নো অ্যাড্রেস টু কস্ট, liberty to the parties to mention the appeal as and when for enlistment as and when the same is ready for hearing.
Lordship, grateful, Lordship. Grateful, Lordship.
Thank you.
Item number 19.
I'm for the appellant, my lord.
Yes.
The ex parte order in the partition suit, my lord.
Section 5 is there.
Section 5 is there.
You are for the other
90
side.
days delay, my lord.
How much?
90 days delays. The reason for the delay, my lord, as it is demonstrated in the application is, my lord, the appellants were not informed about this order due to the laches on the part of the learned advocate.
Serve notice on that advocate.
My lord,
Since allegations have been leveled in the application for condonation against the erstwhile advocate of the appellants, a notice as well as a copy of the condonation application shall be served on the said erstwhile advocates, intimating that the applications shall be listed for hearing next in the monthly list of January 2026, on which date an affidavit of service to that effect shall be filed by the appellants.
Grateful.
Grateful. Yes. Thank you. The habit. Yes. You are for the respondent.
This is my affidavit.
You move the application also since they are not here.
Yes, my lord.
You move their application opposite and you can pass the order also. No, but reply we have to give them some time.
Because I should not serve, I was not there, I could not serve to them, I was
Not serve
yes,
the opposition.
I could not serve,
Why two opposition?
One with regard to one with regard to delay application,
Other?
and can two, an application for passing appropriate order.
The affidavits of service filed in connection with can 1 of 2025 and can 2 of 2025, filed today, be kept on record, full stop. None appears for the appellant at the time of call, full stop. Next para. However, learned counsel for the respondent submits in his usual fairness that copies of the affidavits in opposition could not be served on the learned advocate for the appellant. Full stop. Accordingly, the respondent is directed to serve copies of the affidavits filed today on the learned advocate for the appellant by January 9, 2025 and file a receipt in 2026 and file a receipt in that regard on the returnable date. Full stop. The matter application shall next be listed on January 19, 2026. Full stop. The time for filing reply is extended till the returnable date. Grateful. You try to give a copy by today itself.
I'll
Number 21.
21, Your Lordship, appear for the respondent.
Yes.
I'm on caveat, Your Lordship. I was seeking for a direction for service of a copy of the application.
None appears for the appellant at the time of call. Full stop. Learned counsel for the appearing for the caveator's respondent submits that no copy of the application has been served on the said learned advocate. Full stop. Accordingly, the appellant is directed to serve a copy of the application on the learned advocate for the caveator stroke respondents. You are appearing in this matter?
No, next matter.
Achha. By January 9, 2026, full stop, the matter application shall next be listed for hearing on January 12, 2026. Full stop. A server copy of this order shall be served by the learned advocate for the caveator's respondents on his counterpart for the appellants by January 5, 2026.
Yes.
So that they can comply. So, Mr. Bhattacharya, you did not have to wait till 4.
No.
That's why you told you to wait.
As a service, my lord, I have served all the copies, my lord.
I'm for the respondent.
You are for the respondent.
My lord.
Yes.
First one, it was my delay of 5 days, my lord.
1 second, Mr. Bhattacharya, FMT, yes, taken care of. Yes.
Due to my eye operation.
Your own?
My operation, I could not practically blind. Thereafter, my lord, still I have not regained my vision. However, I have stated my on oath from paragraph page 4.
What is the delay? Amount?
5 days only.
In so far discipline, I'm not opposing, my lord.
How dare you?
I allow that, my lord.
In view of sufficient explanation for the delay having been made out, Can 1 of 2025 is allowed, thereby condoning the delay in preferring FAT 235 of 2025. Now the main,
Now the main case.
which he will oppose.
Yes, my lord. Main case, my lord.
That I will oppose.
What happened,
Yes,
my lord?
yes.
What happened, my lord?
One
In the-
injunction application, one for stay. What the appeal arises out of what suit?
Arrangement appeal matters against the my client is a plaintiff in the court below. My lord,
Suit for?
subject of suit is, my lord, that is Benama transaction.
No, it's sought for a declaration.
Suit for declaration, partition, and injunction.
Declaration that some deed is void.
Is it no? The
Should be.
Benama transaction was void, and all the parties are the co-sharers, and because, my lord, the purchase has been made by the father of all the parties and by from his own business, and the defendant number 2, the mother of all the parties, was, my lord, unemployed lady at that time, my lord, but he was his father was a village barber. His their defendant number 1 stated that out of his freehold during 1955, the price was the land was 6,500 plus construction cost. My lord, it was not possible for the barber, village barber, to give dowry or the ornament at the time of his marriage, my lord. That's the whole thing, my lord.
No, but you have not asked for a declaration. You have sought that the gift deeds are void.
Yes.
Gift deeds executed by the mother.
Yes,
But
mother.
you did not say that
Mother, my lord.
Benami was not.
My mother was not examined during her during the case, my lord, because she died during the pendency of the case, my lord. But she had contested the suit by filing the written statement. My appeal is there.
He has filed written statement, my
Yes,
lord.
yes.
He had.
But in
After she died, my lord.
no, but to support his written statement as per law of plaintiff, my lord, he must be
The suit
examined.
has
He
been
must be examined.
dismissed. Suit has been dismissed.
No. Yes, suit is dismissed. Against that, my lord, we have come before the
Why
lord.
was the suit dismissed? You could not prove your case. That is the finding.
My lord, no.
Finding of the court is that you could not prove your case.
Yes, that is the case, my lord.
That is the case, my
That
lord.
is the case.
The entire thing was Benami transaction, and all the parties are on the defendants are the plaintiffs are the parties, including some defendants.
During pendency of this is the first appeal. You have to hear it on merits. So why shouldn't there be injunction from at
And
least
my lord,
transfer?
and also, my lord,
Kindly hear me then.
and
That even, my lord.
and stay of the all the
Stay there is no scope. Suit
no,
has been dismissed.
what happened, my lord? Injunction is one because it has been the plaintiff number, defendant number 1, the brother of all the parties, had already given the land to the promoter, and promoter has already started construction. Only construction, forcefully
No, there is no
construction.
question of, we are saying there is no question of
Yes.
stay because your suit has been dismissed, Mr. Bhattacharya. It's a negative, I mean,
No,
nothing positive has
yes,
been.
but because
Regarding injunction, we are
some status quo may be given until some for a particular date. My
There is ongoing construction.
completed, but they are trying it just constantly construct by the contractor.
Construction has
by
been
the
completed, Mr. Bhattacharya. Regarding construction, we won't grant any, but regarding transfer, creating
Transfer,
third-party interest,
yes,
we are considering.
I'm on
Subject to
that
hearing.
I am on that point.
Let us hear your learned friend.
I'm on that point.
What about transfer?
Sometime in the year 19.
If you develop and transfer in favor of third parties, the appeal will be rendered infructuous. If you develop and transfer, the appeal will be rendered transfer.
But try to appreciate what
Construction, we are not granting any injunction.
that building, that land was purchased by her own Sri Dharma.
No, that is in dispute in the appeal.
What is saying that is different aspect of the matter.
No, no, that is the that is only his case.
Deed of gift was executed in favor of the of his son.
Yes.
Understood.
There are 6 siblings, my lord. Out of 6, 1 who is defendant number 1, respondent number 1, my lord. That was gifted by my mother to me, my lord.
Even number 2.
You are for respondent number 1.
Yes, my lord.
You are only for respondent number 1.
All respondents. All respondents.
All respondents. But it was given to respondent number 1.
Yes, my lord.
But the other respondents, the defendants respondents are supporting you.
Yes, my lord.
Very good.
They are sister.
Sisters. You are the brother.
I'm the brother, my lord. We are 2 brothers, my lord. One
And
brother never looked after
the plaintiff's appellants are the other siblings.
Yes, my lord.
Obviously, they will have a dispute. But don't transfer in favor of third party.
That is my
brother. He never looked after the family. Never looked at
Please, we'll have to consider the evidence.
He left his home 20 years ago, my lord. Decided somewhere else, married, without any consent of the parents. Thereafter,
We'll decide that in the appeal. Can 2 of 2025 is an application for injunction. Full stop. Next para. Learned senior counsel appearing for the appellant submits that the respondents are trying to transfer, alienate and encumber the suit property in favor of third parties and are constructing and are raising constructions thereupon by changing the nature and character of the suit property. Full stop. It is also alleged that attempts are being made for the property to be transferred in favor of third parties. Full stop. Next para. Learned counsel appearing for the respondents controverts such allegations and submits that construction
it's complete,
of
my
a
lord. Complete.
either you pass the order or we pass the order.
No, I'm sorry, my
Then
lord.
we
that's
make the submissions and we pass the
no,
order.
no, my lord. In order to
Learned counsel for the respondents submits. Learned counsel for the respondents controverts such submissions and submits that construction has already been completed.
yes, my lord.
Full stop. Next para. Upon hearing learned counsel for the parties, we are of the opinion that since construction has substantially been completed, no injunction ought to be passed with regard to such aspect of the matter. Full stop. However, since arguable questions have been raised in the appeal, particularly relating to whether the funds from which the property was purchased by the donor stroke mother belonged to her Stridhon or was Benami or such transfer was a Benami transaction, in the event third party interests are created during pendency of the appeal, the appeal might be rendered infructuous. Full stop. Thus, a prima facie case for grant of injunction in that regard has been made out. Full stop. Also, the balance of convenience and inconvenience is in favor of grant of injunction, and the appellants may suffer from irreparable injury in the event the injunction is refused. Full stop. Thus, can 2 of 2025 is disposed of by restraining both parties from transferring, alienating, encumbering and or creating any third party interest in respect of the suit property till disposal of the appeal. Full stop. You said you're for all the respondents, so we are dispensing with. Since all the respondents are represented through their learned advocate, service of notice of appeal on the respondents is dispensed with, and the appeal be treated to be ready as regards service. Full stop. The trial court record shall be brought by special messenger at the cost of the appellants to be deposited by within January 9, 2026. Full stop. Next para. The appellants shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Full stop. Liberty to the parties to mention the appeal for enlistment as and when the same is ready for hearing. No address to cost. প্রথমে affidavit of service filed to be kept. Thank you.
एक कॉपी पाবে তো एक कॉपी সার্ভার কপি
Item number 23.
Lordship, I appear for the appellant. In your last direction of your lordship has directed to serve the other party. Your lordship, the affidavit of service is completed from our end, but the persons are not found residing in that address.
What is the endorsement in there? Not found.
Your lordship.
Then you have to ascertain the address and serve.
Your lordship, for several respondents, the alternate address is not provided. Kindly pass an order to serve the lower court advocate appearing for the other.
He has lost. He's no longer he doesn't have the power to appear. You have to ascertain the correct addresses. You are the plaintiff.
Your lordship.
Did they appear in the court below?
Your lordship, they have.
At the same address?
Your lordship.
Take instruction. Please come back. Learned counsel for your file your affidavit of service. The affidavit of service filed to be kept on record. Full of learned counsel for the appellant submits that although service has been effected on the respondents at the address as given in the plaint of the suit from which the present appeal arises, some of the postal articles have returned with the endorsement that the addresses are not found. Full stop. Next para. Learned counsel for the appellant is requested to ascertain as to whether the parties, whether the unserved respondents had contested the suit and stroke or entered appearance in the suit from the addresses as given in the plaint. Full stop. For such purpose, comma, the matter is adjourned and shall next be listed in the monthly list of January 2026. Full stop. Please apprise us on the next date whether they had entered appearance or contested the suit from those addresses. If we find that, then we will say they are deliberately avoiding service. Right?
Grateful, Your Lordship.
Thank you.
I appear for the appellants.
Yes, Mr. Bhagat.
My lord, he is partially served.
Partial service? Half of the copy was served?
No, no.
Some of them were
Some
served?
of them have been served, my lord.
Yes.
And others report is yet to come.
So we'll wait for some time.
Yes, sir. May I file the
affidavits of service filed to be kept on record. Full stop. Learned counsel for the appellants, comma, in his usual fairness, comma, points out that some of the respondents have not yet been served. Full stop. Accordingly, let the matter stand adjourned till after the upcoming Christmas vacation for the purpose of ascertaining service. Thank you. Vishwaranjan Bhagat. Vishwaranjan Bhagat K. Vishwaranjan Bhagat K.
25, I appear for the appellants.
Yes.
My lord, there is a delay of 14 days, which was reported, my lord.
Served.
My lord, I had served, my lord, I have checked up. They have received it. And with regard to this matter coming before this honorable court, my lord, it was running in the list of their lordships. And it has thereafter, the determination has come to your
that you are not
Yes,
responsible
yes.
for that.
It was served.
You need not serve further fresh notice of that. But you have served copies of the
Yes, 31 respondents, my lord, I have checked up, my lord. They are, my lord.
So what is this appropriate
My lord,
application?
my lord, this
story?
application, my lord, seeking
Section 5 has to be taken.
yes, section 5 is there.
এই এগুলো সুতোগুলো এটা আগে নেবো ধরুন এটা এই সুতোগুলোর সাথে একটা কাঁচি নিন না কাঁচি কেটে দিন পরে আবার লাগে আগে কন্ডোনেশনটা শুনতে হবে তো ওই জন্য নাম্বারিংটা যাই হোক ঠিক yes what is the delay?
The delay of 14 days.
Reason?
My lord, reason, my lord, we had filed this appeal on the conspectus that we are filing it within the period. After it was filed, my lord, it was assessed by the department, my lord, paragraph 3.
Despite service, none appears for the respondents at the time of call. Full stop. Affidavits of service filed to be kept on record. Affidavit of service, actor. We find from the condonation application that in view of miscalculation in the limitation period, comma, the appeal was filed after a delay of about 14 days. Full stop. We consider the same to be sufficient explanation for the delay. Full stop. Accordingly, can 2 of 2025 is allowed, comma, thereby condoning the delay in preferring FAT 257 of 2025. Full stop. The said appeal be deemed to stand registered and admitted accordingly. Next, yes, what is the
and this application is, my lord, with regard to and the suit is for partition.
You
plaintiff,
yes.
Plaintiff suit got dismissed. The question of dismissal was that the it was not an inheritable property. It was property by owned by purchase. That purchases were said to be
the plaintiff's
yes,
purchase.
yes. Our predecessors and us are also the father and mother of the plaintiffs, present plaintiff,
You purchase jointly or only father mother?
No, separate with separate deeds. There are two deeds.
Some portions are purchased by father,
Yes.
some mother, some
yes,
you.
Yes. Now what has happened is in the
Father are still alive. The
no,
parents?
no.
So you have inherited their portions.
Yes.
Also.
No, I stand corrected, my lord. Mother is still alive. Appellant number 1.
Father's portion also
Yes.
you have inherited.
Yes. My lord, the contentions of the learned trial court was that the deeds by which we had purchased were not correct in the conspectus, as the vendors were not the owners of the property. Those vendors.
What was the premise of that finding?
Because there is one deed which suggests that a minor's share were transferred to the appellant when the proper application and proper permissions were not taken for the authority. The minor share was transferred by the mother, and subsequently what has happened is during the pendency of the suit, when the minor had grown up to be an adult, she had again made a deed of conveyance in favor of the appellants. which were not considered. It is also one of my grounds.
Apart from that, any other ground on which?
My lord, one other grounds is, my lord, the recitals that were followed while passing this order, probably in my humble submissions, was not in a proper perspective. It had to be, my lord, the calculations which were made in respect of the legal heirs. We say that we have made the legal heirs to be 3 legal heirs of one of the vendors. The defendants and the respondents here had come up with their submissions that those persons were not only the legal heirs. There were some other legal heirs also.
What was the answer to that?
Answer was found to be true. Their answer was found to be true by the learned trial court.
What is your reply to that?
My lord, we say in the being the appellants that
their suit is bad for non-joinder at least.
Yes, they say that, and we say that, my lord, that non-joinder of parties cannot be a ground for, my lord, dismissal of a partition suit. And we are in possession.
Can be a ground, but you should have been given an opportunity.
Yes, we are in possession of the property. We enjoyed the interim order till the date of the judgment.
The present appeal arises out of a partition suit. Footstep next para. The suit was dismissed by the learned trial judge, prompting the present appeal. Footstep next para. Learned counsel for the appellant submits that the learned trial judge proceeded to dismiss the suit inter alia on the premise that the share of a minor was one of the subject matters of the transfers in favor of the appellants and their predecessors. However, it is submitted that upon attaining majority, the said minor had also transferred again afresh her share in favor of the appellants. Next para. Secondly, the learned trial judge, it is submitted, on a misappreciation of the recitals of the deeds, came to the conclusion that the suit was bad for non-joinder of other legal heirs who are also co-owners. However, it is submitted that apart from such perception being erroneous, since the suit is in the nature of a partition suit, the cause of action is continuing and an opportunity ought to have been given to the appellants to implead such omitted parties. Next para. We find sufficient prima facie case having been made out on the questions as indicated above and the other grounds taken in the memorandum of appeal for hearing the appeal on merits. Moreover, from the averments in the application for injunction, we find that we find that the balance of convenience and inconvenience is also in favor of grant of injunction, moreover, the appellants may suffer irreparable injury and the appeal may be rendered infructuous in the event injunction as sought for is refused. Why do you say appropriate order? Why do not write injunction application?
I should have been
next para. Accordingly, can 1 of 2025 is allowed, thereby restraining the respondents and or their men and agents from what have you paid?
Since the suit was dismissed,
setting aside the decree and all these things in a anyway, injunction is also there. From transferring, alienating, encumbering, or creating any third-party interest in the respect of the suit property during pendency of the appeal, the parties shall also remain restrained by an order of status quo from disturbing each other's possession, physical possession, in respect of the suit property, also till the disposal of the appeal. The appellants shall put in postal costs and requisites. This is the worst part. Postal costs and requisites, because there are 31.
Yes.
Postal costs and requisites for service of notice of the appeal on the respondents within January 9, 2026. The trial court record shall be brought by special messenger at the cost of the appellants, also to be deposited within January 9, 2026. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Liberty to the parties to mention the appeal for enlistment as and when the same is ready for hearing. Thank you. So very grateful. Next.
Item number 26.
Yes.
For the respondent.
Milord, there is a mistake on my part, Milord.
Use the mic, Mr.
There is a mistake on my part, Milord.
What mistake?
There was a direction, Milord, to exchange of pleadings. Milord, my affidavit and reply has been affirmed and served on my learned friend, but there is no second judge's copy is available with me, Milord, today.
What can be done? You are enjoying an interim order?
No, this is section 5.
Section 5. Opposition you filed today?
Yes, Your Lordship.
You have a second judge's copy?
Yes, Your Lordship.
So you should dismiss the application. They are on a better footing.
Only one copy. Milord.
Why don't you have a second judge's copy?
Mistake on my clerk's part, Milord. I should apologize.
When did you discover? You could have taken out throughout during the day.
Just now, Milord.
Learned counsel for the appellant seeks an adjournment on the ground that inadvertently no second judge's copy of the reply has been prepared. Full stop. The affidavits in opposition filed to be kept on record. Full stop. The time for filing reply is extended till January 6, 2026, when the applications shall next be listed for hearing.
Extremely sorry, Milord.
No. Why sorry? You are suffering. Yes.
Item number 27.
Appearances, please give the appearance. 27, who is appearing? Yes, sir.
My lord, the appellant respondent before my learned senior.
Appellant.
Yes, my lord. The application is taken up by the respondent in the appeal. I am the respondent in this application, my lord. I am seeking, my lord.
First appeal, you are an opposite party in the appeal. Yes.
Now, this is my vacating application of the order passed by this court, my lord.
We'll take it up along with the injunction.
It can be, my lord. The only difficulty is the suit for specific performance. Suit for specific performance. I am the owner of the property. I'm a 72-year-old gentleman, my lord. They are the 82. They are supposed to purchase my property. They are the developers. One big developer of Calcutta. A huge chunk of property. MOU entered in 2017. 7.5 crores.
Who are the plaintiffs? You are the plaintiff.
They are the.
I am the plaintiff.
Developer.
Specific performance. A MOU entered into 7.5 crores total. 50 lakhs was paid to me in 2017. Thereafter, they were supposed to some other litigation. We gave NOC, gave power attorney. I'm saying, please execute the conveyance. Now they come, and I returned the money. Once they're not executing the conveyance. The moment I returned the money, the 50 lakhs which I got, I returned it. NEFT, gave a check, they send it back. Did not encash the check. And even the money.
NEFT and check together, half.
First is check, they did not receive, then NEFT, I saw the bank account closed, but I'm ready to return that 50 lakhs which I received. The moment I attempted to refund that money, they moved the Alipur court and got an order for injunction. They did not get an order of injunction. An appeal was preferred. Lordship has passed an order on me, status quo not to create third-party interest till disposal of the injunction. That order they are enjoying.
The ad interim was refused in the trial court.
Yes.
It has disposed of the appeal and directly.
Now what happened was, I am ready to execute the conveyance. There are 3 orders subsequently where settlement
They don't have the money.
They don't have the money. I have written letter to them. Please call a meeting. Wherever need, I will sign. Give me 7 crores. I'll give my property.
Mr. Mukhoda, put in the money. We'll decide the lock, stock, barrel, shoot everything. Put in the money. We'll give you some time. We'll take it up on 19th January. Pay it by then.
Come ready with the pass any order. Today I have a leader in the matter. We'll see. 3rd July an order was passed. Will keep it on the reopening day. Let my leader
put a lien of your fees on that demand draft. That will be adjusted from
not do that. Firstly, not the entire facts have been shown to Mr.
Anand Chatterjee is your leader.
Yes. No, yes.
He'll not be there even after 1 week after the vacation. We'll keep it after the vacation.
We'll keep it on.
You do the matter, Mr. Mukhoda. Are you ready with the money or not? If you're not,
no, of course.
We're vacating.
Without that money, of course, I won't get the degree.
Nothing is of course.
No.
Page 7. So bring the demand draft or
whatever signatures they require from me, we'll do it
They're agreeable.
across
We'll
the
record
table.
that.
We are agreeable, my lord. Today we have
You
been
cannot
trying.
put a charge on the
No,
property by you of this.
my lord, we are not trying to do that, my lord. My lord, my
Are
plaint
you,
is
are
very
you not
clear.
ready with the money?
My lord, we are ready. They are the ones who have to now put in. My lord,
We'll
we have to
ensure that
agree
they take
upon.
the money. You bring a demand draft, we'll fix a date.
My lord, will then not pass any order today. My lord,
No, no,
we'll
we'll
keep it on
pass an order
reopponent.
today so
My
that
lord,
you can bring the demand draft.
my
It
lord,
will
will
be easier for you.
kindly, I'm not with that instruction, my lord.
Then we'll vacate the injunction.
The order
My
of
lord,
court.
we are definitely, my lord, we are.
No, if you can't undertake that, if your client is not in a position to say that,
I agree.
we'll definitely vacate the order and keep the injunction application pending.
My only
But we'll vacate
contention
the
is,
interim order.
my only contention is, my
Your
lord,
intention,
my
your
intention,
contention, whatever may be, your intention is very clear.
my intention is not to, my lord, defeat the agreement. My lord, here, my lord, will kindly note what has happened. Why we
We'll
had to
just
file
vacate
this.
the order
My lord,
and
will
keep
kindly
the
note.
injunction pending. We'll finally hear the
My
injunction.
lord, we'll keep it on.
Let us see the color of the money. Let
Of
them
course,
see the
of
color
course.
of the money, and then we'll
Of
pass
course,
orders.
my lord, will hear me for 1 minute, and thereafter, my lord, will pass whatever order.
1 minute.
My lord, yes. 2 minutes perhaps. My lord, specific performance suit filed by my client on the ground. My lord, why have we come to court? We have come to court because we have forwarded to my learned friend the copies of the deeds that are to be executed. We've sought their approval. We've asked them to approve it immediately.
We are agreeing to the decree, to your suit itself. We are only asking you where is the money. They're agreeing to, they're consenting to a decree being passed in your suit itself.
Absolutely. My lord.
And you're enjoying an injunction, you're putting them on hold,
We
and
are-
you're not ready with the money when the court asks
My lord,
you.
absolutely, we have to be, or else, my lord, my suit will not survive. My lord, let me take instruction right now. Pass it over for 5 minutes. Let me take that
Yes.
instruction. 5 minutes. Let me please.
5 minutes pass over. Affidavit of service you have filed today.
Yes, yes.
Keep it with you. We will take it up when you pass the order.
Fine. Phone call.
আরে দীপঙ্কর একটু হেল্প করো, ভারীগুলো ওকে দিন হচ্ছে তো। সাইড করে রাখো, পাস ওভার থাকলে কোনো আবার এলে হবে, উনি আবার এলে হবে। Yes,
I pay for the appellant, Your Lordship.
right.
Suit for declaration and issuance of duplicate
First time.
Yes, my lord. It's not. There is a delay, my lord. There is a delay.
No, this is appearing for the first time.
Yes, my lord.
Serve copies and
Yes, my lord. There are two applications, my lord.
both the applications.
My lord.
And this is misappeal or first appeal?
First appeal.
Then
my
the
lord.
applications only for the
Yes,
time.
my lord.
The learned, the appellant shall serve copies of the applications bearing can 1 of 2025 and can 2 of 2025 on the respondents, indicating that the application shall be listed next on January 12, 2026, when an affidavit of service to that effect shall be filed by the appellant.
My lord, 12 January is holiday.
Oh, 13th, January
My
13th.
lord, may I also seek a laboratory to file a supplementary affidavit to CAN to my lord, because
Very well. On the prayer of learned counsel for the appellant, the appellant is granted leave to file a supplementary affidavit in connection with CAN 2 of 2025 on the returnable date, full stop. However, an advance copy of the same shall be served along with the applications on the respondents.
deeply blessed. Deep.
Number 29.
Yes.
Only last question you should directed me to file manner affidavit manner regarding respondent number 5.
Mr. Kamalesh Jha is appearing for the Jhas.
Yes, Bharat.
You are also for the Jhas.
No,
both
yes,
parties are
yes,
Jhas.
both parties. Yeah. One party manner, that is respondent number.
Where is Mr. Jha? Mr. Kamalesh Jha?
Now he's in holiday mood. I think so.
Mood or actually holidaying?
Holiday. Yoshik only prior that manner. Today is the date for manner.
They were to take instruction.
Yes, manner.
Oh, the appeal and the application.
Today is the date, last date for manner. Interim order manner. That
will extend. From the order dated November 18, 2025, we find that an ad interim order was granted by us, whose simultaneously, it was recorded that learned counsel for the respondent numbers 1 to 3 were to take instructions whether the appeal can be disposed of along with the application to cut short the matter. For next para, learned counsel for the said respondents had sought time for taking such instructions. However, at the time of call, none appears for the respondents. Full stop. Accordingly, let the matter stand adjourned and be listed next in the monthly list of January 2026. Full stop. The interim order granted earlier is extended till disposal of the application.
Deeply aware.
What was the interim order? Injunction?
No, my lord, yes, my lord. This was the some money, my lord, regarding my lord.
We restrained. What was the nature of injunction? একবার দেখেন।
Injunction restrain the money, government money to my lord, another. I think so.
কি restrain? স্টে হবে ইনজাংশন না স্টে হবে ওটা
Stay, my lord.
এটা ইনজাংশন বলেছি ওটা স্টে হবে তন্ময়
Deeply aware.
May please your lordship, I am appearing for the appellant petitioner.
Yes, Mr.
There
Adhikari,
is
what-
can number one, my lord, can number one is my prayer for allowing to
What about
repair
this- what
the
about
dilapidated condition houses.
Service.
Service, my lord, I have served upon the opposite party, my lord.
They represent by advocates.
Yes. My lord, this is can
But
number
this is
one,
supplementary affidavit. What about the main service, main application?
a supplementary affidavit. My lord, in can number one,
Why
my
is
lord,
filing piecemeal. File all.
I have prayed for
Yes.
allowing me to repair the dilapidated residential mud houses, my lord.
Why this
In the
supplementary
suit
affidavit,
plot.
Mr. Adhikari? You provided
My
further
lord,
details.
On the last occasion, your lordship
Condition,
were
condition.
pleased
Yes.
to file the supplementary affidavit regarding the status of the dilapidated condition of the houses of the plaintiff appellant. My lord, kindly see that affidavit, and my lord, kindly see the annexer A of the my lord supplementary affidavit. My lord, there is a commissioner report with regard to the my lord commissions of the two houses under order 39 rule 7. My lord, from the commissioner report it appears, my lord, there are two houses. One is, my lord, mud wall construction, one story building, a house with tile shed, and another is two-storied mud construction wall, top roof, my lord, tin shed, and my lord, all sides verandas are tile sheds. All are, my lord, in broken condition.
What is the
My lord,
exact repair you want? Let us see. You
kindly
have to allow
see
in
my-
terms of your
page
prayer.
9, my lord. Page 9, my lord.
Page 9.
This will page 9 supplementary affidavit.
Supplementary affidavit, page 9 is.
My lord, that is the my lord,
These are photographs.
photograph.
No, no. Where is your prayer? What repair do you want?
My lord, where my lord, can application one.
Have you given a schedule of the repair?
Yes.
Repair residential mud houses, general repair won't do. We granted you liberty because we wanted you to be specific as to what repair you want to. You had to give enumerate, these are the repairs I want. Where are those?
My lord, page 7, my lord, that is my lord,
Page 7.
commissioner report.
Acha.
Commissioner report. I have
Exactly what do you want to repair?
My lord-
Commissioner's report photographs you have seen.
Yes, my lord.
We permit you to repair the premises
Upon
and in
the-
the garb of that you make a new construction. No.
Upon the no, my lord, upon the shoot plot, my lord, kindly see, my lord.
What are the points of repair? You have to give in like in a trial court, you have to give the points of repair. 1, 2, 3, these are the repairs. I'll change this tile shade or whatever. Nothing, we don't
That
find
is my
anything.
lord, page 4. But elaborately, I have stated.
Page 4 of what?
Page 4, my lord, supplementary affidavit.
Page 4, page 3, 4, 5.
Page 4, paragraph 5. দাঁড়া না বস দেখতে দে once repair was allowed by the learned trial court and with consent of the my lord defendant.
In terms of paragraphs. The supplementary affidavit filed in court today as per previous direction be kept on record. Full stop. From the receipt and the affidavits of service filed today, we find that copies thereof have already been served on the learned advocate for the respondent. Full stop. However, since the respondents remain unrepresented comma, keeping in view the urgency of the repair sought in the application, comma, we take up the application for hearing. Full stop. In paragraph number 5 of the supplementary affidavit, comma, it has been categorically stated that the suit property comprises of 2 residential houses, comma, one being a 2-story dwelling house in the southern side of the suit plot, constructed by mud wall, comma, the the roof of the said mud house being covered by very old and damaged tin sheds, and side verandas of the said house being covered by tile shed with bamboo, with the support of bamboo and wooden structures. Pushed up, it has been averred that the tiles are in a broken condition and the tin is also damaged, and at the time of rain, comma, uh, rainwater enters into the house through such chinks in the roof. Full stop. Next para. It has also been a case has also been substantially made out in the supplementary affidavit that there is another one-storied construction made with mud wall situated on the northern side of the suit property, comma, attached with a cow shed, comma, some portion of which house is covered by tin shed. Full stop. Next para. The tile sheds, comma, it is alleged, comma, are broken and in seriously damaged condition. Full stop. Some portions of the mud wall, comma, it has been alleged, comma, are also in a broken and damaged condition, which might endanger the lives and limbs of the plaintiffs stroke appellants and their family members. Full stop. Next para, we find from a perusal of the said averments, comma, which remain uncontroverted, as well as the photographs annexed to the supplementary affidavit, that a sufficient cause for repair has been made out. Accordingly, can 1 of 2025 is allowed, comma, thereby permitting the appellants to carry out repair work in terms of the averments made in paragraph number 5 of the supplementary affidavit filed in connection with can 1 of 2025, comma, in the context of the photographs annexed to such supplementary affidavit. Such repair work shall be completed within
within 1 month, with the police help. Kindly grant me, police help.
No, police help not unless there is an allegation.
My lord, I am humbly submitting. Kindly see the once the trial
shall be
court
completed within
allowed my prayer,
within January 31, 2026. Next para. In the event any resistance is put up by the respondents in such repair work, comma, leave is granted to the appellants to file an appropriate application for implementation of the order of this court.
Grateful to my lord.
Not at the first instance.
Because once trial court allowed.
No, it's like granting injunction and granting police help along with injunction. There has to be an allegation. They have to have an opportunity to controvert that they are actually
plaintiffs are on
application.
Prevented by the defendants, from repairing their houses.
If there exists, we have given you liberty.
Great.
That liberty is in any event there. Password. It's sure.
Specific instruction I've taken. 1 crore demand draft will carry by 7 January. Malad was giving me time till 19. By 7 will carry the 1 crore demand draft in court. Thereafter, whatever time Malad fixes, we'll
whatever is the balance. What is the balance?
7.
Balance? No, 6 was the agreed consideration under
7.5. Whatever in the MOU, what is there?
MOU is 6, Malad. 6. No. It's not 7.
Provide the
MOU is 6. 1.5
it has increased because you took the 5 minutes adjournment.
No.
Interest on the 5 minutes.
No, I think there was some.
MOU, I can show the clause of
check up. Convince yourselves. Convince each other, then we'll take up.
6 crores was for the part for which we have shared the deeds of conveyance. Another 1.5 was also to be given. That's yes, 7.5, but 6 crores is the one which has to be paid immediately. That, my lord, we are ready. We will make payment. 7.5, 6 crores is the one, my lord, which is time stipulated in the agreement. 1.5 additional has to be paid. There's separate plots of land. 2 plots of
not like this 1 crore and 6 crore.
My lord, my prayer is
the entire demand draft has to be brought in court. Will direct exchange and dispose of the appeal, the suit, lock, stock, barrel will record in today's order. that will do that.
My lord,
Otherwise,
my only
both of you won't be, I mean,
my humble prayer is, my lord, today, my lord, my leader is also not there. 1 crore I've taken categorical instruction. 7th, my lord, keeps it and thereafter passes this order. 1 crore, let me show my bona fides on 7th and thereafter, my lord, passes the order. 7th, I'm only praying, my lord. Today, I'm without, my lord. My leader also, my lord, full instructions
your
are
leader
not
won't
given.
pay.
No,
He
no,
may
no,
pay,
of course.
but he won't.
No, of course.
That's the
Not
capacity,
my
but he won't.
I'm
Since he's
only
not there,
praying.
we are not elaborating on it.
I'm
But-
only praying, keeps it on 7th. Let me show my bona fides. Thereafter, my lord, passes the order.
You have to
Kindly
total
does not
7.5. Huh?
order, my lord, pass this order today. Kindly keeps it on 7th. We'll bring the demand draft.
At the time of hearing of the application for vacating the ad interim injunction order passed by this court, learned senior counsel appearing for the respondent stroke vacating applicants submits on instruction that the respondents are agreeable to execute deeds in terms of the agreement, of which specific performance was sought in the trial court but refused, subject to the appellants paying the entire agreed sum of rupees 7.5 crore.
7.5.
Next para.
50 has been paid to us.
So 7 crores.
Out of
is
Full stop, it is further submitted that out of the said amount, 50 lakhs have already been paid to the appellant. Full stop. Accordingly, the balance amount of 7 crore is required to be paid by the appellants.
Yes.
So next para, learned counsel for the appellants, while seeking an adjournment on the ground of absence of his learned senior, takes instruction and submits that, in order to show the bona fides of the respondents, of the appellants, the appellants would come ready with a demand draft, stroke, bank draft, stroke, banker's check, stroke, account pay check, whatever mode.
Like instrument.
No, we are giving everything. Stroke, account pay check to the tune of rupees. Yes, account pay check, because before the next returnable date we'll know.
In cash.
To the tune of rupees 1. Acha, account pay check ta dewa dorkar. Bakigulo. To the tune of rupees 1 crore on January 7, 2025. Full stop. Next para. Hence, since the appeal arises out of a suit for specific performance of contract, in which the readiness and willingness of the plaintiffs is of paramount importance, and also keeping in view the bona fide stand taken by the defendants stroke respondents to the effect that if the agreed amount is paid, the respondents would execute the deeds in favor of the appellants, we are of the opinion that the bona fides of the respondents in that appellants in that regard should be tested first. Full stop. Accordingly, let the matter be let the applications be listed under the heading to be mentioned on January 7, 2026 for passing further orders. Full stop. The appellants shall present on the said date a bank draft stroke of rupees 1 crore on the next date, subject to orders being passed by the court.
In favor of respondent in favor. Saranjit Singh Madan.
In favor of which respondent number 1?
Respondent number 1. Saranjit Singh Madan. Who is the?
In favor of respondent number 1, which, it is submitted by the respondents, shall be constituted to be payment to all the respondents.
This is the wife, Chile, my
Lord,
son.
I'll just indicate one thing. I'm not saying anything other than that. We also have a claim in damages because of the delay and obstruction that's been caused by the defendants in the suit.
Separate suit.
No, in this suit, my lord, I have a claim in damages. I have a claim of about 6 crores and odd against the defendants. So I don't mind, my lord, the amount being deposited in court if it commences to, my lord, because that also has to be adjudicated in the suit.
Achha, even if your that amount is set off, then also 1.5 remains. You have a claim of 6 crore.
6 points. I'll indicate exactly the figure. I understand what is called.
Then my property goes for free.
No.
That's the case. My property goes
bring
for
the
free.
demand draft in the name of my learned senior friends. That also
No, but
can be done. I'm just putting this
out. Even if they take that, and if they take the point of this set off, then what would
Then, my lord, if
the use of paying the demand draft has to be in your
now
claim, then it has to
if they press for damages, then obviously then I have to contest this application whether that damages, because they have sought for an injunction before this court only for specific performance.
No, that is
Now
not
they
meant
are
for
pushing it to
injunction.
damages,
No,
a
damages
different
are
any
not
altogether.
suit, Lord. I can't do away with what is part
You
of
ask for
my
specific performance,
What
you
will
ask
they
for
do with that
damages.
one quote?
Well, Lord, there is a delay. 2017 was the MOU. May I just indicate what the
Sir,
suit is
no,
about?
Mr. No, we can do this.
My lord.
You can bring that demand draft.
My lord.
That demand draft will lapse after a time. So we can ask you to pay to him, and you will put that in a particular account, and would
My
not
lord can do that.
deal with that.
Well,
Subject to final orders.
Yes.
Would not deal with that. You will put that in some account.
Yes, yes. Yes.
Will not deal with that. Will keep pass that order. And then hear out the applications that
can-
50 lakhs also in a separate.
That
In this,
in that, yes.
this 50 lakhs was paid to us is also in a separate account, because we have to read
Fair
it.
enough.
Also in a
particulars
We
of
can
that
put that in our
Okay.
direction, that will be kept. And if they bring that, then we'll put the applications for hearing.
Yes.
on
Now,
this
my lord,
date and
if I'm ready to execute the conveyance, they must give up their damages claim of 6 crores.
will
That
be
has to be an amicable solution to the entire problem.
because they wanted a
Because
settlement.
they wanted a settlement. They
I
said before the other division, they
No,
recorded in the order.
This is incorrect. My lord, may I just
It's
indicate,
recorded
we
in
were
order.
there on that occasion. It was the respondents who came forward and said, we want to settle the matter. We were agreeable to that. We had not approached. It is the, my lord, 1 second, my lord. Since we're discussing the merits of the appeal, there's a termination notice issued by the respondents. That is why we had to come to court. 2017 onwards, they enjoy a sum of rupees 50 lakhs. Whatever it might be, that's a substantial sum. From 2017 till 2025, they enjoy. Once we ask them to execute,
Mukhopadhyay, where is the question of damages if they
because of
execute
the delay, my lord, we have my plaint cases. I forwarded them, my lord, the draft deeds. I asked them to execute. They did not do so. And this is a property, my lord. This is 2 premises of Pagladanga Road is the property, my lord. There, my lord, we are owners of a substantial portion. We are seeking to develop it. The respondents, my lord, are
Let
owners.
us come back on.
Whatever, we come back.
Oblige.
Sir.
My lord, this is that Wari Club's matter,
Yes.
my lord.
My lord,
Disposed of
item
case,
number-
we have put an application, my lord. The only problem, my lord, the petitioner number 1, my lord, has passed away recently, my lord. We get to know. Formally, there is
Petitioner number 1 means the respondent number 1.
the plaintiff number 1, who is the petitioner in the CAN application.
Can is for?
CAN is for certain relief, where only
No, the petitioners are the respondents.
petitioners are the plaintiffs in the lower court, my lord.
In this court, what are they?
The petitioners, my lord. Respondents, respondents, my lord, and they have prepared an application, my lord.
Respondents. They are respondents.
My lord, I am not there in this matter.
They are respondents.
My lord. In the appeal.
In the appeal, they are respondents.
My lord.
So if they are respondents in the appeal, if they have died, then he has died, then what can be done? You have to take out.
My lord, Mr. Mukherjee, Mr. Deepak Ranjan Mukherjee is in the matter. He's unwell. He couldn't come to court. Kindly fix it after the vacation.
We are just directly to serve the particulars of the heirs and legal representatives and the date of death to the learned advocate.
My lord.
On record, my lord. Advocate.
Yes, not the record, my lord.
But your name will be recorded today.
Yes, my lord.
Somebody.
Yes.
And in the application, there was a we have sought for a direction upon them, my lord, upon the also upon the chairman, my lord, learned chairman, to allow the plaintiffs to obtain inspection of the copies submitted.
No order can be passed in the name of a dead person. First, you have to substitute. They have to substitute. So you furnish the particulars.
My lord.
Learned counsel for the respondents. You are for respondent number 8.
I am for the respondent, man. All of them, my lord. We were the plaintiffs, my lord.
Learned counsel for the respondents submits that respondent number 1 has met his demise in the meantime. Push up. Accordingly, the learned advocate for the respondent shall serve in writing the particulars, shall inform in writing the particulars of the heirs and legal representatives of the deceased respondent, as well as the date of death of the said respondent, to the learned advocate on record for the appellant by January 9, 2026. First up, next para, the date of service of such notice. Now, leave is date of service. Leave is granted to the appellant to take out appropriate application for substitution of the heirs and legal representatives of the deceased respondent, with the liberty to mention such application as and when such application is taken out. First up, the matter be delisted for the time being with such liberty. Matter goes out of the list for the present. When they file the substitution application, they'll mention everything will be taken in.
Grateful.
Good. Give your name. Yes.
Yes, my lord. I've given.
Somebody has to be held liable.
Yes.
Next.
Lord, I am appearing for the appellant.
My lords, I'm appearing for respondent number one.
Yes, Mr. Mitra, what is the case?
My lord, this is an application for
Analogous.
injunction. And the
Like analogous
analogous
hearing, one eviction suit, the other
other for declaration.
your eviction suit.
My case is for declaration.
That you are a tenant.
That I am a tenant.
That was
The
dismissed.
learned court held that I am a tenant.
Held that you are a tenant.
Yes.
No, my lord. No, my
Lord,
lord.
so far as the question is that yes.
Yes, my lord.
My lord, they have postulated that the court has allowed my lord their application so far as because of
Their
the
eviction
fact
suit has been
that
declared.
I was not dependent. The widow is not dependent because he has deposed before the
Widow,
court.
even the widow is for 5 years, Mr. Mitra.
No, so far as widow is concerned, for his hard tenancy will
Lifetime.
might not devolve during her lifetime.
But the
And
other
so-
dependents 5 years.
Other
Yes,
dependent
I've forgotten.
5 years.
5 years. Yes.
My lord, so far as in that case, the widowed person has to be maintained. I mean, she has to be dependent on the
Yes, that was held to be not dependent.
Yes, my lord.
That had her own income. That is
yes,
the finding.
yes, my
Because
lord. He was
at the
penniless. That
time
is
of
the
the death, she was penniless. His son deposed it. Therefore, he has no income. That has been held by the court below, my lord.
No, you don't understand. Please repeat.
My lord, the widow was not dependent upon the deceased tenant.
Yes.
Because in her deposition, the son has stated that at the time of death of the original tenant, he was penniless and he has incurred expenses for that. Therefore, my lord,
Don't understand.
original
Original tenant was penniless when he died.
therefore the widow is not
Oh, not
dependent
dependent of
of the husband. Therefore, my lord, the
But the
court held
question is whether the dependent, the expression dependent is dependent in law under Succession Act. Whether that will be taken or actual dependence.
my lord, on that ground the suit has been
You
decreed.
can decide the appeal right now. I'm prepared with the appeal. What is the application for?
The application for stay, application for injunction restraining them from putting the decree into execution.
So they have to put in the occupation charges.
My lord,
Yes,
so
my
far
lord.
as that is concerned, they have stated
Affidavits have been
Yes, my lord. affidavit.
affidavits have been filed. My lord, so far as the occupation charges is concerned, my lord, this was 60 rupees rent according to both of them, my lord. It
The
was
husband was penniless and she could not pay anything. Why do you ask for so much occupation charges? What will she do?
my lord,
Poor lady.
they have, my lord,
My lord, the son is taking care of her. That's what he said in his own cross-examination, my lord. That's come up in the papers, in the field
my lord,
papers.
so far as the, my lord, kindly look into, they have relied upon a report
this?
of the, kindly look into
We thought there are bundles there.
bundles of the rooms.
No, no,
My lord,
bundles in the packet. Not in the rooms.
no,
You're
photograph.
Your photographs.
These are
Keep
not.
those with you. You are not interested.
My lord, kindly look into that. This
No,
is
Mr. Mitra, in occupation charge, in respect of occupation charges, we have to start with them. What is their case made out? What is their material? And then you have to reply.
Then
Because they have to show what is the contemporaneous occupation charge. And then you have to revert that.
But so far as the contemporaneous,
Let
they
the
have, my lord,
report on determination of fair rent.
the report on
valuer.
determination by a valuer. My lord, the valuer has not, my
You
lord,
have not reverted that.
my lord, I have reverted. So far as that is concerned, my lord, we have stated that the valuer has valued the property on the basis of the material, the building. So far as the rooms is concerned under occupation, that has not been taken into account.
Let us see the report. Do you argue on that, Mr. Mitra? Report is annexed to their opposition.
Report is annexed to
Show us the report from where you are saying this.
The report is that
Because page 9, 4.0 of the affidavit in opposition, methodology of verification has been stated to be physical verification of assets carried out at the site in presence of authorized representatives of the owner. So therefore, they carried out physical verification at the site, they are saying.
At the site verification, so far as the rooms are concerned, my lord, that was not verified. So far as the area is a slum area within the property, that has also not been taken into account.
This is near my school also.
Right.
My lord, near
So I know the
Calcutta.
vicinity, but there are actually slum areas there also.
My lord, that is also there.
Which
my lord.
area is this?
My lord, this is opposite. So far as I'm aware, it's opposite in Tally Market, the Doctor Lane that we call it.
Yes, Dr.
It's that vicinity, my lord.
Opposite in Telemarket means
I
not
mean,
on the main road.
Not on the no, my lord.
Side.
There's a by lane.
The one which goes to that Suresh Sarkar road.
Yes, my lord, that enters into the Alimuddin Street and etc. other places. Also.
Now, Alimuddin Street is somewhere else.
So it's far from there.
So far he has
What
made
is the extent of the property? Extent of the property?
It's a 3.5 kattha property.
total
my lord.
property, out of which I am in occupation in a ground floor 100
No, let us see this.
square feet.
But to you, the entire property is unusable.
According to him, my lord,
unless you are ousted from the property, Mr. Mitro, the rest of the property also cannot be put to any other use.
The rest of the property, there are other tenants also.
Achha. So what is your occupation according to you?
Only one room.
155, my lord. 155 square.
According to them,
155 square feet.
Yes.
No, according to me, my lord, he has given, my lord, that the baranda, the covered baranda, which is being used as a meter room, that is our occupation. We have denied that these are not our occupation. This is the entry point of my room.
So monthly rent they are saying 4,100.
4,100.
My lord, as per the valuer's report as well as other reports that we found.
4,100 is reasonable.
My lord, I am think, my lord,
That area it's reasonable. 4,000.
kindly look into the situation of the room, my lord. The one room with common veranda.
It is nothing.
Common veranda, a common bath, not a separate room.
4,100 is not at all exorbitant in that area.
My lord, if the room is such, my lord, kindly consider.
My lord, in fact, other houses and huts over there, they are paying more. I've just sought for what is in my valuer's report that is there.
You have annexed those also, the others?
Yes, my lord. I've taken out from the website.
There are other tenants also, they are occupation.
There are lift, amenities, lift, parking, so many things are there. You cannot equate with the page 15. Such.
Yes, my lord, page 15. This is the general that I've in that vicinity. But in so I'm not pressing on that also, my lord. I'm just praying that as per the valuer report, what is today, I'm praying for that, my lord, the occupation.
All right, in honor of Mr. Mitra, we can reduce 100.
Kindly consider it, my lord. 4,000 is.
Photographs, why didn't you annex to this?
My lord,
you cannot just pull up photographs during arguments. You should have annexed so that they could deal with it.
Yes, my lord.
Yes, my lord.
Let us see the photographs, let us prejudice ourselves. No,
I'm giving.
Choose the worst.
No. What? These are the.
What is this? Look, this is the entrance.
After entrance, my lord, this is the room.
What were you paying previously?
60 rupees.
60.
60 rupees.
Where is the interior of the room? Nobody lives here. Nobody lives here.
Living.
No. There is no living, nothing.
This is, my lord, covered veranda in respect
We don't
of
want
which.
to see the covered one. We want to see the rooms.
The rooms is, my lord, this is the
meter
room.
box. You have given these photographs.
This is the room. This is the room.
This is not the entire room. This is one wall of the room, Mr. Mitra. What are you saying?
My lord, for making repair, he is, for the present, my lord, he is beside.
No. The picture of a wall of a room does not help you. Sorry.
My lord, I shall produce, my lord,
No,
photograph
did
of
not
the.
produce anything. We are disposing of the application right now. We won't keep it pending unnecessarily. 4,100 is reasonable.
My lord, I think, my lord, this is not at all reasonable. My lord,
Heard learned counsel for the parties. The present appeal arises out of an application, out of a suit, out of a decree of eviction passed in favor of the respondent number one, plaintiff stroke respondent number one. Simultaneously, the suit for declaration of tenancy rights filed by the appellant was also dismissed. Next para, in the application for injunction, a restraint order has been sought with regard to execution of the eviction decree. Next para, the affidavits in opposition and reply filed today are kept on record. It transpires from the annexure to the affidavit in opposition that the respondent, plaintiff stroke respondent number one, has obtained an elaborate valuer's report who, as reflected from the report, held a physical verification of the property and, upon consideration of various factors, as mentioned in the report, arrived at the conclusion that a fair rent of the premises at contemporaneous rates would be rupees 4,100 per month. Next para, learned counsel for the appellant controverts such allegations, by submitting that the property, the suit premises is comprised of a dilapidated room in the interior of the locality. Accordingly, it is submitted that the room is not commercially viable as well. Next para, we find from the materials before us that the suit room is situated in the entirely area. Despite the size of the suit room not being moderate, upon a consideration of the considerations taken into account by the valuer, we are of the opinion that the amount of rupees 4,100 per month is a conservative estimate of the market rent applicable in the locality. Next para, thus, this court finds that in order to continue the stay order granted earlier, an occupation charge of rupees 4,100 per month is required to be paid by the appellant. Next para, accordingly, can 1 of 2025 is, you have not levied execution as yet. Accordingly, can 1 of 2025 is allowed on contest, thereby granting, thereby restraining the respondent number one from levying execution in respect of the impugned decree of eviction and or disturbing the possession of the appellant in any manner in respect of the suit property till disposal of the appeal, subject to the appellant paying occupation charges at the rate of rupees 4,100 per month. Next para, the first of such current installments for the month of January 2026 shall be paid by January 15, 2026 and thereafter, by the 15th day of each succeeding current month. Next para, the arrears of occupation charges at the rate of rupees 4,100 per month, from the date of the impugned decree shall be paid. What is the date of the decree? When was the decree passed? 2025.
Passed, my lord.
2025. This year only.
Yes.
This year
shall be paid by 4 equal monthly installments, the first of which shall be paid by January 15, 2026 and thereafter, by the 15th day of each succeeding month till the same is cleared off. Next para, all such payments shall be made to the respondent number one you have to furnish a bank account.
Yes, my lord, I will give in the details.
Can you do that by today?
Yes, my lord, I will do that.
To the respondent number 1, at the bank account to be furnished by learned counsel for the respondent number 1 to the learned advocate for the appellant during the course of the day. For sub next para, it is made clear that in default of any of the above payments, comma, either current or arrears, comma, of occupation charges, the order of stay granted by us shall stand, order of injunction form the order of injunction granted by us shall stand automatically vacated without further reference to the court. Full stop, in view of the appearance of the plaintiff stroke respondent number 1, comma, service of notice of the appeal on the said respondent is dispensed with. Full stop, since no relief has been claimed against the pro forma respondent number 2, comma.
That order already passed, my lord.
You have passed this order. Paper books directions have already been
Yes,
given.
my lord. I would just like to indicate, my lord.
Since
On the last occasion, my lord had directed the respondents to pay in the special messenger cost.
So
We
do
have
whatever-
done that, my lord.
Very. Nothing else is required to it.
But in the report, he has also paid for my lord 4,000.
Item number 34.
Yes.
Lordship, item number 34, praying for not today.
What do you? For whom?
For the petitioner, Lordship. Actually, I'm not briefed in this matter.
Take the order record to not to record. Not we are making it not. No order is. Next one. On a order is.
Item number 35.
Not today. না করি না যারা করতে চায় শুধু তার
Item number 33.
both sides
No, Lord.
same side other side is required.
Lord, I have served the copy of notice.
As per lordship direction. কোটি দিয়েছিলাম।
What is the matter about?
Lord, the matter, Lord, I have this is my first appeal. Lord, there is an application for leave to appeal, section 5, stay petition. The suit for specific performance was filed by the respondent number 1 against the respondent number 2 before your lordship. Lord, in that particular suit
for partition.
Suit for specific performance of contract. In that particular suit, Lord, without service any notice upon the defendant who is the respondent before your lordship, suit was decreed. Lord, initially there was an order of injunction, and Lord, I purchased the property when the order of injunction was subsisting. Then, Lord, the suit was decreed beyond my back. Although I purchased,
you purchased during subsistence of the injunction, so your purchase is illegal. Why should you give that premium by adding you as a granting you leave to prefer an appeal? You claim your rights through that through the defendant.
Lord, that is why, Lord, my specific case is that, Lord, without service of notice upon the Lord respondent number 2, before your lordship.
Respondent number 2 has to make out that case. Sorry, you can't have any right.
Lord, I am
you
in
claim
position-
through respondent. You were in the teeth of injunction. You were your claim lies in damages against the respondent number 2 because they that respondent, he or she, one is she, 2 is also she.
Yes.
Because she has violated the injunction and transferred it in your favor. You may not be at fault, but your remedy lies in damages.
Lord, I am the bona fide purchaser.
You are not a bona fide purchaser.
Lord, I purchased without, Lord, notice of the injunction order, Lord. Lord, my vendor had no knowledge about the order of injunction. Lord, by the
See, if it was not in violation of injunction order, we could have considered you to be a bona fide purchaser for value without notice. But this concept is not applicable to a person who has purchased in the teeth of an injunction order. This is violative of the injunction. If there was no injunction, you are right. In a suit for specific performance, a bona fide purchase for value without notice is a good defense. You might not have been affected by the outcome of the suit. You would have an independent right.
Lord, if I succeed,
injunction application was violated.
Lord, if I succeed before your lordship on this point, that when the substituted service is made, the substituted service is not the good service. Lord, the paper.
You cannot make out the point. Sorry, At that point of time, an injunction was succeeding and your interest was represented by the respondent number 2. He was suffering an injunction. He sold the property to you. We'll make it clear that remedy lies in filing a suit for damages against the respondent number 2. You can go and do that. What is the section 5? How many days delay?
2806, 2806.
2806. কোর্টে কি করে সার্চ করব? কোর্টে সার্চ করব করি না তো আমরা রেজিস্ট্রি অফিসে সার্চ করব। কোর্টে কি করে কোন কোর্টে সার্চ করে? সব কোর্টে সার্চ করে কোনোদিনই সার্চ করে না কোনো সার্চ রিপোর্টে
My lord.
So it's easier for us now. This is an easier question to decide.
Lord, kindly consider one thing, Lord.
Lack of knowledge must be.
Lack of knowledge, Lord. When they were trying to evict me from the possession of the property, then Lord, I got the.
Satisfy us on law that bona fide purchaser for value without notice. And what is the effect? Bring judgments on
Lord, I will Lord.
Purchase, because there are certain judgments that purchase in the teeth of injunction order. Some say illegal, some say irregular. Previous line of judgments was irregular, but probably I am a very bad. I have a very bad memory. I don't recollect any of the citations. But there are judgments. If you key search, you can find out. Previously, the line was irregular, but now probably some judgments are there against you. Judgments against you. You also bring those judgments. The judgments which are against you. We are confident that you will bring those. So where it says it's illegal, this is one aspect of the matter, injunction aspect. And also, please try to bring judgments and argue on law also that what would be the effect for a bona fide purchaser for value without notice in a specific offense suit. Bona fide purchaser for value without suit in a specific offense probably has a good defense. Bring judgments on that also. We'll take it up after the vacation on the ground that he is not here. Despite notice, none appears for the respondents. Full stop. Accordingly, to give an opportunity to the respondent to controvert the applications, the matter is adjourned for the day. Adjourned for the day. It will remain in the list. So please remind us on the next date, Mr. Ghosh.
Yes.
We will forget, but you will remind us.
I shall.
Whatever is against you, you will bring also.
I shall bring the 2 set of the judgment.
Yes. If there are, I mean, if there are no judgments, if our memory fails us, then whatever you find, bring us.
No, Lord, I shall.
Item number 37.
37, Your Lordship, I am appearing for the applicant. This Mr. Kushal Chatterjee is appearing in this matter as the advocate on record is Mr. Devrup Chaudhary. Both are out of station, Your Lordship. I am stuck here. I would request Your Lordship to kindly adjourn it.
Well, on the prayer of the appellant, the matter is adjourned for the day.
Grateful, Your Lordship.
Thank you. What is your name, Mr. Orko Prabhu Roy?
Mr. Orko.
Orko Prabhu Roy. Sab A last O. Yes. Next.
Item number 38. 39.
Not
39.
39, yes.
And this is for the last matter for the.
My lord, I am
Yes.
for the respondent, my lord.
Yes.
And in this matter, my lord, there was a direction, my lord, for filing my affidavit in reply.
Other matters are released. Yes.
My lord, I have served the affidavit. My lord,
You
may
have
I,
also served.
yes, my lord, may I just file the same?
17th of November order ta pori.
My lord, 17th of November, your last order.
Tara, once again.
What?
This is my reply. And this is a video service.
What is the matter about? Tell
My
us.
lord,
And
this
about-
matrimonial suit
My lord-
that is basically asking for alimony.
My lord, may I submit?
Opposition you have filed.
Yes, my lord, may I file the opposition to all the applications?
And my lord, this is my
Yes.
reply.
Reply you have filed before the opposition. You file your opposition.
My lord, may I file my affidavit of assets? I have used a separate affidavit opposing the application for alimony and also a separate opposition for all the other applications. My lord, may I file the same?
Rightly so.
My lord,
So,
in addition to that,
Your affidavit of assets are filed separately. With
yes,
this.
yes.
And you have filed replies to everything.
Yes.
Separate replies.
Reply ke সময় তো file করেছে।
Reply separately,
Only
everything.
for the affidavit
But
of
there was a
assets.
direction to combine,
Yes, my lord, there was a direction to combine, however, we
but they are filed separately.
My lord, may I?
And we have dealt with, my lord, in combined reply.
In 1 minute, we cannot dispose.
Yes.
So
My
we
lord, may
keep
I
this on
speak?
record. Yes.
And my lord, my application, my lord, regarding alimony pending liability, and that was the direction we have submitted our affidavit assessment liabilities. They have also
So
submitted.
Doctor, we have to go through these documents.
Right.
Because we have already disposed of some applications today.
No.
So this will remain in its position. There.
My lord, may I make a prayer, my lord? My lord, in addition to the affidavit of assets, my lord, that I have already filed on behalf of the husband, my lord, I was seeking your leave, my lord, to file a supplementary affidavit to, my lord, we've referred to documents there, but my lord, inadvertently, we've not annexed the same. So, my lord, we've prepared a supplementary affidavit to that, my lord, containing the documents. My lord, I have a copy, my lord, if your lordship grants me leave.
My lord, in our reply, you have stated they have suppressed.
My lord, we have said we are attaching the same, but
Right,
we
your
have,
lordship, my lord.
it's not a part of the affidavit.
I have specifically stated and enclosed the documents. They have submitted the.
You have said they have suppressed, but they say that they have mentioned in
Yes,
their
my lord,
main
we have-
application.
No.
They have referred to those.
No.
Yes, my lord,
They are
we have.
only wanting to file a supplementary affidavit for the documents which have been referred
Yes.
but omitted.
Yes.
No.
Yes, yes.
In the application, they have not referred at all. They have stated that
Right. Show
they are,
my
We'll have to go into this.
they are the
Having said, my lord,
Yeah.
of annex.
The next date and we'll
they are the
consider
Dutch
the question.
citizen, my lord.
Prepare your supplementary affidavit, but we'll
My lord,
consider.
if your lordship grants me leave, I'll file it.
Cannot
on
grant leave because
Well,
if he,
my lord, one more thing. My lord, may I just also point out one thing? My lord, on the last occasion, your lordship had directed us to pay a sum of rupees 1 lakh.
We have received, my lord.
Yes, my lord, that if your lordship can just record it, my lord. We have
Learned Counsel
of it also.
for the parties file their respective affidavits in opposition and affidavits of assets which are kept on record. Full stop. Learned Counsel appearing for the defendant stroke respondent seeks leave to file a supplementary affidavit which is opposed tooth and nail on behalf of the appellants
And they are
on the ground that only after taking the objection as to suppression of documents, comma, the said supplementary affidavit is being sought to be filed incorporating such documents. Because Learned Counsel for the respondents denies such allegation and submits that the documents now sought to be produced before the court by way of supplementary affidavit have already been referred to in the pleadings filed today. Full stop. However, comma, due to paucity of time, comma, the matter cannot be adjudicated today. Full stop. Accordingly, let the matter stand over and retain its position in the list. Full stop. The question as to whether leave shall be granted for filing supplementary affidavit shall be considered on the next occasion when the matter is called on for hearing. Full stop. Next para. Learned Counsel for both parties submit that as per the previous direction of this court, comma, an ad hoc amount of rupees 1 lakh has already been paid by the respondent to the appellants.
And my lord, the monthly my lord, maintenance
has already been paid.
20,000, which was granted by the. My lord,
It is being paid. That has been recorded by your lord.
no, that has been earlier paid. But in the
It is being paid. Earlier paid, but
no, in this month they have not as yet paid.
my lord, we've paid 1 lakh as far as I know.
No, rupees 1 lakh I have received.
Not been paid, my lord. I need to ascertain because last time
Regarding
20,000.
petty amount of regarding petty
If they
amount.
pay 1 lakh, they'll pay 20.
my lord, we have
Petty
been
amount of
paying
maintenance, which was.
continuously. They have admitted that in their affidavit. So if we have missed
Well,
it,
she will not allow to make any submission. That is the problem, my lord. She is not allowing me to make my submission. My monthly maintenance, which was granted by your lordship, that may be paid by her.
Not allowing because she's saying that she has already paid that 20,000.
No, 1 lakh I have received. But these are the
20,000.
20,000 is not paying.
Let her take instruction on that.
My lord, item number
being
15.
paid, my lord, we will pay it if it has not been paid.
Okay, my lord.
Yes. My lord, item number 15, my lord.
Yes, Ms. Bandhavadhyay.
Yes, my lord, it was taken, my lord, today. My lord, my lord, there was a direction by my lord, that the postal cost and requisites, my lord, they are paid on, my lord, as per the order of the Lojima Court, my lord, the order dated 21st April 2025, my lord.
15, item 15.
15, my lord, yes.
15. Meghnath, আপনি নিয়েছেন?
I apology, my lord. I
No,
tell
no,
my
no,
apology,
don't
my
make
lord.
15 কে নিয়েছে দেখো? শুভ্রকে একটু মেঘনাথ বলে দিতে হবে আপনার যে 15 এ যেখানে বলেছি যা বলেছি থাকবে তারা ঘেঁটে যাবে। If not already deposited. Postal cost যেখানে দিতে বলেছি shall deposit if not already deposited.
My lord, it was deposited, my lord.
We'll put in the order to deposit if not already deposited.
Deeply obliged, my lord. Deeply obliged.
My lord, before vacation, my lord, I hope your lordship, my lord, Happy Christmas. Happy Christmas, my lord.
Thank you. Same to all of you.
Both of your lordship, my lord.
একটু গুছিয়ে নেবেন। আপনাকে বলছি, আপনি উত্তর দিন।
My lord, both your lordship, my lord.
My lord, Merry Christmas as well.
Merry Christmas, Lordship.